It's only 2:30.
My lord, it's serial number 112, my lord. It is in B group, my lord.
Serial number?
112.
Use the mic.
Serial number 112, my lords. It is in B group, my lords. The sixth respondent has disconnected the power supply of a residential building of the petitioners, my lords. This matter already adjourned for fifth time, my lords. Kindly may
It's
take
early hearing.
2:30, my lords. The urgency is please, my lords.
Serial number?
112, my lords.
105.
112, 112.
Yes.
Kindly take up at 2:30, my lords.
Yes, 2:30.
My lords, this is a fresh matter. I have some urgency, my lord. The commercial court has passed an order under Order 7 Rule 10. It has transferred the suit under Order 7 Rule 10, my lords, and the files are being moved now. It may be taken up today at 2:30, my lords.
No order pass.
My lords, it was passed 3 days ago on the 3rd.
Nothing will happen. We can hear it tomorrow also.
My lords,
Nothing will happen. If it is wrong, we can stop it.
please, my lords, the process will be started by the registry. That is the
Let
urgency.
it be done. Let it be done. There is not a matter for urgency. You please file it. It will come. Yes.
My lord, this is a order that's been passed by the civil court, my lords, in a defamation case, where the police has been directed to secure all detailed records of my client. These are over a period of 18 months with location, phone numbers of everyone she has contacted over a period of 2 years. And this is due to be listed on Monday, where the police has been summoned to place these records before the trial court.
When was the order passed?
The order was passed on 7th July, but my client is virtually unrepresented because the advocate over there has filed a memo of retirement and not been appearing. She was not informed of this, and therefore we have moved.
Only absences before High Court. Every matter has to be taken up in that manner.
I apologize, my lord, but this is grave urgency.
I think we have to, sir, we have to deprecate this practice of this everyday urgencies. Then only something can be done to the list.
Lord,
Take it at 2:30.
My lords, if I may make one for
I
some.
said,
My lords, it's a patent infringement suit. There's a revocation petition pending in Bombay, my lords. The reason is that
I have rejected. It will come. Yes.
Serial number 105. There is a direction from the Supreme Court to dispose the matter in 6 months, my lord. Although matter is listing every day and we are not able to reach out the matter, my lord.
You know that what is the difficulty of the court? There are matters which are urgent, which are filed fresh. I have to take care. The Supreme Court might have said so, but I'll be able to, I have to take it.
Money recovery suit, my lord. 2 crore is pending due from the
So
respondent.
many matters which are much older than your matters. They
1
also
year
have
it
to
has
be
been
heard.
stay granted by this court, my lord. We are not able to
Yes.
proceed before the trial.
Madam, not requesting tomorrow, my lord, because my lord, the trial court fixed date on Monday, my lord, for further argument, my lord. It may be posted for judgment otherwise, my lord. Lordship may kindly.
When did you file it?
My lord, 3rd, my lord, 3rd August, day before yesterday, my lord.
It will come.
Lord, it is
If
not.
you comply with the office objections,
Complied, my lord. We have-
it will come. It will come, Maria. Don't have to
Requesting,
give a memo for that. It will come on its own course because that is the instruction from the court to list all the matters.
my
So
lord,
for that, no memo is required.
Serial number 91.
68. By mistake, I filed the revision petition, my lord. I may be permitted to convert it into writ petition, my lord.
60,
68, my lord.
take that. The office has raised an objection with regard to maintainability, then consider the petition. Has filed a memo seeking permission to withdraw this petition with the liberty to file a writ petition. Accordingly, memo is taken on record and
My lord,
the,
conversion, my lord. Conversion, my lord.
yes, memo is taken on record and the petition is permitted to, no, instead of saying withdrawal, just the memo is taken on record and the petition is permitted to or convert this CRP into a writ petition within a period of 2 weeks from the date of receipt of the copy of the order. For statistical purposes,
Not one.
CRP is disposed of.
Not one urgency matter is that
96 also, my lord, I'm filing the memo for withdrawal, my lord. Liberty to file 96, my lord.
Huh?
96, serial number. So liberty to file before the trial.
It's a first appeal.
First appeal.
The office has raised an objection with regard to maintainability. Memo is well seeking to withdraw with a liberty to file an appropriate petition. Accordingly, the memo is taken on record and Writ petition is dismissed with a liberty.
Lord,
Lord, one
serial
matter-
num,
One minute, appropriate application shall be filed within a period of 2 weeks from the date of receipt of the copy of the order. Office is directed to return all the documents by keeping the copies of the same. Yes.
Madam, one matter seeking for, Malad, the urgency is that, Malad, second list to 24 serial number. Malad, decree has been challenged in a, Malad, no decree has been challenged. Now execution petition has been filed by, Malad, the respondent. Malad, where, Malad, the arrest warrant has also been issued. Malad, before this court, Malad, it has been stayed and subject to deposit 1 lakh. Malad, now, Malad, respondent, Malad, is already, Malad, is admitted to hospital for kidney. Malad, I have filed an application for seeking release of that amount. But this court, Malad, by the order dated, Malad, as directed, not Malad, the application will be considered on merits only. But so far, Malad, the matter has not been listed, Malad,
Is
since.
that urgent to take it up at 2:30?
Malad, urgent is that, Malad, since the matter is not listing, Malad.
That is not everybody's urgency is
Malad,
that, then every matter I have to
Malad, he
take
is
up at,
already admitted, Malad, he is 70 years. That is why, Malad, I am only making
We
submission.
will let it will come in the first list.
Malad, at least
I will not
first
take
list,
it-
Malad. At least first list, Malad.
No, the list is smarter in the first list.
Please, please.
Lord, serial number 91,
Serial
Milord.
number,
Date may fix,
94.
Malad. Date.
Serial number 91, Milord, for 230, Milord.
Why?
Because, Milord, we filed application, 3 common orders has been passed. So one single petition filed. Officers raised that objection because non-compliance list it is stated. The urgency, Milord, is the trial court, Milord, has.
I will not consider that. I will take that and you have to comply with it.
Allah, that we note in submission mentioned.
Submission.
Objection only that
What are the 3 IAs?
3 AS recall, reopen and to lead secondary evidence, Milord.
So why it should be taken up at?
The reason Milord trial court is proceeding with the other evidence because my primary evidence is
Let
required.
it go. It will reach. when
Okay.
it-
Lord, list one, serial number
serial number
76,
95
my lord.
Huh?
List one, serial number 76. I appear for the respondent. The petitioner had to release certain payments with, in compliance with this honorable court's order, my lord. Matter may be taken up by 2:30, my lord.
My lord, it's a pending matter. OS.
Give it to the court officer.
Your Lordship, serial number 95, Your Lordship. In maintainability objections raised again, I have to, I should file a civil revision petition under section 150.
19?
I have filed the memo for conversion, Your Lordship, in serial number 95.
Where is the memo?
It's in the file, my lord. I have filed it in counter on
Land counsel
30th.
for the petitioner submits that. The office, not land counsel, the office has taken objection with regard to the maintainability. Land counsel, the petitioner submits that he may permitted to convert this writ petition into a CRP. Accordingly, the permission is granted and the same shall be done within a period of 2 weeks from the date of receipt, within 2 weeks from today.
Lord, serial number 98, my lord. Serial number 98.
It's the writ, yes.
Serial number 98, my lord, is listed today for council submission. Lord, 3 IAs were rejected and a single writ petition was filed. I'll comply, my lord. I need to pay some more court fee. That would bring it within the parameters of the required.
No, their objection is 3 IAs.
Yes, my lord.
You have to file 3 different writ petitions.
No, the reason is this, my lord. The 3 IAs for bringing LRs on record and setting aside abatement.
But first of all, officer. the
Yes,
court
a
has
week's
to-
time may be granted. I'll comply, my lord. That's all I'm saying. 90.
Oh.
Sorry, my lord.
It is like this, when there are 3 IAs unconnected with the other, this court is asking the advocate to file
True.
3 writ petitions. So whether it has to be 3 writ petitions or 1 writ petition, have to look at it and pass order. That's what I'm saying.
Please.
Yes, next.
Lord, list 2, serial number 22, appear for the respondent. The petitioners, it's a CRP matter, my lord. The petitioners had obtained a stay of proceedings last year under a false undertaking under which they have not acted yet. It's posted in list number, it may be taken on list number 1 on another date.
No,
Any date may be granted.
there are vacate petitions of 6,000-7,000 in number. Everybody has same urgency. That is not a reason at all. Call the list.
My lordship, one mention, my lords, list 2, serial number 8, my lords, it's a CRP, my lords. The urgency is this, my lords. They have laid challenge to acquisition proceedings before the civil court, my lords. The prayer even in the civil court is to delete them from the acquisition proceedings of the BDA, my lords. What has happened is, my lords, civil court has rejected my application under Order 7, Rule 11, my lords, and we have approached this court, my lords. During the pendency, my lords, matter has not been listed even once yet. During the pendency, what has happened is, my lords, various other parties on the score of that order have approached the same court and have obtained similar orders, my lords. I am the land loser and my rights have been frozen because of this particular OS that is pending, my lords. I pray that it may be taken up at 2:30 today,
You
my
are so
lords.
confident that now order 7, rule 11 will be heard and CRP will be heard.
My lords, not allowed, my lords, but even if it's heard, I can at least
That
make
is
out a
not,
case,
that
my
is not
lords.
an urgency at all.
My lords, no, my lords, my lords.
That's not an urgency at all. Yes, next.
My lords, the civil court cannot go into the aspect of acquisition proceedings, my
yes,
lords, it's
yes.
established by law.
Moving a memo, my lord's pending matter, the one of the writ becomes
If it is pending
infructuous.
matter, give it to the
My
court
lords, it's
officer.
infructuous, it's just for withdrawal, my lords, and
Give
similar.
it to the court officer.
My
I
lords,
can
it may
read
be
and give a date.
my lords,
All the three matters. All three matters.
it may be listed in list 1 on any other date, my lords, that's
Call the list.
My lord, serial number 39, my lord. For kindly, for adjournment, my lord. We have received a copy yesterday itself.
Lord, I am for the petition, my lord, I am opposed, my lord, this urgency. Today is the not final argument.
We have received to file a wakalat and objection, my lord. Yesterday, we have received afternoon copy.
Objections are required in a writ petition. You have to argue basing on the material before the, what is given to you. Is
Your
called the next.
lordship, your lordship, listed to serial number 15, your lordship, it says for rejection of the plaintiff. The trial court is proceeding with the trial matter.
Will proceed. What is
Matter
wrong
may
with
be
that?
listed at 2:30, your lordship.
No, no urgency for that. Call the list.
Serial number 25, my lord. Serial number 25.
Call the
There's
list.
a matter. Serial
My lord, serial number
62,
63 and 64. I request for next week.
Serial number 25 matter is likely to set the family matters. Family members are between the parties. They are likely to set that to other two matters, they are likely to settle. They are, you can kindly refer to mediation. Serial number 25, if you refer to mediation, it will be settled. 25.
I am for respondent number 2 and 3.
20.
2 and 3, serial number 25.
It has to be referred to the mediation.
Yes.
Both the parties that the matter, there is a likelihood of settlement. And they want to go for mediation. The party shall, the matter is referred to the mediation, the High Court Mediation Center, the High Court Mediation Center, and the party shall appear on,
Next week.
Next week is
shall appear before the mediation center on 13th of August.
30.
My lord, serial number
Much
62,
grateful.
63 and 64. I seek for an adjournment, my lord. I informed the other side. 62, 63 and 64. I request for next week, my lord.
You appear for whom?
Petitioner.
You have an interim order.
No, my lord, it's a fresh matter.
List this matter in the month of September at the request of friend counsel the petitioner. Yes.
My lord, date may be fixed, my lord.
On 9th of September.
Serial number 49.
40?
49, CRP. Senior got the minor eye surgery. A matter may be taken after 2 weeks, my lord.
List is in the month of October. Yes, next.
Obliged.
My lord, serial number 78.
Yes.
Office objection complied in office seeks adjournment, my lord.
78. Yes. List this matter in the month of September. Yes.
My lord,
The request. of
one
friend counsel.
submission,
Yes.
serial number
30?
35.
Hmm. Have you informed the other side?
I informed.
Yes, list this in the month of September.
my lord.
At the request of counsel for the respondent.
May I make a submission, my lord? Serial number 7, my lord, at first list. In that, there is a Kannada portion which we are relying, my lord. I'll file a translated. I seek for one adjournment, my lord.
Is this matter on 25th of August?
Please, my lord.
List number 1 for orders, matter serial number 1.
I filed a memo for withdrawal, my lords.
Manna Naganan.
Give that.
It's filed already, my lords.
The memo is filed stating that the petitioner does not want to prosecute the matter and to withdraw the petition. Memo is taken on record and dismissed as withdrawn.
Grateful, my
Number
lords.
2.
Petitioners, the National Highways Authority, my lord. The lists out of which the present writ petition arises has been settled before the Lok Adalat. May I just pass on the,
Not required. The memo is filed stating that. The memo is filed to withdraw the writ petition stating that the dispute between the parties is amicably settled before the Lok Adalat conducted on 11 July 2026, bearing MFA number 3579 of 2026. And as per the directions in the order passed in the MFA, the amount deposited in WP number 4289/2025 has to be dispersed to Special Land Acquisition Officer and thereafter to the respondents. Accordingly, the memo is taken on record and the writ petition is dismissed as withdrawn. The amount in deposit shall be dispersed to the account of,
The Special Land Acquisition Officer.
that is,
My lord,
That
the
is the
details are
petition.
given in the
Who is
petition.
the-
That
I'm
is
asking which
actually I think it's the respondent number 3, my lord.
it is not you think, you have to be
Illa,
sure
respondent
about
number
it.
3,
In
Special
this
Land
case, madam.
Acquisition Officer.
In this matter, petitioner.
Huh?
In this matter.
Illa, illa, sir. Respondent number 3 is the Special Land Acquisition Officer.
Before this court.
Before this court.
To
In
the
this writ
respondent
petition.
number 3 as per the Lok Adalat award.
Cell number 3.
My apologies, my lord. My apologies. In this writ petition, it is petitioner number 2.
That's what he's saying.
Yes, it's
the
right.
petitioner
I was
number
looking
2.
at the cost title of the
Yes.
MFA. My apologies.
Cell number 3. All Guru. That for petitioner.
See, the memo is for signature to withdraw, taken on record and dismissed as withdrawn.
Cell number 4. Prakash RB.
Memo is filed. Need to withdraw the writ petition. As not pressed, accordingly, memo is taken on record and dismissed.
Cell
Not
number
pressed.
5. Jagdish.
Hearing for petition.
Declare for the petition. Move for withdrawal.
It is, memo is filed stating that the dispute has been amicably settled and they have handed over the position of the property. Hence, they want to withdraw the writ petition. A memo taken on record and dismissed as withdrawn. Yes, next.
Hearing on interlocutory application. Cell number 6. MS Raghavendra Prasad.
So filed this application seeking withdrawal of the petition with liberty to file a fresh writ petition.
What is the fresh writ petition?
Lots, initially I had filed this writ petition to seek mandamus for my representations to be considered. It has been considered and rejected. There's a development after I filed this writ petition. Therefore,
I think liberty is not required. You can always question it. The writ petition, land counsel, the petitioner submits that the writ petition is filed. Seeking, a memo is filed seeking to withdraw. Land counsel, the petitioner submits that. They file the writ petition. So, seeking a direction to the respondent to consider representation. Now the representations are considered and rejected, hence nothing survives for consideration in this writ petition. Accordingly, writ petition is dismissed as withdrawn, giving liberty to the petitioner to avail the appropriate remedy, questioning the rejection orders.
Preliminary
Great.
hearing. Cell number 7 urgent. Cell number 8. VM Lokesh.
Petitioner. The petitioner is the contesting respondent. Defendant
What is the
in
suit for?
Suit for partition.
You are the plaintiff or the defendant?
Defendant.
What is the IA?
IA seeking DNA test
Let's see, where is that?
at Annexure C
Page number?
application. 51 mile. Seeking the DNA test in partition suit. I filed application for seeking DNA test. Plaintiff number 2 and 3. Claim to be claim as to the father, daughters of the Padmanabhaya.
Yes, what is wrong with this order? Para 13.
There is no biographical relationship between the Padmanabhaya and there is no relationship between the family.
Court has given a reasoning at paragraph number 13.
Please space.
It is well considered. Please come. Agreed with orders passed tonight, number 21, invoice number 1533 of 2019 by the senior civil judge and JMFs in Ilmangala, dated 28 March 2026. The petitioner defendant is before this court. The respondent herein has filed a suit for partition. in that the defendant, who is a petitioner herein, 1, 2, defendant numbers 1, 3, and 4. 4, 6A, E, 9, and 10 have filed I number 21 and order 26 rule 110A, Deadly section 151 CPC, to direct the plaintiff number 2 and 3 to undergo the DNA test by referring the same to any government agency which is having facility of DNA test. That came to be dismissed by order impugned. The court has observed that the defendants are trying to establish that the Kamakshi and Chaitra are not the children of the deceased Padmanabhaya by procuring DNA tests. The court must carefully examine as to what would be the consequences of ordering a DNA test. If the test comes in the positive, the children of the deceased plaintiff may be declared as having a relationship with the deceased Padmanabhaya and are his children. And in a situation, the test comes negative, there may be a cascading effect as to the individuality and status of the plaintiff. DNA test is not to be directed as a matter of routine, and only in deserving cases such a direction can be given. Further, in the present case, apart from DNA tests, the court can take other documents to the aid of the court. As per the judgment of the High Court of Karnataka, apart from initiating DNA tests, the court can take the other materials to find out that the said Kamakshi and Chaitra are the children of the deceased Padmanabhaya or not. But at this stage, the court cannot initiate DNA test as requested by the defendants. Accordingly, dismiss the petition. Next, when counsel appearing for the petitioner, defendant submits that if the DNA test is done, the facts, as it is the scientific method of determining the facts, it would be easy for the court to decide the disputes between the parties, and the court, without considering the same, has dismissed the petition. Next, having heard the counsel, the petitioner peruse the order impugned. The court at paragraph number 13 of the order, which is already extracted in the preceding paragraphs, has rightly considered and passed an order. This court finds no reasons to interfere. Accordingly, dismissed.
Cell number 9. Yes, Jivan Kumar.
Yes, my only prayer is for a writ of mandamus to direct the civil court to dispose of my IA filed for injunction.
When was it filed?
It was filed on 29/7/2025. IA number 2.
7/25, it is not heard till now.
A notice was issued. After the notice, it has not been considered.
The present writ petition is seeking the following prayer. When counsel for the petitioner submits that he has filed a suit for
Declaration.
Suit for declaration, in that an IA number
2, my lords.
2 is filed seeking injunction on
24/7.
24/7/2025. It is a grievance of the petitioner that the said application is not disposed of even till now, considering the submission of the land counsel, the petitioner, and the fact that right from 24/7/2025, the IA is pending. This court is passing the following order: say the petition dispose of directing so and so, dispose of I number so and so within a period of 1 week from the date of receipt of the copy of the order.
Much.
Cell number 10. 18. B for petitioner.
I requesting for a short pass or mail. I requesting for a short pass. Short pass or mail.
Pass or case 11.
Cell number 11. 11. Kavita D.
This case, I'm challenging the annexure A, my lord, A and B, the work order issued by the respondent number 8 to 11, my lord. My lord, in this case, my lord, I'm the developer of the suit schedule property. After developing the property, some disputed arose between the petitioner and respondent. I have filed OS, my lord.
Work is allotted by whom?
The work order to issue electricity connection to the scheduled premises, my lord. That was challenged and stay was granted in the OS number 190.
Where are this councils? Electricity. What act? Council's names. Mr. B.S. Karthikeyan is directed to take notice on behalf of the respondents and counsel for the petitioner. Respondents 8 to
11.
11. The petitioner is directed to serve the papers for the council. Ministry is directed to print the name of so and so. This is matter tomorrow. In the first list.
12 P. Nehru for petitioner.
Okay, appealing for the petition, my lord. My lord, petition is before this honorable praying this honorable court to set aside the order passed by the learned principal judge to civil judge and CJM Tumkuru
Where is the impugned order?
in page number 28, my lord, 27. My lord, the petitioner
You are the decree holder or the judgment debtor?
judgment data, my lord.
Let's
He
read
was
the
in
order.
original.
Let's read the order. Then you can make your submission. Please come to the reasoning part.
Sir?
Come to the reasoning part. At page number 34, point number 10.
Admittedly, the suit is filed for the relief of specific purposes of contract, and it was decreed by this honorable court on 4/9/2024, and plaintiff was directed to deposit the balance sale consideration within 15 days from the date of judgment. But as could be seen from the material on record, neither the DHR number 1 and 2 nor the DHR number 3 complied the same, even after lapse of long time, and now has come up with the present memo seeking permission to deposit the balance sale consideration amount to the court as directed in the judgment placing reliance on the decision of the Honorable Supreme Court of India in civil appeal number 10683 of 1986 and appeal number 4484 of 2025. On the other hand, the JDR has filed an IA number 3 to resign the alleged agreement of sale dated 4/4/2019, as the degree holder number 1 and 2 have filed memo to drop the proceedings against them, and the degree holder number 3 has not deposited the balance sale consideration amount in terms of the degree and placed reliance on the decision of the Honorable Supreme Court of India in SLP number 8166 of 2022. At the outset, Section 28 of Specific Relief Act 1963 governs the rescission of contracts for immovable property when a degree for specific performance is not followed. If a buyer or lessee fails to pay the purchase money or other sum of order by the court within the given time, the seller or lessor can apply for to have contract rescinded.
The petition is agreed with the order passed on I number 3. The petition is agreed by an order whereby the trial court has rejected the memo filed by the petitioner judgment petitioner for resigning the contract, and the court had allowed the application filed by the decree holder to deposit the remaining amount. Then counsel submits that the court without giving any reason and without considering the fact that the decree holder has failed to comply with the conditions, and merely because he has filed the application as the petition has not chosen to avail the benefit under section 8 of the said act before the memo filed by the JDR number 3 had dismissed the application. Considering the submission, there shall be stay of all further proceedings pursuant to the order dated so and so so and so. Notice to the respondents answer with same. Today for all the matters, give the date as 25th of August. Yes, next.
Till number 13.
My lord, in this matter, my lord, I am appearing for the petitioner. Petitioner here in the plaintiff before the trial court. But he is challenging the order passed by the trial court, my lord, Annexure A. In page number 16, my lord, the impleading application was allowed. But when the matter posted for arguments, my lord, the impleading application was filed by the defendant number 2. Reason, my lord, for a moment, my lord, kindly see in page number 20, my lord, reasoning portion. Plaintiff. Suit for a partition and separate possession. My lord, they have filed an application impleading as my uncle for the DNA test. Reasoning portion, my lord, in page number 20, my lord. Where is the available and merit, my lord? The present impleading applicant is my uncle, my father brother.
petition is before this court agreed by allowing an application under order 1 rule 10, whereby the implead applicant is proposed to be impleaded to conduct a DNA test. Even the applicant has raised the objection, and the plaintiffs have also raised the objection, and both the objections are not considered, considering this application.
Objection.
Notice the respondents and summons. Yes, next.
So number 14, Kantrajappa MG.
I appear for petition. I have challenged the LR application was allowed, my lord. Bringing LR application was annexary, my lord. The respondent number 1 was filed the partition and separate question of the suit. The suit was dismissed, my lord. Then I have challenged, the respondent number 1 was challenged the RA, my lord. Before district court. The RA was pending. Meanwhile, the respondent number 1 father was died, leaving behind the legal heirs, my lord. The respondent number 1 filed bringing LR application under section 22 rule 4, my lord. One, the daughter is LR son. I have objection stated that the mother was also legal heirs of the Krishnamurti, the respondent number 1. The trial court is contended that the wife is the second wife, Nagaratnama is the second wife observation. The application is allowed, Nagaratnama was rejected. Nagaratnama is the necessary for legal heirs, my lord.
Where is
My
it?
mother. Page number 45, my lord.
40?
45. Second. LRs of the Krishnamurti respondent number 1 and also produced the government service book. Petitioner also produced copy of the respondent number 1 reference IA number 1 show that name of the Nagaratnama is the appearing in the service register also Krishnamurti. Considering the aforesaid material, it would be up to observe that the second wife cannot be considered class 1 heirs legal heirs. The trial court is error in the observation, my lord. Without document. The petitioner is produced service register and other government document is produced Krishnamurti, wife of Nagaratnama. Only daughter is also legal
No,
heirs.
where from the court is saying that she is the second wife?
Without document, pass the order, observation.
No, the court says in all his service record, her name is there.
Petitioner is produced the Krishnamurti service record, Nagaratnama is the wife, my lord.
Please
The
come.
trial court is error the order, my lord.
Counts for the petitioner submits that. When an application is filed, when an application is filed to complete the LRs of the deceased.
Krishnamurti respondent number 1, my lord. Before the RA.
Defendant, respondent number 1 in the RA. Only application is filed to implead the daughter. Then the petitioner has brought to the notice of the court that the wife is also a proper and necessary party. And the court has dismissed the same on the ground that she is the second wife. It is the contention of the land counsel of the petitioner that there is no material before the court to come to such a conclusion. In fact, he has filed the material to show that in all the service records of the deceased, her name is found. Considering the submission, okay, stay, notice.
Please.
Number 15, Chandrasekhar BK.
I am appearing for the
Yes.
petitioner. That the respondents 1 to 4 filed a suit in OS 260 of 2007 for the relief of partition and separate possession, in which the third defendant passed away on 4/7/2012 itself. Then thereafter, without taking note of the same, the suit came to be decreed pursuant to the judgment and decree dated. Pursuant to the judgment and decree dated. One second, my lord. I will give the judgment date. (13/7).
Which year?
Then thereafter, Lord,
2013.
FDP was also filed. In FDP 22 of 2016, thereafter, we filed the application in IA number 6, stating that the very decree obtained itself is nullity, because by the time the decree was obtained, the defendant number 3 was dead. Now that application is rejected, solely on the count that relying upon a judgment that impute order is at annexure.
Why can't you question that preliminary decree?
Yes, brother.
Why can't you question that preliminary decree?
Preliminary decree.
Preliminary decree, I did not question. Now, the very decree itself is nullity, for the simple reason that the very decree passed is against a dead person. Is against a dead person. That is why. Though LRs are not brought on record, even though it was known to him. Decree is dated 31/7/2013. He died even much earlier.
Even that aspects can be brought to the court by questioning that order. That preliminary decree as well could be questioned, saying that it is without notice, without completing the the LRs of so and so.
Yeah.
That has to be set aside. The preliminary decree
No,
has to be
even thereafter, my lord, now also they have not. Even thereafter, they have not taken any.
You are doing. What you are doing?
No. No. The very judgment, the very order passed is a nullity, because a judgment relied upon by the learned judge is against the principles laid out by the Supreme Court in another judgment. In another judgment.
I understand if a judgment is a nullity, it can be questioned in the execution proceedings also. I'm asking why you have not filed an appeal against this order. Why you have not questioned an order, judgment and decree, the preliminary decree, which is without notice to you?
My lord, against this order, no appeal can be
I am
filed.
not hearing.
Why? I am passing on the decision of this honorable court. It can be questioned even in the collateral proceedings, even in
That is Kiran,
because the very
1953
decree is
Supreme Court.
nullity. It need not be challenged, so that it cannot be enforced at all. So that I am passing on the decision quoted in ILR 2018 Karnataka 41/41.
No, even before that 1953
The
Supreme
subsequent
Court judgment
judgment
is there. Yes, please come.
Because since the decree itself is in nullity, it cannot be enforced.
Agreed with the orders passed in. Petition is before this court. Agreed with the order passed with the court under 151 CPC, whereby the I number 6 filed with the petition is dismissed. It is a case that a preliminary decree is passed against a dead person. The same is a nullity, and they can question the same in the execution proceeding. It is submitted that Honorable Apex Court, as the law laid down with the Honorable Apex Court in this regard is very clear. Considering the submissions, there shall be stay of all further proceedings in FTP number 22 of 2016 and so and so.
Notice may kindly be dispensed with respect to the respondents 5 to 16.
5 to 16 dispensed with 1 to 4 notice.
Well, further proceedings may be stayed.
Further proceeding.
Yes.
Cell number 16, Mahesh CM.
Appearing for the petitioner.
Yes.
Lord, the petitioner is the defendant before the trial court.
What is the
And the respondent has filed suit for eviction and arrears of the rent. During pendency of this suit, a compromise petition has been filed by the both parties, which is produced at annexure
C at page number 29, where it has been mentioned that on 14/8/2026, the present petitioner has to give the key of the premises. Now, what happened, my lord? The daughter of the petitioner got engaged and the date was fixed for the marriage. Therefore, I have filed an application before the trial court seeking 2 months extension of the time. The reason mentioned
Which
in the
provision?
please, my lord.
Under which provision?
Under application has been filed under section 151 of CPC only seeking extension of the time due to the marriage date was fixed. The trial court says the application has been rejected on the ground that the matter has been settled in the Lok Adalat. Therefore, the court doesn't have a jurisdiction. Now I am requesting my lords to kindly grant 15 days time so that they can shift to another house, and they are in busy their daughter's marriage. My lord, I have produced the invitation card also. I am not seeking any time. I will voluntarily hand over the keys to the plaintiff before the trial court.
You should ask the court something which the court can do.
The trial court says it is settled in the Lok Adalat, so the court doesn't have a jurisdiction
The
to.
compromise or
Please, I do
award
agree.
it's an award is passed.
Please.
No, how can the court will reopen it and pass some other order under 151?
No, only I am seeking extension of the time, my lord. So from
What
10
is
days,
not
at least 10
permissible
days.
is
my
not
lord.
permissible if you are
I
seeking
do
time
not-
or not.
True, my lord. I do agree, my lord. I do agree. But I'm seeking 10-15 days time, my lord. That's the only prayer I'm making.
Pass any such orders.
My lord, I have produced the invitation
I
card.
understand all that, but the court cannot pass that kind of orders. You only request the respondent.
They will not agree, my lord.
And we
There
can't
is no
we cannot
single-
compel them to agree.
I do agree, my lord. I do agree. But it's a discretionary powers, my lords. I have.
No.
It made
Discretionary powers is what is vested with the court, not everything.
no, my lord. I do agree, my lord. At least 7-10 days may be granted, my lord. I'm not seeking months time.
No. That's not permissible, Mr. Counsel. Please, and where there is a scope for discretion, court will do. Not these kind of. It should be discretion should be judicious, not otherwise. The petition is before this court. Agreed with the order dated 15/7/2026 with the principal city and session judge Bangalore. Invoice number 6246 of 2022. The petitioner is the tenant and the respondent has filed a suit in that they have entered into a compromise. As per the compromise, he has to deliver the possession of the property by
14/8.
14/8/2026. Hence, the 14/8/2026. It is the case that the petitioner's daughter's marriage is on
On 30/10/2026, my lord.
30/10/2026. Hence, he wants the time to be extended for giving possession of the property. Hence, he has filed an application under 151 CPC before the court. By order impugned, the court had dismissed the application. The court has observed that after contesting the suit for 4 years, the defendant in the compromise petition agreed to vacate the scheduled premises. The compromise entered is before Lok Adalat. This court has no jurisdiction to review the decision of the Lok Adalat, and both the parties are directed to obey the terms of the compromise. Land counsel appearing for the petitioner submits that he is not asking any independent relief, only that as a daughter's marriage is fixed, there may be a permission to he may be granted some reasonable time to deliver for the position of the house next per and in the same thing he submits that the court has failed to consider the same next per. This is an award passed by the Lok Adalat, and if there is any violation of the same, the only remedy available is seeking execution of the same. The courts cannot intervene with the same and modify or alter or extend the terms and conditions of the said compromise decree. If that is the same, there is no end to this litigation. And in the considered opinion of the court had rightly dismissed the petition. There are no grounds to interfere. Dismiss.
Then number 17, Rupesh B.
My lord, defendant writ petition, my lord. My lord, the defendant in the suit, my lord, filed the application under section 10 of the CPC, my lord. Stay of the further proceeding in the suit. my lord.
Section 10.
Section 10 application, my lord. Earlier, my lord, plaintiff has, the defendant has filed a suit in OS number, my
What
lord,
are those
annexure-
suits? Tell the numbers.
Annexure A, my lord, 81117/2012.
Filed for what?
Filed for the bare injunction against the father of the, my lord, the plaintiff in the present suit. That suit was came to be decreed, my lord. And now against that decree, my lord, they have filed a RFA before this Honorable Court, which is pending adjudication, my lord. Now, my lord, during the pendency, during the passing judgment in the earlier suit, my lord, father has executed, my lord, gift deed in favor of daughter. Now, daughter has filed the present suit. In respect of the, my lord, the property described in the written statement in earlier suit, my lord, the present suit filed in the present suit.
The suit is also for bare injunction.
It is also for bare injunction. Well, kindly see, my lord, while
Yes, please come
the
to
honorable
the-
trial court,
come
my
to
lord.
the order. Come to the order.
Well, page number 108, my lord. Reasoning part. Next page is the, my lord, important. Section 10 of the Civil Procedure Code embeds doctrine of res judicata. The object of the provisions is to prevent the court concurrent jurisdictions from the simultaneous trying to two suits involving directly or substantially the same matter in issue between the same parties or parties claiming under them, unless all the statutory requirements contained under section 10 of CPC are satisfied. The subsequent suit cannot be stayed. In the case on hand, the defendant seeks to stay the proceedings on the ground of RFA so and so is pending before the honorable court in decree passed in OS number so and so. It is relevant to note that OS number 8177, which is said appeal is arranged pending to 6 kuntas so and so. On the other hand, the present suit is for permanent injunction in respect of site number 62 and 163 bearing assessment number 331, 332, kata number 246.
Reasoning is correctly given at page 109.
Milan?
Page 109.
105, Milan.
99.
109. Therefore, Milan, kindly come to Milan written statement in the earlier suit.
No, that property is no more in existence.
No, it is. Milan, kindly come to Milan page number.
So converted into, earlier it was 6 kuntas of land out of 26
That is my
acres, 8
property.
kuntas.
That-
Now in the present suit, site number 62 and site number 163 bearing assessment number so and so.
Therefore, Milan, earlier written statement filed by father, Milan, kindly page number 31. There, they have described their property, same property. Written statement annexure B, Milan, page number 21 start. Scheduled property, Milan, they have described their scheduled property, page number 31. 21 is the Milan written statement filed by their father. 31 is the Milan scheduled property described by their father. Same property.
Then where from the court finds the 6 kuntas of land?
That is my claim. That is my claim in the earlier suit also, in present suit also. That is my claim. Their claim is this property, schedule A and B property.
What has
in the
happened to
written
the
statement.
suit? Suit is dismissed.
Milan, suit decreed in my favor. Now, my lord, during the pendency of the suit, my lord, father has transferred in favor of our daughter. My lord, they are written in the written statement. They have clearly admitted. May I read, my lord, section 10, my lord. Nor court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially.
Then counts for the petitioner submits. Earlier, he has filed a suit for partition, a suit for injunction. That is OS number 8117 of 2012, which came to be decreed against that. An appeal is, an RFA is pending before this court. It is submitted that the defendant in the suit has transferred the property, suit scheduled property, in favor of the daughter, and the daughter has instituted the suit OS number
6964 of 2017. 69, 64,
69, 64 of
2017.
2000. What are you doing till now?
My lord, till then, my lord, the notice was not issued. I have got recently notice, my lord. Thereafter, injunction.
2017, it is submitted that in this case, there is nothing to be independently determined, as the father has gifted the property to the daughter, and she is also bound by the judgment passed by the court, and there will be every likelihood of conflicting judgments, and the court has failed to exercise the discretion conferred on it, in the section 10 of the CPC. Considering the submission, there shall be stay of all further proceedings in the 2017 suit.
Cell number 18, Vinay
So
Swami.
please hand someone say.
Vinay Swami, see.
Lord, sister files a suit for partition against the brother, my lord. Now, here is the case, my lord. The father writes a will in the year 2012 itself, my lord, in favor of the respondent. This is on 6/5/1980, a will is executed by the father in respect of the suit schedule properties.
When he died.
Pardon, my lord?
When he died.
He died in the year 2012, my lord. And subsequent to the will, my lord, the father executes a gift deed in my favor in respect of item 1 of A schedule property, wherein the respondent.
Where is the question of acting upon a will during his lifetime?
No, he died. The will was executed in 80. He died on 10/4/2012. Subsequently, all the revenue records, most of the properties.
He executed a will in the year 2080.
80.
1980. Sorry, 1980. When he died?
He died on 10/4/2012.
10/4?
2012.
When was the gift deed in favor of you?
One gift deed was executed. Gift deed was executed in 2012, 21/3/2012, and release deed was executed on 10/4/2012.
On the date of his death.
Prior to that, my lord,
He died on 10/4/2012.
his death is 24/8, my lord. 24/8 is his death.
24/8/2012. The release deed is dated 10/4.
Yes, my lord.
Hmm.
And the gift deed is dated 21/3/2012. Lord, in both these documents, the release deed, the plaintiff in the suit, that is my sister, is a witness in the gift deed. In the release deed, she is a party. Both are registered documents. She participates in these documents executed in my favor way back in 2012, keeps quiet all along. Now she comes and files a suit for partition in 2024, does not seek for cancellation of those two documents which are executed in my favor, wherein she is a party to the case, not that some third party has sold the property.
So what is IA?
IA is only for the injunction not to alienate. My lord, both the courts should consider whether it's a prima facie case made out by the plaintiff. Just says the best thing about the trial court is it says in view of those documents and the revenue records transferred in the name of the petitioner, more the reason an injunction order should be granted, because everything stands in his name.
Come to the order.
Yes, my lord. If your lordship can, lordship may go to page 15. That is the prayer in the plain. She doesn't seek for cancellation. She just
come to the
seeks
MA order.
Impugned order. Yes, my lord. I'll take your lordship to the impugned order. That is at page. If your lordship goes to the page 52, 51 paragraph 15, 51 paragraph 15. The copy of the gift deed dated 21/3/2012 relied upon the defendant number 1 shows that the Honorable Justice Range Gowda gifted item number 1 of the suit schedule property, the defendant number 1. Copy of the relinquishment deed dated 10/4/2012 relied upon by the defendant number 1 shows that the plaintiff is
Para
found.
13.
Pardon, my lord?
Para 13.
Para 13. Therefore, after considering the rival contentions of both the party, it is very clear that the rival, the trial is
Where are you
certain.
reading?
You said, my lord, paragraph 13.
1-3.
1-3.
But you are reading something which is not here.
Page, my lord.
12.
Oh, the lordship has gone to page 12. 12 is the plaint, my lord.
Page 12 of the para number, internal page 12 of the order.
Page 12.
Running page 75. Any order.
External page 75, internal page 12, para 13.
Paragraph 13.
After hearing the arguments of both the sides and appreciating the rival pleadings, it reveals that admittedly the plaintiff has filed a suit for partition in separate position in respect of suit schedule properties. Is also admitted fact that the A and B schedule properties are self-equate properties of Justice Rangegowda and B.K. Rajamma. On the one hand, plaintiff claims that there is no partition in the joint family constituted by both the plaintiffs and defendant, and he has a share in the suit schedule properties. On the contrary, defendant number 1 contends that he is the absolute owner by virtue of deeds executed by Justice Rangegowda and B.K. Rajamma. It reveals the records that the kata of item number 1 and item number 2 to 7 of A scheduled properties are standing in the name of defendant 1, and item number 1 in B scheduled property also standing in the name of defendant number 1, whereas item number 8 in the A scheduled property and item number 2 of B scheduled property stands in the name of the parents of the plaintiff and defendant number 1.
No, where does the court discuss about the documents?
Yeah, exactly, my lord. Paragraph 15, my lord. 76. Paragraph 15. The trial court observed that the kata of both the above said properties are entered in the name by defendant number 1 by way of gift deed and relinquishment deed. But there is no substantial document with regard to the entries of the name of defendant number 1 in respect of remaining properties, other properties. But he says that these 2 documents are there.
No. What are the suit schedule properties? Only these properties or other properties are also
Other
there?
properties are also there, which is executed by way of a will in my favor by Justice Rangegowda in his own handwriting.
No, as far as these 2 properties are concerned, we can understand. So why can't be there in an order of not to alienate in respect of other properties?
I have no objection. I am not. But this, with regard to these 2,
They are suit. What are the item numbers?
these 2 are, one is a property in Malleshwaram.
Let's see the plate. Where is the plate?
Item 1 of A scheduled property and item 2 of B scheduled
Come to the
property.
plate. Let us see the
16, page 16, my lord.
Yes.
A scheduled property, one is Malleshwaram property.
Mm.
With regard to the other agricultural properties, my lord, it was billed to me, but anyhow, since some revenue.
Only this property is where she signed.
Yes, my lord.
Only one.
And then with regard to item 1 of B schedule, it's page 7. At page 18. This is a Chamrajpet property. This also, she is a party to this relinquishment deed, my lord.
B schedule property.
This
House property, door number 18.
Yes, my lord. She stands, my lord.
What about 2?
With regard to that, again, agriculture land, these are all in my name, but the revenue records have not been transferred. It was standing in my father's name. He had executed a will in his own handwriting, my lord.
Please come. Let counsel for the petitioner submits the petitioner, let counsel for the petitioner defendant submits that the respondent herein has filed a suit for partition. In respect to the suit schedule properties, item 1 of the A schedule property and item 1 of the B schedule property, already a gift deed dated to 21/3/2012, also a relinquishment deed dated 10/4/2012 were executed in favor of the petitioner. In both the documents, the sister, that is a plaintiff, is also a signatory. It is submitted that she has not sought for cancellation of those documents and has filed a suit for bare injunction, for partition. The court, without considering all the aspects, the trial court and the appellate court have failed to grant injunction. The trial court has granted injunction, passing an order not to alienate, and the appellate court has confirmed the same. Considering the submission of the learned counsel, as far as the order, the order of injunction, the order granted by the appellate court granting stay of alienation shall not be, will not apply as far as the schedule A, item number 1 of A schedule and item number 1 of the B schedule. Notice to the respondents that said order will not operate against so and so.
But with regard to second respondent, he is my son, my lord. That may be dispensed with, my lord. I am not seeking any relief. It's
Memo.
mentioned in the cause. I mentioned it in the cause.
It is submitted that the second respondent is none other than the son of the petitioner. Hence, a memo, hence it is submitted the notice to the, say, he is not a necessary party for deciding this application. Hence, the notice to D2, respondent number 2 is dispensed with and summons on 1.
80, my lord, the hill is 1980. Witnesses would have gone. It becomes so difficult for us to, these sort of suits have become plenty, my lord.
Yes, 19.
Yeah.
You would beg to appear for petitioner Melada. Is the respondent number 6 petition Melad. Is the suit for partition. The defendant number 6 Melad, who is the petitioner herein, had purchased the suit schedule property. Melad, suit for partition, suit came to be decreed. Melad, defendant number 6 had placed ex parte. Melad, in FDP proceedings, Melad, notice had been issued. Melad, insofar as Melad, petitioner is respondent number 6 is concerned, respondent number 6 daughter received the notice. My lord, subsequently he came to know after he was placed ex parte. My lord, he came to know and he filed application. Order 9 Rule 7 application has been filed to restore the ex parte. Same came to be dismissed. For a moment, later, my lord, insofar as ex parte decree is concerned, mispetition has been filed. Mispetition dismissed.
Petition dismissed.
Mispetition dismissed. Subsequently, RA filed. In RA, my lord, on considering the merit of the case, absolute stay has been granted, staying the entire proceedings in FDP proceedings. My lord, I furnished the stay order copy along with memo. On considering the same, the earlier proceeding officer stopped the warrant to commissioner, the issuance of warrant to commissioner, and my lord, further proceedings has been stayed. Await order in RA. My lord, the incumbent proceeding officer, my lord, even after record, there is a filing of a stay order. My lord, he passes the order. The respondent number 6 had been placed ex parte. Therefore, the memo taken by the earlier proceeding officer is incorrect. Therefore, he issued the commissioner warrant. My lord, once the entire proceedings has been stayed,
To the order, I understood.
kindly came to
The order, I'll pass an order. Yes.
my lord,
Page number.
kindly came to page number 38, my lord. I have challenged both the orders. Now, placing ex parte has been also challenged annexure.
You can't challenge both in this.
Now, my lord, kindly come to
Restrict it to one order. They're two, they're both are independent. Which order you want to restrict it? This
my lord, annexure B, my lord.
That is order dated.
My lord, order page number 38, my lord, order dated 29/6/2026. Page 38, my lord. Page 38. Page 38.
Please come. The petitioner has questioned two impugned orders.
May
Petition.
my lord, is the consequential order. If, my lord, there are two applications, my lord, what my order says correct. There is no application. It's a continuation of order.
The petitioner has
Same
questioned
facts,
two
no?
orders. One is an order dated 28/7/2022. 28/7/2022 order is questioned now.
My lord, my lord, because of placing my ex parte, the trial court is not ready to accept the memo and stay order. That's why I am challenging the both order.
There are two orders questioned in this court, in this writ petition 28/7/2022 and 29/6/2026. The petitioner wants to restrict this writ petition to
29/6/2026.
29/6/2026, and the petitioner shall carry out the necessary corrections. And this, as far as the other relief is concerned, 28/7/2022, he can file a independent writ petition. Just come to this order. Where is it?
My lord, page 38. Man. Heard perused. On perusal of the order sheet, it is
But
evident.
anyway, the court has granted, the appellate court has granted the stay of FDP proceedings. Where is that order?
This, my lord. Page, my lord, annexure of page 66, my lord.
Page?
Page 66. relevant page, page 71. From reasoning, my lord. There, FDP proceedings 9 of 2020.
Where do you get that, that FDP proceedings are stayed?
My lord, in page number 16, internal page 16, page 75, my lord. Page 75. The application, that is IA number 2, filed by the appellant under Order 41 Rule 5 is hereby allowed. He seeks further proceedings in FDP proceedings. That's in reasoning, my lord. Line 3, it was stated. Even when the facts of stay came to the knowledge of the court, there is no question of proceedings, the further proceedings. Even I am not filed memo also. Court had knowledge the proceedings of stay in FDP proceedings. Even then,
Where is your application under Order 41 Rule 5? Application under Order 41 Rule 5. You filed it?
that was not filed, my lord. Because I furnished a stay order. That's why I am not furnished.
Counts for the petitions in the appeal when the court has granted stay of all further proceedings in the FDP proceedings. The FDP court has passed the impugned order whereby issued the commissioner warrant. I'm not able to understand this order.
Can't be.
Not his order. I'm not able to understand the appellate court's order. What is that is stayed? That I don't understand.
IA
from the
number
order.
2, my lord. That is the further proceedings in FDP case. Order 41 Rule 5. That was the point number 6, my lord, reasoning.
Where do you get that?
My lord, reasoning, page number 71, my lord. Page number 71. The appellant has filed application seeking to stay the operation of judgment and decree passed in FDP. Preferred my lord, appeal challenging the judgment and decree OS number, and as such it is just necessary to stay the further proceedings in FDP number 9 of 20.
The appellant has filed the application to seek the operation of judgment and decree passed in FDP. Where is the FDP judgment and decree?
Next sentence, man. Next sentence. By mistake that was. It is just and necessary stay the further proceedings in FDP number 9 of 20.
Yes. What do you do? The commissioner issued the commissioner warrant and counts for the petition submits that when the entire proceedings are stayed by the appellate court, question of proceeding with the matter does not arise. Considering the submission, the order impugned. Why should you come here? You can bring it to the notice of the appellate court about this order.
Even then, I filed 151 application. Court is not entertaining. Keep adjourning the case.
Proceedings, the registrar judicial is directed to call for a report from the FDP court. That is 11th ACJ and JMFC, Mysore, on when an order is passed by the appellate court staying the execution entire final decree proceedings, why the learned judge has passed this order. Lists this matter on 14th of August till such time they respond the FDP there shall be stay of all further proceedings in the FDP proceedings. Yes.
My lord, insofar as respondent number 1 is the contesting respondent, I seek dispensation to the my lord other respondent, my lord.
For the other respondents.
My lord, respondent number 2 to my lord 6, my lord.
2 to 6 memo file dispensed with 1 notice and summons. Yes, next.
Then number
Please.
20, Puneet C, 20.
Yes.
Defendant number 3 is writ petition, suit for partition. I filed transposing application, please, my lord, to transpose me as plaintiff number 2 is concerned. Plaintiff being the dominant, my lord, he says no objections, my lord, to transpose me as a plaintiff number 2 is concerned.
You're the family member.
I am the family member. In fact, my lord, in the parties to the suit, all of them are family members, please, my lord, the brothers is concerned. Now, please, my lord, if your lordship would peruse the, my lord, cause title of the plaintiff at page, annexure A.
Let's see what is the order first.
My lord, may I, before that, my lord, may I complete
We'll
the
complete this and go.
Please.
Yes, please come.
Page 39, annexure G. Page 42 would be the reasoning. The trial court says, please, my lord, that the plaintiff has not withdrawn or abandoned this claim as so provided under Order 23 Rule 1A is concerned. My lord, and also the judgment which is relied by the trial court is concerned, please, my lord, in Joginder Kaur versus Bagh Singh of Punjab and Haryana court. My lord, that suit, that judgment, my lord, relates to, my lord, the declaration suit is concerned. This is a partition suit. My lord, plaintiff, defendant number 1 and defendant number 3, they stand on a, my lord, one footing is concerned. Defendant number 2, my lord, he says, please, my lord, that there is an unregistered.
No, why you want more? No, you can contest the suit as a defendant. What is the reason that you should be transposed?
The plaintiff is not supporting me, my lord. I have produced the medical records of the plaintiff, my lord, at annexure J.
No, in the you must have filed an affidavit.
My lord, annexure 84, page 84,
Affidavit.
medical records.
Not that, not records before this court.
Please, my lord.
What is the reason you have stated in the affidavit?
My lord, the reason stated, please, my lord, of course, please, my lord, the not, my lord, but the fact remains is that, please, my lord.
Nothing remains.
My lord, my submission.
Affidavit is for the purpose of understanding why you
Yes,
want
please,
a
my lord.
particular
Yes, please,
order.
my lord. Yes, please.
So,
but if
without
your
you
lord-
stating just like that, say, I want to be
Lord, if your
transposed as a
lordship would see
plaintiff,
page
and the
70
plaintiff says you can be transposed, can't be a reason.
Page 72, my lord.
Under which provision permits you, a defendant, to be transposed as a plaintiff?
My lord, Rule 10(6), my lord, says.
What it says?
My lord, my lord,
When the plaintiff abandons it or the plaintiff
my lord,
fails
that,
to?
the 23 Rule 1A is what being relied by the trial court is concerned. My lord, to
Whichever provision you show.
Please, my lord.
Which provision
My lord,
says that
one-
just like that, this transposing should be done?
My lord, the mentioning of my lord, correct provision would not be.
I'm not saying this provision, that provision, any provision you show under CPC which allows this transposing the defendant as a plaintiff, routine
My lord,
manner.
in fact, please, my lord, plaintiff, my lord, is not supporting or conducting. Why? Because plaintiff, defendant number 1 and 3, they stand on a one footing, please, my lord. They all seek
It's
partition.
unfortunately the case of that is what is the order of the trial court. It says that you don't give a reason. What reasons you're giving here?
Please.
Now under 226, under 227, I can't consider all
That I
that.
had produced, my lord, the medical certificate before the trial court.
Do you expect the court to understand that
I
plaintiff is
understand,
unwell?
please, my lord, the reasoning may not be. But the plaintiff says no objection, please, my lord. Your lordship may kindly peruse the
Cannot be
order
a
sheet.
ground.
Page
That cannot-
72.
That cannot be a ground.
But the, my lord, the person, my lord, but the person who has objected for transposing is the defendant number 2 is concerned.
Forget about what plaintiff said.
Kindly
what
see the
defendant
written
said.
statement in.
Please understand. Let's
Please.
forget about what are the objections. Only tell the court there should be what is the procedure when an application has to be allowed transposing the defendant into a plaintiff. Have you satisfied those requirements? Without that, how do you expect the court to pass an order? It's a very simple question.
Page 35 in my affidavit, please, my lord.
Let's
I
see
only
the
say
affidavit. Let's see.
page 35.
Yes.
Para 3. Para 2 and 3, please.
Nothing. You don't even say that the plaintiff is not prosecuting the.
My lord, if your lordship, my indulgences, kindly
them-
peruse the written.
let others come. We will see. Notice the respondents.
May I
And
seek,
summons.
in fact, I have not sought for stay also, my lord.
And
But
summons.
may I seek only this much. As far as the notice to defendant plaintiff and defendant number 1 is concerned, my lord, it may be dispensed. The only person who filed an objection is the defendant number 2. My lord, I'll take out notice to the
Notice
defendant.
to, a memo is filed seeking dispensation of notice to respondent,
Respondent number, please, my lord. 1 and 2.
1 and 2, notice to third respondent.
Or trial court counsel, my lord.
Counsel. And if the memo is filed by 24th of August, list the matter on 25th.
Please.
Number 21. Sampath
Plaintiff's writ petition in a eviction suit against the tenant respondent.
Mm.
The petitioner filed an application at Annex D under order page 33, my lord. The notice to produce the lease deed, my lord, which is with the tenant. Page 33, my lord, under 11 rule 16. Original lease deed, well, which is in the custody of the defendant, my lords.
What is order now?
Plus the order says, my lord, not Annexure A, page 11 is the order. Reasons is page 15. Para 9, my lord, it says after filing the magistrate.
You are the?
Lords, I am the plaintiff in the suit. My lord. As stated, my lord, it is with the custody of the defendant. My lord.
As for the pleadings of para 9 of the plaintiff, pleaded that the plaintiff is herewith producing original lease deed dated 31/20.
That is the mistake, my lord. I'll just show you one document, my lords. May just tender this document. Lords, at the time of filing the plaint, my lord, there was a oversight mistake saying that there is original I have produced. And the first date of hearing, my lord, learned trial court noted that I produced only a Xerox copy. The first date of hearing, my lord.
What are the objections to this IA by the
Lords,
defendant?
he says it is not with me. The tenant says it is not, originally is not with me. It is with
What
the
the court can do now?
Lords. Lords, normally, my lords, but lease deed, my lords, it with the tenant.
There is nothing like normal.
Please, my
You
lord.
say it is with him. He says it is not with me. Then what the court can do?
Lords, court, my lords, now the difficulty, my lords, that I have understood. Difficulty, my lord, learned court director, my lord, the lease deed which I wanted to produce, my lord, it's a photocopy. On that, my lord, trial court said, page, it is insufficient stamped. Refer to the district registrar. District registrar gave a report saying that I have to pay this much so and so as the amount. Lords, I'm ready to pay and get it marked. Lords, the registrar is unable to import the document which is a photocopy. But I am with the Xerox copy and he is with the original. But he wants to play with the Lord. He don't want to matter to proceed.
We are not on a criminal proceedings.
No, Lord, I
How do the court will? He says he nowhere stated that it is with him, even in his written statement. And on the top of it, on your in your plaint, you say that you're producing the original document.
That's a mistake. The first date of order sheet may just request note that the memo.
No, anyhow, but no, how can the court compel him when he says it is not in his custody?
But I followed. But so another difficulty, Lord, I may be permitted to lead the secondary evidence that may be considered, Lord, without the because the original is, Lord, that's a.
So in this case, I'll be passing an order that you will be.
No, Lord, I'm just
to,
saying this should not be being influenced. That's so, Lord.
That I will not go into any of it. It is not there. It is not there.
Yes.
When you file an application, when the court passes any such order, then you will come to the High Court.
Yes.
We will not prejudge things. Please come.
That's,
Agreed with the order dated 23rd February 2026.
I'm sorry to disturb, Muller. In the original, Muller, the copy of the lease deed I produced with the memo. In that, Muller, it says, Muller, original, Muller said it's in two duplicate. Duplicate is with me and the one is with the defendant. Muller may just take that clause in the lease agreement to show, Muller, the page 6 of that memo is the lease.
No, all said and done. When he says, I don't have, what we can do?
That's but Muller, it's my only contention. Muller, he is withholding unnecessary is my submission.
That I'll record that submission.
Please.
Basing on this.
Please.
Agreed with the order passed on IN number 7 in OS number 314 of 2018 by third edition senior civil judge and JMSC at Kolar dated 23rd February 2026. The petitioner plaintiff is before this court. The plaintiff herein has filed a suit for eviction.
Eviction and recovery of arrears of rent.
Eviction and suit for recovery of eviction and recovery of rent. In that, he filed an application under Order 11, Rule 16, that is Section 151 CPC, seeking to issue summons or direct the defendants to produce the document as referred in the written statement at para number 3 and 4 in page number 2 and 3 in respect of 4, that is the original lease deed dated 31/20/25 that came to be dismissed by order impugned. While passing the order, while rejecting the application, the court has observed that at the filing of the suit, the plaintiff has not stated reason as to who is holding possession of the original release deed dated 31/20/25. As per the pleading of para 9 of the plaintiff, it's pleaded that the plaintiff is herewith producing original lease deed dated 31/20/25. Nowhere he has stated the original lease deed is in the custody of the defendant. On the other hand, the defendant contended that the lease that he has nowhere pleaded that the lease deed in his custody, and the defendant denied the fact that it is in his custody, and accordingly, court had rejected the application. Learned counsel appearing for the petitioner submits that it is by it is a typographical mistake in the set plain, wherein they have stated that there is a original is placed before the court. In fact, what is placed before the court is a copy of the Xerox copy.
And that is noted in the first date of hearing.
That is noted in the first date of hearing. It is submitted, he has drawn the attention of the court to the lease deed. It is submitted that in the lease deed, it clearly stipulates that the original lease with the tenant and the copy is with the owner of the property. It is submitted that the court ought to have allowed the application and ought to have directed the defendant to produce the document. Next para, having heard the counsel for the petitioner, what is the material on record? Without considering the facts that, not even without going into the fact, what has been stated in the plaint by the petitioner, which is clarified thereafter. But the fact remains is defendant, according to the defendant, the original document is not in his possession. In those circumstances, the court cannot direct the defendants to produce a document according to them, which is not in their position. Considering the same, the court has rejected the application filed by the petitioner. In that view of the matter, this court is passing the following order. This court do not find any infirmity with the order impugned, accordingly dismissed.
Please, great.
Cell number 22. Or Lokesh.
The mandamus direction to the respondent authority to assign the timings which has been granted by the authority.
Let's see, what is that?
Annexure A. The petitioner has sought for the variation of the condition of the permit.
Mandamus directing to the respondent authority to comply the directions issued by the KSTA. That is
Annexure A, KSTA has granted the variation.
Stated decision pronounced on. Why should there be a direction by this court?
Because even after 6 months.
By the KSIT won't do anything.
No, KSTA will not do. It will direct the secretary. Secretary has to assign the timings.
Yes, Mr.
1 month, 1 month, 4 weeks, my lord.
What's 4 weeks for everything? This order is dated 15/10 and 24/12. Get instructions. I'll take it up this matter tomorrow.
Please.
This is matter tomorrow in the first list. AGA takes notice on behalf of the
Monday, my
respondent. Monday.
Please.
In the first list, so that we will pass a definite order.
Please.
Yes.
Cell number 23. 23. Okay.
This matter, my lord, yesterday, my lord's petition is maintainable, my lords. The coordinate bench has decided on maintainability.
Justice Tara Ganjusman.
Please.
But there are exceptions to that.
Please, my lord. Whether it is an appealable order or not is the exception which is decided. Even the other coordinate benches, my lords, have entertained the petitions with similar matters.
Copy.
Sorry, sir.
Yes.
It's 11 page 22, my lords, discussed about maintainability. 11 page 46, my lords.
What are the judgments of the Supreme Court on this?
Please, my lords.
What are the judgments of the Supreme Court on this?
My lords, even Supreme Court says, my lords.
That you can rely on, the Supreme Court judgment.
Timing, it is maintainable, my lords. The other coordinate benches have entertained the petitions.
The difficulty is the whole purpose of this commercial courts will lose its sanctity. Like any other civil suit, every matter we start entertaining. You understand? Not
Please,
in your
ma'am.
case. On a larger perspective, I'm saying. always the powers, there are Supreme Court judgments where they say the arbitral proceedings are under this, not that it is completely the doors are closed. They can.
Please.
There are very, very limited intervention of the High Court, not in every and each
Please,
and every order.
Please,
So whether you will fall under those exceptions or not is the question.
Please, my lords, I fall under that exceptions, my lords.
What are those exceptions carved out?
But appealable orders are explained in 43, order 43.
Not appealable orders, forget about that. Any order arising out of a commercial court, filing a 227 writ petition, for that there are certain limitations in which matters the court will interfere. That we will, if you can point out that accordingly, nothing like every order, whatever is not appealable, every order is amenable to 227.
Section 13 says that, my lords. Only the appealable, Section 13 of the Commercial Courts Act says that. Only the appealable order which is mentioned under order 43 is appealable.
That is one limb of it.
Please.
Then there are judgments. You please look at it. I remember I've come across the judgment of the Supreme Court where they say that though the completely 227 is not a bar for any of the interlocutory order, but they have said there is a cap on that. 1, 2, 3, 4. There are some illustrations on that. On which cases the court can interfere under 227. Not like any other the original suit. Yes.
Even that is dealt in this judgment, my lords, Tara Vistara, Lordship Tara Vistara judgment, my lords, where in the page 2. Page 2 only. It clearly mentioned supervisory jurisdiction at 227 to be exercised sparingly, not as an appealable remedy. Article 227 jurisdiction not barred by Section 8.
Where are you reading?
Page 2, my lords, the judgment, where the table of contents only, where the lordship has clearly stated on what all it is applicable.
So para 2.
Page 2, my lords, though, not the para 2. The table of contents I am stating. Page 2 of the judgment.
Brief facts are there. Preface is there. Table of contents.
Please,
yes, table where?
After maintainability, my lords, the points are third point, fourth, fifth, and sixth. All these points are specifically
issues for consideration.
Please, my lords.
That's why you draw the attention of the court to that.
Let's page 46, my lords. Page 45 is the commencing, my lords. Article 227 and commercial disputes. The Commercial Court Act was enacted in the view of increasing pendency of commercial cases. It was observed in the statement of objection and reason of the Commercial Court Act that there was required an effective mechanisms for speedy and efficient disposal of commercial disputes, including by amendments to CPC, Arbitration and Conciliation Act, 1966, another statute. When this writ petition was initially considered, a doubt was expressed as to whether the petition under 227 of the Constitution would be maintainable, and the extent of interference to be excised by the court, since challenges to the interlocutory orders passed by the Commercial Court were curtailed under the Commercial Court Act. The reservation of the court was also based on the fact that the Commercial Court
Section 8 of the Act.
Please, Section 8, my lords, is about the petition, where it bars to file a petition, where the Commercial Courts Act bars to file any petition. Even that is dealt in this case, my lords. Section 8 as well as 13.
Which state that no civil revision petition application filed against an interlocutory order passed under the CC Act. Para 19 I'm reading.
Please, my lords. Next, for 19.2, my lord. Section 13 of the Commercial Court Act.
8, not Section 8 is extracted here.
Please, my lord.
Read that.
Bar against revision, application, or petition against an interlocutory order. Notwithstanding anything contained in any other of the time in force, no civil revision application or petition no civil revision petition and application shall be entertained against any interlocutory order of a commercial court, including an order on issue of jurisdiction, and any such challenge, subject to the provision of Section 13, shall be raised only in an appeal against the decree of the commercial court.
So, read with Section 8 and Section 13, a conjoint reading of both.
Please,
a 13 deals with the appealable order that will go to the commercial appellate court. And 8 says there is absolute bar
under 8 for the petition. Even that is dealt with the further paragraphs. It is
what
dealt.
Is that for petition? What I didn't understand. It says against an order of the
interlocutory orders as well. It says,
that is Section 8.
Please, my lords. Page 51 for a minute, my lords. Page 51, para 20, my lords. Clearly, the intention of the legislature was not to have all pervasive access to the challenges made to the Commercial Court Act. Thus, the question that would arise is whether parties should be able to circumvent this statutory provision by making frequent recourse to Article 227 of the Constitution to challenge under the Commercial Court Act. An examination of the law as set out herein above reflects that. It is important for the courts to ensure that the power under 227 be exercised to ensure compliance with the objectives of the enactment of Commercial Court Act remains intact.
I'll tell you, the civil revision, when they are saying, you don't have to look at it as a CRP under 115.
Please,
the problem is, all courts do not have a 227 WPs. What it is in some other courts, like in Andhra or Telangana, what we have is a CRP under 227, CRP under 115.
Please,
so whenever it is referred to as CRP, that doesn't mean that GMCPC under 227 is something else.
Please.
Revision, we are only doing it by supervisory jurisdiction. We are revising or the order of a court.
Please,
so whether you're filing it at a 115 or 227 is the only difference.
Please.
But the powers that are conferred on the court are the same under both. So when come to this point number 3 at page 52.
Article 227 of the Constitution should be used for jurisdiction.
4. What has been barred by section 115 of the CPC through section 8 of the Commercial Court Acts cannot be subsequently reviewed by use of powers under 227 of the Constitution.
Please. Whereas ultimately the conclusion is that it is entertained.
Where the turn has taken.
Various Supreme Court judgments have been.
Now that we will look at.
That is mentioned in Malat's para 23. Page 23. A division bench of Delhi High Court in CP Ramarao case has been held that the petition 227 of the Constitution is maintainable against orders passed by the Commercial Court. That the jurisdiction of the High Court under 227 of the Constitution.
Court was dealing with a particular provision, Order 7, Rule 10A.
Please, ultimately,
it proceeds with the dispute and other things. Then where is the discussion on this? If you look at it,
please,
then after laying all those the parameters or guidelines, whatever you call, court has gone into Order 7, Rule 10A and the provisions powers.
That was challenged before the coordinate bench. Order 7, Rule 10 was challenged under 227. That is what is particularly dealt with.
That is an appealable order and that's how it is dealt with.
Whereas the maintainability is specifically raised on the
my point is when the provision says something and when the intention of the legislature is something in having this Commercial Courts Act, we just can't. There should be some interpretation to that, like when, where, and how. Every party feels that's a grave injustice, manifest error. In whatever order he wants to impugn, there is a manifest error. That won't be the reason. So we have to distinguish between what a regular, interlocutory order arising from a civil suit and what are the other interlocutory orders arising from a commercial court. Unless and until that distinction is there.
Section 13 draws the distinction, my lords.
8 you are forgetting.
8, my lords. Bar against revision application or petition against interlocutory order.
That is what yours is, an interlocutory order.
It's an interlocutory order, my lords.
So 8 and 13 are two different provisions, and it speaks about 13 speaks about an appealable order. Yes. It has to go before the commercial appellate division. That's what it is. You can't file a regular appeal against that. It will go to the commercial appeal.
Section 8 in fact says, my lords, notwithstanding anything contained in the law of the time being in force, no civil revision application or petition shall be entered in against any interlocutory orders of commercial court, including an order of issue of jurisdiction.
What is happening in this case, Mr. Counsel?
Let's may just assist your
No,
lordship.
not about this. What is happening now? What is the immediate necessity for him for?
Yes,
for
my lord,
India?
I am the decree holder, my lord. 4 crores of rent, they have not paid till date. 8 lakhs per month rent, 5 years they have not paid the rent. They're happily enjoying the possession. Now execution proceedings have been filed. It's been more than 6 months. The decree and judgment also has been passed, my lord. Now, my lord, their only ground, I just read the petition. I just borrowed the petition from my friend and I just read it 2 minutes back, my lord. So their only ground is that the immovables of of the judgment debtor, my lord, are already pledged with Canara Bank. Since it's already pledged for Canara Bank, they're trying to say we are going to take delivery.
Oh, why
warrant.
are you so concerned with Canara Bank?
Yeah.
Canara Bank will protect itself.
Yeah, and my lord, as far as that is concerned, my lord, I have already sent a legal notice to Canara Bank with all the proceedings of this case, my lord. That is the legal notice, the judgment copy, decree copy, attachment before judgment copy, everything I have already sent to Canara Bank. I have already appraised these issues to the Canara Bank. And all this legal notice and proof of delivery, all the documents have already been filed before the commercial court on 17/7. Now they are challenging the order of 17/7 and the subsequent order of 27/7 on the ground that Canara Bank's properties are also hypothecated. But my lord, this is already brought to the notice of the Honorable Commercial Court, my lord. So even if your lordships were going to the
He's
facts,
trying to take. He's trying to protect the interest for the.
Canara Bank, Canara Bank,
Not the protection
which
of
Canara
the
Bank only is not
interest of the
interested
Canara
because they've
Bank.
already
I'm
intimated
protecting
to Canara
myself
Bank.
for the reason.
Secured creditor.
Yes.
For the
Basically,
reason,
they're only trying to just arm twist us and delay the execution proceeding is only attempt here played here.
not the intention, my lord. The
So that
only,
was the case, my lord.
only,
The commercial.
Tell the court. How are you bothered about now? You have.
Lord, the
You have
reason is,
taken.
my lord.
You have taken loan from them, or no? You owe certain
Please,
amount. Court
please,
has passed an
please,
order,
please.
and the Canara Bank is also aware of this proceedings.
Please, ma'am.
Canara Bank keeps quiet.
Please,
Now, if the execution takes place, how are you affected?
Lord.
Either it will Canara Bank will take or they will take.
Please, my lord.
Yes.
The difficulty is, my
And
lord.
and the Canara Bank, when there is no secured asset, they can't do anything.
It is secured asset, my lord.
That's what I'm saying. If that is secured asset, if in the process of this, the execution, if they sell that property, it's for the Canara Bank to decide. How are you?
Because I'll be classified as willful defaulter.
My lord, even
That is
as
the
for
thing.
this
And
is,
second thing is, my lord, it's a brewery.
It's already a willful defaulter.
yes, my lord.
Not a willful defaulter, my lord, by choice.
Well, just to shed
Well,
some
the
light on
reason
this
is, my lord,
point
there
of
is around
argument, my lord, they have
12,000
taken a
liters
loan
of-
from, just a minute, I'm sorry. They have taken a loan from Canara Bank, my lord, with being a property being pledged. So the Canara Bank is already against those properties before DRT under surface proceedings, my lord. So Canara Bank money is going to be realized by selling those properties. They're not really concerned about this movable assets in office, my lord. That is furniture, equipment, tables, and
That is
things
also
like
plant
that.
and machinery.
They're going to get the money from the property itself, my lord. They're already secured to that extent. It's a secured loan of a secured property loan. But as a bank practice, what they do, they're giving a loan. Since they're giving a loan to the company, property is being the director. His director is giving a personal guarantee, giving his property. So just as a formality, they write also the equipments and machineries of the company is what they write.
What do you say about the maintainability?
My lord,
What do you say about the maintainability?
maintainability, my lord, I agree with your lordships, my lord. Like lordships already pointed out on 8 and 13, my lord, that elude your lordships, my lord. But as far as the facts are concerned, my lord, and the merits are concerned, there's absolutely no facts or no merits in the bit.
Because my only submission is, my lords, they filed application under IA number 3, my lords, for attachment of sales, attachment of movable property. That is still
That is not
pending
allowed, that is
consideration.
kept as abeyance, my lord.
That is pending consideration,
Yes.
whereas the court allows the order of attachment without considering my objections.
The only
That
grievance
is the only
there is,
objection
my
I'm
lord,
raising. Let them
the
provide
court
an
has the-
opportunity, let the Canara Bank also contest. And I request for
Forget
a
about Canara Bank.
Canara Bank.
Forget
Because
about
I
Canara Bank.
request for
Nobody will ask Canara Bank to come. He has already informed to the Canara Bank. They will take care of their interest.
please, my lord.
Yes.
Because what I'm seeking is a little time, my lords, because it's a brewery, my lords, it's a huge machinery is placed there. I'll have to remove it. There is 12,000 liters of beer inside that, which I can't just put it away, my lords, for the reason that the excise department won't allow it to. For that
petition
reason,
is filed-
I sought for some time.
Petition filed on 22nd April, my lord. Notice has been issued. They've appeared on May. From 3 months, that's sufficient time to all this. In fact, judgment and decree is for 6 months back. That's sufficient time to take these steps.
Because even now, my lords, even now I'm ready to pay the rents. I've already mentioned that every month I'll pay 8 lakhs. With that, every 3 months I'll pay 25 lakhs. That is 1 crore per year.
So forever you will stay in the premises.
No, that is not the intention. No, in fact, my lords, I'm selling the business itself. Until then, my lords, at least I can.
So, any other judgments on this?
This, my lords, in this judgment, it is clearly held that it is maintainable, my lords, and there
It is not. Nothing. No,
judgment, my lords,
no
where
such
the-
law has been laid down in this. You show me the particular portion. This what? Where it said that. And in the light of what I have read,
Please.
issues for, not issues, where it is,
Page 23 itself. Page 23.
page 23,
Page 23.
maintainability.
Please, Novas. Para 12. Thus, the question number 1 aforesaid is answered by holding that the petition under Article 227 of the Constitution of India to the High Court with respect to the orders of the Commercial Court at the level of district judge is maintainable, and the jurisdiction and the powers of High Court has been and could not have been affected in any manner whatsoever by Section 8 of the Commercial Courts Act. The use of word petition in Section 8 is not and could not have been with reference to a petition under Article 227 of the Constitution, and is with reference to a revision application / revision petition only. The aspects noticed by us in Black Diamond also find a reasonable resonance in a judgment rendered by the High Court of Bombay in Parvin Chandra versus Hemant Kumar, and where it is held. Though Section 8 of Commercial
So
Act.
you come to this page 31. Article 227 jurisdiction not barred by Section 8 of the CC Act. Interference to be limited to erroneous manifest injustice. What is that?
The impugned orders is challenging, my lord, is orders of issued delivery warrant. It's an eviction come recovery suit. So issuing delivery warrant cannot be a ground for filing a writ petition in 226.
My lords, without considering the application,
What application?
Order 21 Rule 30, which is still pending, they issue the order for attachment. The very application is filed or attachment. I filed objections. I've stated my contents.
What will happen to the mobiles?
My lord, that is kept in abeyance, my lord, because our priority before the court is first to get the possession, my lord, because they're enjoying the property from 5 years without paying rent. 4 crores arrears, my lord. So our intention is to first get the possession, my lord, and thereafter proceed with the sale, my lord. Because as a duty, my lord, in coming in good faith, we have informed Canara Bank. But however, my lord, we have also done our due diligence. We have taken the DRT papers. We see that they only.
No, but the court ought to have decided that, because if you have to have the possession or whatever you want to do with the premises,
My lord, to
court has to decide about the
Yes,
mobiles,
yes, my lord. So to
whether
cla-
you are entitled or he is entitled.
Yes, my lord, to clarify this, my lord, when the suit was pending, an attachment before judgment application was filed, all the mobiles attachment order has already passed. The bailiff report is already there, my lord. So all that is part of my execution petition, my lord, where I've given the attachment.
Oh, it's already attached.
Already attached in the suit itself, my lord. Even
There is
before the
nothing which is
execution
mentioned in the
proceeding.
judgment. It was attached during the suit.
Yeah,
There is
but-
no recital in the judgment, my lord.
They're aware of it. Why
Yes.
should there be another attachment now?
Yes, absolutely no merits,
In
my
fact,
lord.
my lords, to be frank, my lords, the suit is more or less like a ex parte suit, my lords. It is not contested. In
So
fact,
you're
my lords,
going-
the notice, the eviction notice is also not in
Option one
accordance.
not working out, then taking two, then now
So
you're
that is
come
why
to
I'm
three
not going
now.
to the facts of this thing, my lords. My lords, the only request is, my lords, let the court consider the application. Until then, tomorrow is my lords, the matter.
It doesn't matter. Tomorrow you can be assured that the court is going to pass an order favorable to them, because already there is an attachment.
Yes, sir.
Yes, Mr. I'll pass orders on the maintenance. Yes. No, not that. You have to detail on.
My lords, may we be permitted to give appearance slip, my lord, of our names?
Yes.
Oh, please.
Cell number 24. Cell number 24.
Hearing for the petitioner, my lords. Challenging an order of BESCOM, my lords. Adjudicating officer.
Why
Lords,
there
the
is no
impugned
appeal
order is
against that?
Please, my lords.
There is no appeal against that.
Sorry, my lords.
Appeal.
Lords, yes, of course. Section 127 of the
Then
Electricity
why are you
Act.
before this court?
My lords, this is a patently illegal order. Errors are apparent on the face of the record, my lords. Alternate remedy does not bar your lordship's writ jurisdiction in this matter, my lords. And I'll demonstrate this error patent record, my lords. My lords, the assessment order is of 2026, my lords. A similar proceeding was held in 2021.
Better you take notice on them. Will hear them also.
My lords, my connection has already been disconnected, my lords.
Huh?
I seek an interim order, my lords.
Tomorrow.
My lords, my disconnection. So, my lords, can I just?
I'll take a passover and serve the papers on them. I will not be passing any orders without hearing them.
Please, my lords. I've
The-
in fact
the-
served BESCOM already.
Yes, who's the council in the Viscom?
My lords, can it be today at 2:30, my lords?
Mr. Vinayak VS is directed to take notice. Serve the papers on the council. Passover.
Cell number 25. Prakash, yes.
Tell them that he should get instructions. Court, he should get instructions by afternoon. Yes.
appearing for petitioners in this case.
Yes.
Petitioner is the dependent number one in the trial court, and respondent one is the plaintiff in the trial court, and other respondents 2 to 7 are the dependents in the trial court.
What is the suit for?
The suit for declaration injunction.
What is the IA?
Filed IA number 7, Your Honor. Page number 37, Your Honor. This is
Framing
the
of additional issue.
recast the issues, frame and propose additional issues, Your Honor. Kindly permit me to read the proposed additions, Your Honor. One is whether the suit filed by the plaintiff is barred by the limitation in view of the alleged transfer of rights in favor of the dependent number 3 in the year 2007, Your Honor. And 2, whether the plaintiff proves that the suit is property valued for the purpose of the court fees and jurisdiction. And third is whether the court fee paid by the plaintiff is insufficient and the suit is undervalued. Fourth is whether the suit is bad for non-joinder of necessary parties, namely the concerned revenue authorities, which is very important, Your Honor, relating to the alleged grant under the Enarmed Abolition Act. So, in para 16 of the, page number 16, Your Honor.
Why the Enam authority should be parties to the suit?
Because they claim the declaration. It is in 1958 they got the
They are
grant.
claiming declaration, whatever are the relevant document they will place. In every declaratory suit, all as authorities are not necessary parties.
No, this is 2023 suit, and they were saying 1950 they grant.
Documents will be
No,
there.
For the
Document
moment,
basing
if
on that, it
assuming
is
that-
not, it is not necessary. Court has rightly said so.
And the 2, Your Honor, that is page number 18, Your Honor. In the land, they says there's a construction of the part of that, and when the construction is there, the valuation has to be taken for the 50% of the market value. That is not been done. Accordingly, the court fees also changes. So therefore, I sought for interim leave to stay.
Then the court has passed, the limitation issue has already been framed.
No, they are not framed, Your Honor.
Accordingly, the following additional issue is framed by the
So
defendant number one.
it is only for the purpose of limitation. This is order 14 rule 1. The trial court should have been seen much earlier passing this, the issues.
Notice to the
After
respondents.
filing the additional issue, they have filed it.
Notice to the respondents, hand summons, the memo, shall file a memo. If the memo is filed, once the memo is filed, is the matter, yes.
Number 26, Vivek S.
Pass over in this one.
Pass out. Yes, next.
Number 27. Cell number 27. Kapil Dev Ullar.
Both the matters pass over. No, this 27, no pass over. He is not there. List this matter in the month of September. 28.
Cell number 28.
For the petitioner, my lord. My lord, suit for specific performance. I filed an amendment application, my lord. That amendment application has been rejected.
What is the suit for?
Suit for specific performance, my lord.
Which year is the suit?
Suit is of the year 2009, my lord.
What is the amendment now?
My lord, the amendment is they had issued a legal notice for termination of the sale agreement, and subsequently the reply notice was given. Those facts, because my husband was taking care of the case, those legal notice and reply notice was not in with my custody, and subsequently after issuance of the legal notice also they have received payments, my lord. But they deny, they have produced the receipts also. Those, because they have denied those aspects, I've filed an amendment application stating that the legal notice and reply notice was not aware, I was not aware of that until unless they produce in evidence. The amendment application was filed to that effect, my lord, and also sought for declaration that the termination is invalid because subsequently to the their claim of termination, they have received payments from us. So that is the reason I filed.
Have taken place.
My lord,
All these things when they have taken place.
after sale agreement was done in
There
1996.
should be a date for that.
My lord, the sale agreement is for page number 20, my lord. 7/10/1996, my lord.
7/10/1996.
96.
Suit is of the year 2009.
2009.
Now in 2025, you want to bring the facts which are taken place in 1996 on record.
My lord, because the evidence was
Order, I understood. Come to the order. Let's read the order.
order, my lord. In found at ink page number 14, the reasoning starts at ink page number 18, my lord.
Come to para 9.
9. A careful perusal of the pleading, the documents and order sheet, the both parties have adduced evidence before the court. The matter was posted for arguments on merits on 29/1/26. But on the said that the plaintiff has filed the present application by seeking amendment of plaint. A careful perusal of the proposed amendment, the argument for the counsel for the plaintiff that in order to avoid execution of sale deed in favor of the plaintiff as per agreement of sale dated 7/10/96, the defendant with ulterior motive has issued legal notice dated 21/97 to the plaintiff without any basis, and the plaintiff has issued reply dated 7/4/97, and they have denied the termination of the agreement and also argued that agreement of sale dated 7/10/96 was valid and binding the parties. The said arguments of the plaintiff discloses the defendants have already issued notice to plaintiff on dated 21/97 and terminated the agreement of sale dated 7/10/96. The said fact is within the knowledge of the plaintiff. As admitted, they have issued a reply notice dated 7/4/97. The suit has been filed by the plaintiff in the year 2006, and they have not been pleaded about the issuance of notice by the defendants by terminating the agreement of sale and also issuance of reply dated 7/4/97, stating they have denied the said termination which was issued by the defendants. Further, in the present case, the plaintiff has sought the relief of declaration to add in prior column to declare that the termination of agreement of sale dated 7/10/96, while legal notice dated 21 is illegal, invalid, and not binding on the plaintiff. A perusal of the plaintiff governments, it is the case of the plaintiff that the defendants and their father have executed agreement of sale dated 7/10/96. In presence of witness, also they have stated that her husband and she had handed over the money many times and also obtained receipt with regard to payment of money. Therefore, firstly, the plaintiff has to prove the agreement of sale dated 7/10/96. My lord, this is a thing which is incorrect because they are not denying the agreement of sale, because I will take your honor through the written statement. The execution of the sale agreement is admitted, but the trial court says they have to prove it. Before the court stating the defendants have executed the sale agreement.
Considered at the stage of after the arguments.
My lord, I was not aware about the legal notice because they produced at the time of evidence. Immediately I filed this application.
Not immediately. In the year 2026, you have produced.
My lord, the evidence happened till April. In fact, in this matter only. My lord,
to your husband?
My lord, husband is no more. My lord, he was taking care. He was taking.
He died.
Huh? He died in 2015.
So the suit is of the year 2009.
No, one second, I am not sure exact date. No, he died recently. That is recently, my lord. I'm not sure exact the date.
Only it's on the face of it to cover up the lag.
My lord, now, my lord, only after the direction from this honorable court, the matter was pronounced for judgment, my lord. Kindly come to Annexure J, my lord.
When was it pronounced?
My lord, it was posted for judgment without giving the order copy to me, my lord. If your lordship remember, Annexure J, only after direction from this court, there are two orders which were given to me, IA 15 and orders on IA 15 and 16, my lord. Only after getting those orders, I filed this writ petition, my lord. And the matter is posted for judgment on 29th August, my lord.
I am not interfering with it.
My lord, because now that amendment application is very much necessary.
Not at all necessary.
My lord, because if the termination subsequent to the sale agreement, my lord.
Understood your contentions. I'll record it. Agreed with an order passed in I number 15 under order 16 rule 17 by the senior civil judge and JMFC at Nelamangala dated 9th April 2026. The plaintiff is before this court. The petitioner plaintiff has filed a suit seeking specific performance. The suit is filed in the year 2009. In 2026, the present application is filed seeking amendment of the plaintiff that came to be dismissed by order impugned. The court has observed that while dismissing the application, the court has observed that the plaintiff has sought relief of declaration to add in the prayer column to declare that the termination of agreement of sale dated 7/10/1996, while legal notice dated 21/1997 is illegal, invalid, and not binding on the plaintiff. A perusal of the plaintiff governments, it is a case of the plaintiff that the defendants and their father have executed agreement of sale dated 7/10/1996 in the presence of witness, and also they have stated that her husband and she handed over the money many times and also obtained receipt with regard to payment of money. Therefore, firstly, the plaintiff has to prove the agreement of sale dated 7/10/1996 before the court, stating that the defendants have executed agreement of sale in presence of witness by receiving the partial consideration, and she's always ready and willing to perform her part of the contract on the basis of the agreement of sale. But after reducing the evidence of the both parties, the plaintiff has filed the present application seeking amendment of the plaintiff. The proposed amendment discloses that the plaintiff is trying to withdraw the admissions given in the cross-examination of PW1. Further, a perusal of the order sheet and material available on record It is a case of the year 2006 filed for specific performance of agreement for the contract against the defendant, and already 19 years has gone. And when the court has made efforts to record the evidence of the parties, the plaintiff has filed the present application without arguing the matter on the merits. Further, a careful perusal of the pleadings and proposed amendment, the said application filed with the plaintiff is barred by limitation that the application is filed after a lapse of 19 years. If the application is allowed, it would cause a lot of hardship to the defendant than the plaintiff. Further, if the application is, if the application is allowed, it would cause a lot of injustice to the defendant than the plaintiff. And the court has held that the application has to be rejected and accordingly rejected. Then counsel appearing for the petitioner submits that this amendment is very much crucial in the facts and circumstances of the case. It is submitted that the petitioner, who is the wife, is not aware of the notices and other aspects. Only the husband is aware of the same. After his death, she could procure these documents, and she has filed the present application seeking amendment of the plaintiff. If the said amendment is not allowed, it would cause a lot of prejudice to the plaintiff. These aspects were not appreciated by the court. Mere delay in filing the amendment itself cannot be a ground for the court to reject the application. It is submitted that if the amendment is allowed, they would cooperate with the suit and with the trial. They cooperate with the case, and within a time-bound manner, the matter can be decided. Next one. When counsel appearing for the respondent submits that the matter is posted for judgment. It is submitted that in the light of the judgment of the division bench of this court, which is later reformed by the full bench in so and so, once a matter is posted for judgment, question of deciding any other application would not arise.
On submission. Sorry to, my lord, this matter, after the application order has been passed, then it was posted because the order copy was not, only after give a direction from this court.
And it is submitted that the application that is filed is belated application. There is no due diligence, and the court has rightly dismissed the application. There are no grounds to interfere. When counsel appearing for the respondent submits that after the order is passed, the order is not made available to the petitioner, then he has to come before the court and seek an order from this court later, and in the meantime the matter is posted for judgment. Hence such judgment would not apply to the facts and circumstances of this case. Expert, having heard the counsels on either side, files of material on record. The suit is one for specific performance filed in the year 2009. The husband was contesting the matter, and according to the petition, the husband has died recently. Now, by virtue of this amendment, the petitioner is taking a stand, wants to place on record what has transpired in the year 1996. After the amendment to the CPC, after the trial has commenced, if the petitioner wants to file, any party wants to amend the pleadings, it has to be pleaded and prove that in spite of due diligence, they could not bring these facts to the notice of the court at an appropriate time. Looking at the fact that the evidence is already completed, and now the petitioner is trying to take an inconsistent turn from the earlier pleadings, it's not permissible, and it would, as rightly observed by the court, it would cause a lot of hardship to the prejudice to the defendant. In that view of the matter, this court do not find any reasons to interfere. Accordingly, dismissed.
Cell number 29. Venugopal MS for petitioner.
Petitioner, yes. Plaintiff's writ petition is, the suit is for declaration of title, possession, and mandatory injunction and other consequential reliefs.
Have you served the papers on the caveator?
Yes, my lords, it is filed. The defendant number 3 and 4, who are respondent 3 and 4, files an application under section 151, seeking permission of the court to proceed with the construction. That is allowed by the trial court by the impugned order.
What is the suit for?
Suit is for declaration of title, possession, and mandatory injunction for demolition of the illegal construction that is put up, and other consequential relief seeking the documents as not binding.
Now, the defendant wants to proceed with the construction that he will not claim the equities.
Please, my lord.
He will
Now,
not claim the equities.
the order is that, my lords, he has to file the bond, my lords, therefore.
So, no, in matters of this nature, if he is in possession of the property, and now eventually if this suit is decided after 20 years, if he has to make a construction then, no, he will not create any third party rights. He will make the construction and he will not claim equities. If you succeed, you will get the building also.
My lords, suit is pending since from 2014. My lords, initially the injunction order was passed on 10 to 2014.
Let's see the order. Come to
Please,
the order. Let's see.
The impugned order is at page, my lords, 72. Reasoning portion is at 75.
Let's read.
May I read, my lords? Record reveals that it appears on the face of the record that plaintiff has filed a suit for declaration, possession, and also she obtained ex parte TA wide order dated 10 to 2014. It is also an admitted fact that D3 and D4 are alleged purchasers of the suit schedule property. Claims of both parties required full-fledged trial. It is also on record that plaintiff has filed miscellaneous 617 of 14 seeking action for alleged disobedience of the interim TI. And when the case is posted for cross-examination of PW2, PW3, D3 and D4 have come up with this application. Therefore, there is considerable delay in filing the present application. However, though the photos of the suit schedule property, which are not in dispute, do not reflect any dwelling in the said construction, prima facie it reveals that because of the stop of construction, the construction work is stopped at the lintel level of the first floor. And from the photos, prima facie it.
The petitioner submits that in a suit of 2014, where the injunction is granted, the defendants have sought permission for making construction. And in fact, earlier a contempt petition is also moved by the petitioner, but still the court has permitted the same without any basis. The caveat is filed on behalf of the
3 and 4.
3 and 4. The name of the counsel is printed in the list, no representation for the counsel. Hence, there shall be stay of all further proceedings. Only the operation of the
Only
order
impugned
dated,
order.
operation of the order dated so and so is state next.
Notice to R1, R2, R5 to 8 may be dispensed with because
All other
application
respondents.
is filed by R3 and 4.
Memo is filed second dispensation of
I'll file.
notice to
R1 and 2, R5 to 8.
R1 and 2, 5 to 8.
Please.
So no notices are required now in the light of this caveat.
No notice is required.
Yes, dispense with. Yes, next.
Number 30. Then what?
Yes.
Respond number 1 in this case. I raise for short accommodation.
Hmm?
I raise for short accommodation to file objection and address chairman.
No, because.
My lord, in the connected matter has, in the lower court, it has already been stayed, proceedings have been stayed. And this is also exactly similar matter, but.
No, anyhow, suit proceedings are stayed.
Yes, ma'am.
If we adjourn it, no harm to you.
No harm.
This is matter on 19th of August at the request of Land Counsel for the respondent. Yes, next.
Cell number 31. K. Vijay Kumar.
Respondent. Defendant's petition, my lord.
Yes.
Defendants preferred an application before the land trial court seeking permission to file the written statement. 1 year delay, my lord.
How much delay?
1 year delay.
Only 1 year.
Is a age.
What is it? It's a commercial suit or a?
Declaration, not commercial suit, my lord. Declaration suit between the
Land Counsel
family
for
members.
the petitioner submits that.
On submission, my lord. The
Oh,
delay
you're
is-
here. Yes.
Delay is a deliberate delay because they have participating in the proceedings, but intentionally
Of the
avoid.
year 2024.
Yes.
When were the summons served on you?
By page number 21, I have detailed objection was.
Page number?
Page number 21. This is my objection to their application.
Hmm.
So 25/11/24 is
One
suit
to
was
reported
filed.
the duty service of cause defendants and their advocate. So 1/2/2025 they appeared.
It was served. Then 3/4/2025, the defendants appear and sought time to return statement. Then 20th/6/2025, the honorable court is passed, the WS not taken. 4825, defendant's counsel was present. The plaintiff's counsel filed affidavit evidence and got marked on 6/9/2025.
What is the suit for?
Suit for declaration among the
and-
family members. Younger son filed case against father, mother and brother.
Not filed the written statement all
My
these
lord,
years.
one more connected matter was also filed by the father of this plaintiff, my lord. That was pending. This aged father, my lord, suffering from old age ailments, my lord, he is admitted in the hospital. We have produced the records also. Now, my lord, they have proposed for settlement also in that another case. Now, son is claiming that because of my loan, I have constructed the house, you should vacate the house.
No, forget about all the merits of the matter. What is the delay for this? Where is that IA?
So in their application, nothing has been stated.
Where is that?
My lord, my IA is at page 18, my lord. Annexure B.
What did you say?
At paragraph 3 at page 19 is the supporting affidavit, my lord.
What is your age? 71
72
years.
He has to be explained the delay within the.
He says that
90
he
days.
is
No,
suffering with.
my submission is only one defendant. What about other two defendants? They are son and wife. They are still, moreover, they are participating in the proceedings. When the matter was posted for argument, after heard my argument, they are
When was the evidence there? Evidence is over.
Evidence is over.
When?
When 6/9/2025 itself is over. And 6/11/2025, I made an application for production of document. That application was opposed by the defendant side, and also made an application for adjournment. So in this way, they are well participating in the proceedings. What was the impediment to file their written statement? They have not been stated anything. So this attitude is not purpose. So in this regard, I have placed the judgment is of the Honorable Court and also Supreme Court matter.
The aged
Not
person
at the
is,
time
my lord,
of,
he is
when the
taking,
matter is posted for arguments.
my lord,
We will not allow it.
my lord, please, my lord, he is suffering from old age ailments, my lord. He is a diabetic
Your other
patient.
family is contesting.
My lord, he is,
Your other family members are contesting.
my lord, he is a senior member. He is taking care
Doesn't
of the case.
matter.
My lord, his
Your
wife
son
is,
is contesting. Your your case will be dealt with. We will not allow. Open it now. Please come.
please, my lord.
Take the judgment. Agreed with the orders passed on item number 2.
I am also placing a judgment, my lord. Kindly consider my nominal cost may be imposed, my lord. Please, my lord.
Filed by the, you take that, filed by the defendant under section 151
Supreme Court
CPC,
decision, my lord, sir.
dated 4/4/2026, dated by the Principal Senior Civil Judge, Bangalore Rural. The defendant is before this court. The respondent herein has filed a suit for declaration. And when the matter is posted for arguments, at that point of time, the defendant has come up with an application to recall the order dated 26/2025 and permit the defendants to file their written statement. The court by order impugned had dismissed the same. While dismissing the application, the court has observed that the suit summons was served on 1/2/2025. The defendants entered appearance. However, the defendants failed to file their written statement within the period prescribed. As such, taking the written statement as not filed, the court proceeded further, and when the matter was posted for argument, the defendants have come up with the present application on 23/2/2026. And the court has felt that the written statement filed after the outer limit of 120 days from the date of service of summons shall not be entertained by the court, and such defendant shall forfeit the right to file the written statement.
One submission on order sheet, my lord. 26/3/2026 order sheet may be looked into. On
What
that
is
day,
that?
both the parties are absent, my lord. Court sumo to taken it as heard and posted for the orders, my lord. No matter was heard, not heard by.
I have submitted my argument.
This order sheet may be looked into, my lord.
Not required.
13/7/2026, I heard.
26/3/2026.
Have considered the delay in filing the application and ought to have taken the written statement on record. He relied on the judgment of the apex court in Deshras versus Balakishan D. through proposed LR, Ms. Rohini, arising out of SLP civil number 6217 of 2000, civil appeal number 433 of 2020. He relied on paragraph number order para 18 and 20. The court, having discussed the law, had till 22, has taken a lenient view, directed the written statement to be filed with the appellant on 2/11/2017, within 1 week from the from the day, and further subjected to payment of costs rupees 25,000 to the response. Then counsel relying on this judgment submits that a lenient view may be taken. Then counsel appearing for the respondent submits that respondent has drawn the attention of this court to the affidavit which does not contain any reason. He submits that the other children, the children of this defendant are contesting the matter, and knowing fully well about the same, and the matter is posted for argument, the defendant has come up with this application only to delay the proceedings. He relied on the judgment of this court, a coordinate bench of this court, in Ashok Murthy and others versus Srimati Muniyamma, reported in AR Online 2020 Karnataka. He relied on paragraph number 10 and 11 extract. And also, he relied on a judgment of the Apex Court in case of Adcom Technologies Limited versus YA Chunabala and Company and others, reported in 2018, 6 SCC 639. He relied on paragraph number 22.
Judgment relied on by the plaintiff millers is applies to commercial suit millers. I undertake to participate in each and every data pairing in millers.
With judgment?
The judgment relied on by the counterpart.
No, it is not commercial code.
Adcom Technologies Limited.
It was
with
discussed.
respect to commercial.
The parameter is different. That is.
Adcom Technologies Limited millers.
He has relied on the judgment of this court also. Relying on these judgments, then counsel with the respondent submits that the court ought not to have condoned the court has rightly not taken the written statement on record. Next part. Having other counsels on either side, there is a material on record. This is a suit for declaration. The defendants are the father and the children. It is an admitted fact that the children have already filed their written statement and they are contesting the matter. The father now, after the matter is posted for argument, wants to contest the matter. This court has perused the affidavit. Affidavit does not contain any reasons. And here the interesting aspect is when other family members are contesting, why the defendant was not contesting. Now his interest is also taken care of by the other family members, and why he wants to has come up now when the matter is posted for arguments for filing the written statement. On the face of it, it appears that only to drag on the proceedings, the present application is filed. The petitioner wants to file the written statement, while taking the written statement on record, court has to consider what is the reason for the said delay and the facts and circumstances of the case. In this case, considering the fact that already the other defendants are on record, and this petition defendant has failed to make out a reasonable cause for filing the written statement, and in the considered opinion of the court, the trial court has rightly considered in past orders, and this court finds no reasons to interfere. Accordingly dismissed.
Cell number 32, A.G. Sridhar, for petitioner, Agaya for petitioner.
For petitioner in this case, amendment application filed by the plaintiff came to be rejected by the trial court. Order of 6 rule
Suit
7.
is of which year?
Please, madam.
Suit is of which?
Of the year 2024.
What is the suit for?
Suit for declaration and partition.
What is amendment?
Amendment, what I sought for, the thing is, my lord, one Nagaraju and M. Lakshmi Nagaraju executed.
And what is the stage of the proceedings?
To hearing on a year and also for evidence.
What?
For evidence.
Come to the impugned order straight away.
Yes, madam. My lord, before impugned order, what I sought for in IA, minimum 14 places in the impugned order, the court has misread. Instead of in the place of the will, it has mentioned as cancellation of the will dated. In the place of cancellation of the will dated, it has mentioned as will. 14 cases there are error in the impugned order. So I take your lordship to what the amendment I sought for before this order. IA. May I read my IA? What I sought for. Page number 65, Mala. Relevant portion. Page number 66. May I read?
Yes.
Before that, just 2 lines.
What is 63?
Well, only 2 this. M. Nagaraju and Lakshmi Nagaraju, that the first defendant were the absolute owner of the property.
Please come to your affidavit. All those lengthy arguments will
okay,
not hear.
Yes, ma'am.
Come to the
After,
IA.
yes, proposed amendment.
Yes, come to the affidavit. We'll
Page
read
number
the affidavit.
66.
Affidavit in support of the IA. We'll
Yes,
read
ma'am.
it. Para number 3.
No. Here, my lord, in IA, when they have proposed amendment, I have stated here.
That
What
time
I want to amend, I have mentioned here, my lord. Then after,
I will see.
Yes, ma'am.
We have to know what is the affidavit. When
Yes,
we
madam.
look at the affidavit.
Yes, madam. I submit that I am the plaintiff number 4 in the above plaint, and I am fully conversant with the fact of the case. I submit the amendment made in the plaint may be read as part and parcel of this affidavit. And para number 3, I submit that we have filed a above suit for the relief of partition and other relief against the defendants. One M. Nagaraju and the first defendant were the owners of the associated property. They had no issues. Hence, our father, that's another plaintiff father, was taking care of them as a foster son. The said M. Nagaraju and the first defendant executed registered will dated 16/1/1997 in respect of the scheduled property in favor of our father by name Narayanappa. This M. Narayanappa, the said M. Nagaraju and the first testator passed away on 13/6/2001, and our father, that is the husband of the first plaintiff, also passed away in year 2024, leaving behind us as his legal age. I submit that the entire scheduled property was being taken care of our father, and after his death, we are in possession and enjoyment of the scheduled property, and we have let out the portion of the scheduled property of the tenant. I submit that the defendant number 2 to 4, who canvassed themselves as far relatives of the first defendant and took her to their house for short period, I submit that by brainwashing the aged illiterate first defendant, the defendant number 2 to 4 illegally made the first defendant to cancel the registered will.
Yes.
It was executed in favor of the father of the white deed.
Yes, 1 minute.
Yes.
Please.
No, why it is
declaration.
What is the difficulty in allowing this?
No, because amendment cannot be sought by in this way, because kindly see the paragraph number 10 of the plaint which they have filed.
No, what
Plaint
is the
and-
reasoning given by the court?
Same.
Court has gone into
No,
the,
it is already there in the plaint.
court has gone into the merits of the matter. On the order, sir, or when an application
The
is filed
amend-
seeking,
please,
please
madam.
listen, order 6 rule 17, when an application is filed, whether, no, it is a
Can
pre-trial
be.
amendment.
Your lordship, it can
It's
be.
pre-trial amendment.
Right.
Number 2, whatever is the amendment, now you will get an opportunity to file your additional written
Please,
statement. Why should the court go into the merits of the matter
Court said
and
kindly see,
decide that
kindly
is for
see the-
him, that
kindly
is for
see the-
him to seek?
kindly see the impugned order of the court, page number 21.
Yes.
The paragraph number 2, the amendment can be permitted only when it is necessary for determining real question in controversy between the parties. In the present case, the controversy regarding the validity and the legal effect of the will already arises from the existing pleading. A perusal of paragraph 10 of the plaint shows that
the plaintiff has specifically questioned the will and have laid the necessary foundation to challenge the legality. Thus, the essential pleadings are already there on record. Now, I take this Honorable Court to para number 10 of the plaint. Para number 10 of the plaint at page number 29. The plaintiff further submits that the very recently plaintiff came to know that at the ill advice of the defendant number 2 to 4, the defendant number 1 has cancelled the earlier registered will dated 16/1/1997 executed by her and her husband by name Nagaraju by executing the cancellation of the will dated 18/10/2024. It is already there. So therefore, seeking the similar amendment in this application is of no consequence.
Please come. The petitioner, plaintiff is before this court, agreed with the order passed on I number 4 in OS number 8947 of 2024 dated 7/7/2026 by the City Civil and Session Judge. The petitioner herein has filed the suit declaration and injunction against the respondents. Suit for declaration and injunction.
Yes, ma'am.
In the said suit, the present application is filed seeking amendment of the plaint. By way of this amendment, the plaintiff wants to
Add one paragraph and
add
one
para number 10,
10A and prayer.
para number 10A, and also
Prayer.
a prayer that the cancellation of the will dated 18/10/2024 registered as document number registered as document on 9/10/2024 at the office of the sub-registrar Shivaji Nagara, Bidderhalli, Bangalore is illegal void document, and the same is not binding on the plaintiff in the interest of justice and equity. That came to be dismissed by the trial court on the ground that the main contention sought to be introduced that the defendant number 1 had no exclusive authority to cancel a bill allegedly executed jointly by him herself and by late M. Nagaraju, and the cancellation has no legal effect. Whether defendant number 1 possesses such authority and what would be the legal consequences of the alleged cancellation or questions which fall for consideration on the basis of the evidence adduced and the applicable principles of law. These issues do not require any further amendment. Then the court considers that the legal position with regard to the amendment. The court observes that the essential pleadings are already on record. The proposed amendment neither introduces any material fact that is absent from the plaint nor enables the court to adjudicate any issue which cannot otherwise be decided on the basis of the existing pleadings and evidence. On the contrary, permitting the amendment would merely enlarge the pleading and is likely to delay the disposal of the suit without advancing the real controversy between the parties. Agreed thereby, the plaintiff is before this court. Then counsel for the petitioner submits that he has set up a pleading supported by and also a continuation of that. He has also sought for a amendment of prayer while an application is filed under Order 6/17, which is not a belated application. The court has to allow the same liberally. Further, the court has failed to consider what is the prejudice to the defendant, and without any findings on that, and just like that, going into the merits of the matter, whether the Order 6/17 is required or not, what are the merits of the amendment, the court cannot dismiss the application. Next, when counsel appearing for the respondent submits that the court has rightly observed that already the pleadings are there in the plaint, and this is not required. It is submitted that this is nothing but to delay the proceedings, and the court has rightly considered and passed the order, and no interference is called for. Next paragraph. Having heard the land counsels on either side peruse the material on record. After the amendment to Order 6/17, the post-trial amendment is required. Any amendment application is filed. The applicant has to plead that in spite of due diligence, these facts cannot be brought to the notice of the court. When it comes to the pre-trial amendments are concerned, the court would have a liberal approach. The suit is of the year 2024. While allowing an application seeking amendment of the pleadings, the court would be looking at whether by way of this amendment, whether the party is trying to cover up the latches or trying to take away an admission already made, or it will cause prejudice to the defendant. This amendment that is sought by the petitioner does not cause any prejudice to the defendant for the reason the defendant can come up with, can always file an additional written statement when this amendment is allowed. In the considered opinion of the court has gone on a hyper-technical approach, which is not permissible, and dismissed the application. Hence, the order impugned dated so-and-so is set aside, and the application filed by the IA number, consequently, I number, what is this IA? 4. I number 4 is allowed.
Cell number 33. Ganapati but for petitioner, Abhishek MK.
Who moved the memo?
But what happens is they have taken an interim order in February. Every time there is request for adjournment, not all proceedings are stayed in the trial court.
Where is that order sheet? This is the one. When is the interim order granted?
February month.
In which matter?
In
33.1, my lord.
4314.
Give the next order sheet.
4314. I think it's
Issue notice to the respondent. All further proceedings are stayed. Password.
Cell number 34. Nagbhushan R.
The plaintiff before the trial court, my lord. I am the plaintiff before the trial court. I have filed the suit for easement right and permanent injunction against the defendants. I have filed IA 1 and 2 for the.
I have filed Wakalat today in morning, my lord. They have not served a copy on
Lord,
it.
I have served the copy with the hand summons, my lord. It has
Oh, my
been
lord.
written in the hand summons.
Oh,
You have served, my lord. Just to prolong the matter, they are submitting it.
I need to file my application.
No objections are recorded in writ petition.
I have not been served. Today
Lord,
itself
I
I
have
have
served,
served. I filed Wakalat. I undertook to file Wakalat.
Lord, there is some urgency, my lord, in this matter.
What is
They are
urgency?
interfering with my property.
Two courts have concurrently held against you. And there is urgency tomorrow, today itself. This is matter on Tuesday in the first list. And don't ask for adjournments again.
Copy.
So the papers.
Yes, please.
Cell number 35 adjourned. Cell number 36. Deepa J.
And for the respondent, my lord, I have not received a copy. They have not served a copy.
Lord,
There is
serving copy,
Office
my
objection regarding, now they are serving there.
Yes, this is matter on Tuesday.
My lords, the connected matter is there, my lords. We have filed one more matter, my lords. It's a deputy.
List along with so-and-so.
Yes, my lords.
Give the number.
There is also, we filed a caveat. They are not served a copy.
Serve that also.
We'll serve, my lords.
Cell on Tuesday.
Tuesday.
Cell number 37. Anjana. CM for petitioner. HV Praveen Kouda for respondent.
My application was for.
We have engaged the senior counsel. We have engaged the senior counsel. Any convenient date may be given. Matter was listed on 28th. This
20th before the trial court.
This month.
Before the trial court.
No, your lordship. We have in this.
It had come up before your lordships, my learned friend took time. Lordships
No,
adjourned it.
Lordship, the
Again it is, we have moved. But it's a very short.
Okay, and hear it. You can come whenever you want.
Please. But now,
The short point is this one. My application for execution of the arbitral award, which is in compromise, is before the trial court. The impugned order, lordships will get it at page 13.
Page?
13. This is an application filed by the judgment debtor for recall of an earlier order dated 22/1/2026, which has been recalled by the trial court.
Even this arbitration matters also execution of the year 2020.
Yes, Lord. In fact, the arbitral award itself is based on a compromise memo. But I am the owner of the property. There was a joint development agreement. They failed to do so. I initiated arbitration proceedings. It was agreed between us before the arbitrator. They'll complete the process of construction within about 24 months. If they do not do so, the JDA stands dissolved. They have to return our original document. This is all the agreement. They did not do so, admittedly, after 24 months. Well, I have initiated now proceedings for return of the original title deeds. That is the execution. Now, but multiple proceedings took place. Now, ultimately, it boils down to this.
What is this order passed under
Now,
47?
that is earlier 22nd January 2026 order has been recalled. That order, lordships will get it at page 270, at page 100 and or page 65. Correct, page 65. IA number 5, order on IA number 5. Order on IA number 5, the earlier order, 22nd commences from 113.
The JDR under 47 is here.
No, 113. Lordships may kindly see 113. The operative, it's a lengthy order. I will not trouble your lordships to go through the whole thing, but kindly see the operative portion at 190. Or 94, in fact.
Yes.
Where is the operative portion? 194. 279, my lord. In fact, it is at 279.
What is this order?
A number 5 operative portion will be there.
No, such a lengthy order.
Yes, no, it's a very lengthy operative portion. But kindly see page 197. This portion I'll read. Therefore, initially, Honorable High Court of Karnataka, Bangalore in WP number so and so has directed this court to conduct the inquiry and then to pass an order on the said EP subsequently. Later on, JDR has preferred another WP dated 8/7/2025 against the DHR herein. The Honorable High Court of Karnataka has passed an order observing in detail regarding the maintainability of the execution petition and also regarding the abuse of the process of law taken by JDR against DHR, and the said WP was dismissed by the Honorable High Court of Karnataka by imposing a cost of 1 lakh. Therefore, by relying on the observation of the Honorable High Court of Karnataka and WP so and so, the IA filed by JDR for inquiry under 151 so and so is hereby rejected. Therefore, I answer this point. So, their request for an inquiry has been rejected by the trial court by this order. This is now again recalled by the trial court by the impugned order before your lordships. But that is because there was an earlier order by His Lordship Justice Devdas wherein not an apart.
See, what is the basis for passing this order by the court?
22nd of January 2000. This order.
This order. What
Yes,
is the basis?
This order is based on an earlier order passed by this honorable court.
8353.
Please, I'll just point out this order of this honorable court. 375/7. Kindly see page 377. Now, in 377, kindly see paragraph 7 at page 382. In that view of the matter, this court is of the considered opinion that in the interest of justice, it would be required that the petitioner should deposit the original title deeds before the executing court and the original document shall remain in the custody of the court till an inquiry is held and orders are passed by the executing court subsequently. But I'll explain.
So by this order, the court has directed them to deposit the title deeds with the court.
With the court, which
Yes.
they did, ultimately, which they did. Then there is a passing observation that you hold an inquiry and then pass subsequent, you pass final orders, that second sentence. Till an inquiry is held. That
The
word.
original document shall remain in the custody of the court till an inquiry is held.
Now,
And
my
orders
lords,
passed by the court.
they sought for an inquiry to be held, which the trial court, my lord, according to me, rejected it, saying that, no, I can't hold an inquiry because there is one more writ petition they had filed, which was dismissed with costs, etc. Now, my lord, they filed recalling of that order based on the order, observations of the
So let us,
Please.
no, this is the order. Thereafter, they have deposited the
original
deeds.
title deeds.
Then what happened there?
Then they filed IA number, my lord, 5 for holding an inquiry. That came to be rejected.
What inquiry to be?
That is the question. No, that is, our contention is there cannot be any further inquiry.
No. Now the court has dismissed that only on the ground that the High Court has observed and so and so.
This observation.
What, that's what I'm asking. What is the connection between this and that the dismissal of their inquiry application?
No, they say, I'll explain. But after this order was passed, they deposited the title deeds.
Yes.
And they filed an application to hold an inquiry in the matter.
What is the
Now,
nature of the?
yes, without specifying what is the nature of the inquiry. In fact, our contention is the question of inquiry doesn't arise in a execution proceedings under section 47. You have to, now that you have not executed the project, you have to simply return the title. It is the scope of the inquiry. All that the trial court is required to do is only examine this aspect. What the trial court initially did was not that application for holding an inquiry was rejected. I can't hold any inquiry. We will proceed further in the matter. Then they sought recall of that order, stating that it is this honorable court, the honorable High Court has held that an inquiry should be held, but you have rejected our application incorrectly. It is contrary to the order of the honorable. Now the trial court says, since the honorable High Court has directed me to consider hold an inquiry, my earlier order recalling is rejecting is recalled. Now I will hold an inquiry. That is called into question.
Oh, why this is made so complicated?
I'm sorry.
Why this is made so complicated?
It has been made complicated, but I have now a solution for this, not which I would propose, subject to what my learned friend will say. But we are ready for an inquiry. That compromise memo says they must, as I said, they must do it. If they don't do it, we have the scope of inquiry. Has,
Section 47 is filed by.
we have filed.
What is the application under section 47?
Formulates deposit of title deeds.
Let's see.
Yes, kindly see the award itself. Award is at page 315. But the learned arbitrator records the memorandum of compromise commencing from page 315. But I will show before your lordships what could be the relevant. 327, 26 lordships may kindly see. 326.
Yes, 326.
The parties agree and confirm that in case of failure of completion of the task as per Annexure C for a continuous period of 8 weeks, as per the timelines decided, it shall be open for the claimant to notify that the compromise entered into between the parties to this joint development agreement dated 26/2013 and memorandum of understanding dated 24/6/2013 and GPA be registered as per the compromise petition are cancelled. Consequently, the project implementation would be stand halted on account of cessation of relationship between the parties as owner and developer in respect of the schedule down. The respondent shall return the original documents and the claimant would refund the deposit of 7,50,000. This is, they did not do it 8 weeks. So I said, I want to execute this. You deposit the title deeds. I will refund 7 lakh.
Oh, they must have filed an application for inquiry.
Now they filed an inquiry.
What is that? Let us
No,
see where is
yes,
that
their IA number 5. I'll just IA number 5. Copy of the IA number 5 lordships will kindly get at not include IA number 5. No, you show that Order on IA number 5. But may I request Lordships to, that IA is not before your Lordship, but I'll just show the order
What is
itself.
there at 94?
94. Application notes is to,
That is your application.
this is their application.
Yes.
But what they say is, if
This
Lordships
is,
are to,
when is this filed? 3/2/2025.
correct.
When is the order of this court? Just now you read that Justice Devdas order.
Justice Devdas order is 30th of July 2024, subsequent.
Yes, 30th July 2024.
Yes.
Now, according to them, what is to be done? What are
But they say inquiry means not they want to go back before not kindly see not para, for instance, not they say para 3, page 95. I further submitted the decree holder has filed above petition claiming that we have not complied with the terms and conditions of the above compromise within time. Our specific case was that we are not able to complete the project within the stipulated mentioned in the compromise in view of natural calamities in and around Kodagu district. In view of the government order to stop conversion of any agricultural land to non-agricultural nature. However, it is very much necessary to bring to the notice of this honorable. The government has made efforts by corresponding to the, but I'll just stop it. But therefore, they want to go back the compromise.
According to them, for various reasons, they
That,
could not
that
complete,
cannot be the scope, is my
they could
submission.
not complete it.
Yeah, they
so
could
all
not.
that facts they want to place on record.
Therefore, they say the award cannot be
Conduct inquiry
executed
on
at all.
that.
It doesn't become enforceable. Now, that is going behind the award, because the award simply says you either complete within 8 weeks or it stands dissolved.
Then
There's
on
no force
this
majeure
IA
clause, etc.
On this IA number 5,
Yes, ma'am.
when was the order passed?
Initially, the trial judge rejected it on 22nd January 2026.
22nd January
Correct. It was rejected.
2026.
26. Now, this order was sought to be recalled by A number 7, which has now been allowed.
That is dated?
22nd, the present order, 30th of April 2026.
What the court says now?
Now, this is what we have called into question now.
What it says?
No, she recalls that earlier order of rejecting and says, now I'm going to hold an inquiry. But my submission, therefore, is this one. Now, what is the scope of inquiry? Something which Lordships may direct them to do so. According to us, they now want to conduct it in the manner like Section 47 by leading evidence, by trying to show the nature of the affidavit that we were prevented by other factors in not complying. But that cannot be the scope of an inquiry. The award records the compromise, which says that within 8 weeks, if you do not do so, it stands cancelled. Lordships may observe that the scope of the inquiry will be limited to seeing whether they have completed or not, and it could be disposed of. I don't think we are in any other manner aggrieved by that.
We will file a detailed objection. We will reply on next. Regarding an inquiry only, there is a broad.
This will not cause any prejudice to them, whatever Lordships would say.
Next day.
What next day?
No, Lordship, we have.
No, it's a very simple issue.
Regarding an inquiry, Lordship, there is a misinterpretation.
No, all those can be looked into. What is the award by the arbitrator? It says there are certain responsibilities by you, certain by you. If it is not, what are the consequences flowing from that?
And that time only, Your Lordship, there was a flood.
All those things are not matter of adjudication. That is what is his submission. Let the senior counsel say that will dispose of the matter.
We have made every attempt to complete the thing, but it was due to the.
Well, can that be considered under Section 47 is the question now.
And having regard to the fact of the latest judgment of Supreme Court, Lordships are aware of the limited scope of an enforcement of an arbitral award.
Ask the senior to come. Afternoon. Next.
Number 38. Hemavati Rajaram petitioner.
For the first respondent.
I'm for the petitioner, Your Lordship.
No,
I'm also the defendant number 3 in the in OS number 4000. Lordship, this suit was filed by the plaintiff in the year 2014, seeking for declaration and to set aside a gift deed.
Yes.
which was,
may I-
which was based on,
May I interrupt for a moment, sister? I filed no objection, wakalat yesterday. I filed my wakalat yesterday, my lord.
Hmm.
My name is not shown. My request is not to be taken the shortest possible Monday or
So and so submits that he has filed the no objection wakalat.
Yes, sir.
my
Registry
lord,
is directed to.
my submissions may be taken on record. Your
Register,
Lordship.
the registry is directed to reflect the name of the council. This is matter tomorrow in the first list.
Grateful,
Yes.
Your Lordship.
Cell number 39, Devi Prasad Shetty.
No rep, yes. Papers are served on you? Papers are served?
No, no, my lord.
Yes.
Through mail I have served on 31st. Yesterday I have served the hard copy. Not one Chikkamadeppa, my lord, he had two wives.
No. Before going into the history of the case, what is the suit for?
Not suit for declaration that the plaintiffs are the absolute owner of the suit
It's
schedule.
the IA.
Suit schedule. Not IA, not I filed an IA under order 11 rule 14 to produce the not to mark to produce and mark the relinquishment deed executed by the son of one of the wife, not the first wife, in favor of the plaintiff Mangamma. Not now the trial court has dismissed the IA.
Let's go to that one.
On the ground that not earlier while marking, not it was rejected at the time of marking. Not kindly see at page 56, my lord. Now, because my entire case is on the basis of relinquishment, unregistered relinquishment date.
No, you want to mark the document.
Yes, ma'am, that unregistered. My lord, even if it is impounded, my lord, I am ready to pay the penalty also.
4, come to paragraph number 4.
As stated supra, the present application is being filed under order 11 rule 14 of the CPC seeking permission to mark the unregistered relinquishment deed dated 25/1/1981 in favor of the applicant executed by the defendant number 1 in favor of Mangamma, the plaintiff, for collateral purpose. It is pertinent to mention that order 11 rule 14 of the code of civil procedure meant for production of document, which document mentioned in the application has already been produced by the deponent himself by filing an application on order 8 rule 1A of the CPC. During the course of the marking the said document, the plaintiff number 6 and 7 has raised objection with regard to the marking of the said document, as the said document is a compulsory registrable document under section 17.
No, earlier when the court refused, you didn't raise an objection. You didn't question it.
That particular time, Lord, I did not
Not
question.
that particular time.
I did not
With
question.
regard to the document, that is the stage.
I did not question.
You lost that stage.
But I did not
Now, how can you ask it now? When a document which this court specifically said that
Lord,
you will not
yes, my
mark
Lord,
the
I
document.
do admit that.
Then
It was-
how can you get a
Lord, it
relief
was
now?
not the, even for the sake of collateral purpose, at least, my Lord, it could be
No, whatever purpose, the court rejected it earlier. You have to question that order.
rejected, not by, IA was not filed. While marking, it was rejected. It was,
That you have to question it. That order has to be questioned. We can't reopen everything just like that. And in the light of the earlier order, no, the court cannot do anything.
my Lord, the entire case depends on the
But you,
relinquishment date.
unfortunately,
where
you did not take any steps.
Defendant number 3,
When was that order?
18/10/2025.
because the entire Lord, this scheduled property, my Lord, they had relinquished in favor of the plaintiff. Not I am, I'm ready to even deposit the.
No, we
No, I understand.
Court
sir,
can only
not-
do something which is permissible. I
Yes.
can't do anything, not a supervisory jurisdiction, not Superman jurisdiction.
There are judgments where it says, even if it is,
No.
I know, Lord, I understand that I had
Can't
not.
be. You question it, it's for the court to consider it or not. That whatever earlier order, if you want to question it, you question it. And you can impress upon the court saying that that is very much crucial. The court might consider in facts of the case, but not in this application. Please come. The petition is before this court agreed with an order passed on IA number 28/5 filed under Order 9, Rule 14 of the CPC, dated 16/6/2026, whereby the court has rejected the application with cost of rupees 500. The petitioner herein, who is the defendant number 3, wants to mark the unregistered relinquishment deed 25/1981 for the collateral purpose. The respondent plaintiffs have filed objections to the application by denying all the amendments of the affidavit. And also, the matter is posted for the final argument. At that stage, the present application is filed and the same cannot be considered. The trial court has observed that the present application filed under Order 11, Rule 14 of the CPC, seeking permission to mark the unregistered relinquishment deed dated 25/1981 in favor of the applicant, executed by defendant number 1, in favor of Mangama, the plaintiff, for collateral purpose. The court has observed that the said document is a compulsory registrable document under Section 17 of the Indian Registration Act. Noting the same, the court did not permit the deponent to mark the said document. Thereafter, the deponent has fully cross-examined the plaintiff number 6 and 7. The deponent on 18/10/2025 tried to get the said document marked, but the same came to be refused as it is an unregistered document. Though the document is not registered and cannot be marked in evidence, only with an intention to procrastinate the proceeding, the present application is being filed. Hence, the application deserves to be dismissed with exemplary cause and accordingly dismiss the same. And counsel appearing for the petitioner submits that this is the document on which he is relying on. Unless and until this document is marked, at least for the collateral purpose, it would cause a lot of hardship to the plaintiff, and this aspect was not considered by the court. And no prejudice would be caused to the respondent if this document is marked, as the burden lies on him to prove the document. When counsel appearing for the respondent plaintiff submits that when the court has refused to mark this document, as it is an unregistered document, way back in the year 2025,
18/10/25.
18/10/2025, the petitioner has not questioned the said order. That order has become final. Thereafter, the matter was proceeded, and now the matter is posted for the final arguments. At that stage, the present application is filed. Hence, the court has rightly considered and passed orders. No interference is called for. Next, having other counsels on either side. Peruse the material on record. The petitioner wants a particular document to be marked. In that regard, earlier, an exercise was done. Court has rejected the said request. If the petitioner is agreed with the same, he would have questioned the said order. But in this case, the petitioner has not taken any steps and he has proceeded with the matter. And when the matter is posted for the final arguments, again has reiterated the very same request, saying that the document can be marked for collateral purpose. The court has rightly considered and dismissed the application. And this court finds no reasons to interfere accordingly.
May I make one submission, my lords? May be permitted to file a wakalat in the council.
Petition is that the counsel for the respondent is permitted to file the wakalat in this section.
One submission, Your Lordship. See, list number 143, the judgment and decree passed in OIC stayed yesterday in RFA, Your Lordship. That may be actually, I produced a copy, Your Lordship. List number 1, serial number 43, the judgment and decree passed in OIC stayed yesterday in RFA case before division bench. I will produce that order copy, Your Lordship.
Want adjournment?
Yes, please.
Respondent is served.
is well aware of the fact. Yesterday he appeared caveat in RFA.
Matter listed in the month of September.
Please,
Lord,
Lord.
serial number.
Submission, my lord.
My lord, serial number 30, my lord.
Plot one. Okay. 230, my lord. End of the day. 43. Serial number 43.
This 143.
Yeah, month of ಆಗಿದೆ. End of the day. 43 ಅಲ್ವಾ sir?
This one.
ಅಲ್ಲ 230 ಗೂ ತಗೊಳ್ಳಲ್ಲ.
These two, why madam? ಅರ್ಜುನಾಗೆ ನೋಡಿ.
230 ತಗೊಳ್ಳಲ್ವಾ?
ಹೇಳಿ ಸರ್.
These two, serial number 5.
ಅರ್ಜೆಂಟ್ ಯಾವುದು ಅರ್ಜೆಂಟ್ ಮಾಡಿಲ್ಲ ಸರ್.
These two
ಇಟ್ ಈಸ್ ದೇರ್. ಸರ್ ಮೇಡಮ್ ಬರ್ಬೇಕು ಪಾಸ್ ಅವರ್ಸ್ ಇದೆ ಯಾವ್ದನ್ನ ಕರೀರಿ ಅಂತ ಅದು ಕರೀರಿ.
Madam,
Lords, one
Lordships
submission.
kindly. I'm not seeking for an adjournment, my lord, because your lordship has made it very clear. In respect of that writ of at serial number 98, my lord, today morning also I had made a submission. My lord, there were 3 IAs filed by me, and the registry insists that I file 3 separate writ petitions. I will do that, my lord. A
When is 95?
week's time, my lord.
95.
98.
Lord, one submission.
You know that I don't hear any.
Apologies, my lord, apologies. It's only one matter which is already
95.
listed.
98, my lord.
98. Oh.
Weeks.
The office has raised an objection with regard to maintainability as three IAs are questioned in one writ petition. Then counsel for the petitioner seeks time. Office objection will or upheld. The petitioner shall
File
shall
3
take
separate
appropriate steps
Yes, ma'am.
within a
Week's time.
week from today. Yes.
Grateful.
My lord, matter is a part-heard matter. My lord, already listed. I filed for modification, my lord. Serial number 31, list 2. May be taken up at the end of the day, my lord. Great urgency. I filed.
What is the modification?
My lord, I sought for direction to the petitioner to provide the survey report, my lord. This is a part heard by my lords had ordered release of the property. We've in fact initiated the release, my lord, and we've taken the payment made by the petitioner. But we want a specific survey report because there is certain
Who
discrepancy
appears
in
to the respondent?
my lord,
Who appears
for the
to-
petitioner, my lord, Swaroop, my lord,
Have
the
you informed
borrower.
them?
I've informed him, my lord.
End of the list.
Grateful.
My lord, serial number 30, my lord, it was already adjourned to 1998, my lord. Kindly any other date, my lord.
Why?
Some inconvenience, senior year.
September. List on 16th of September.
Serial number
30.
Huh?
30.
30.
Please continue the list.
List number 1 continued. Serial number 40. A.S. Vishwanath, for petitioner.
My lord, 40 and 41 are connected, my lord. They arise out of the same impugned order. The underlying suit.
Have you served the papers on the council?
Yes, my lord, we served. The underlying suit, my lord, is a suit for declaration. But the IA that was being rejected, there were 2 IAs filed, my lord. It was an IA for setting aside the abatement against defendant number 1 and condemnation of delay in setting aside that abatement. There was 317 days delay, my lord.
40 is arresting order.
40, my lord, is the condemnation of delay.
Condemnation.
And 41 is the setting aside of
Which
the
is the
abatement.
delay?
317, my lord.
Who are the you are the
I am the plaintiff, my lord.
what is the suit for?
The suit is for declaration, my lord, seeking that the sale deed in question.
Who died?
Defendant number 1.
Oh.
Now, what has happened here, my lord?
We can look at the order. Come to the
Yes.
order.
The order, my lord, is at page 26. The operative portion, my lord, is at 29. Shall I read the order, my lord?
Yes. Yes.
Before taking into consideration the present application on merits, on careful reading of Order 22, Rule 4, CPC, which reads thus, and the learned trial court quotes the entire order, my lord. By careful reading of the wording as stated in Order 22, Rule 4, CPC, it is crystal clear that when any of the defendants to the suit dies during the pendency of the suit, then the surviving defendants or legal heirs of the deceased defendant shall proceed with the suit. When no application is made under Sub-Rule 1, the suit shall abate as against the deceased defendant. But as per Order 22, Rule 4, Subclause 4, when the court thinks fit, may exempt plaintiff from the necessity of substituting the legal representatives of any such defendant who has failed to file written statement or who, having filed it, has failed to appear and contest the suit at the hearing, and judgment may in such case be pronounced against the said defendant, notwithstanding the death of such defendant, and shall have the same force and effect as if it had been pronounced before death took place. As per Sub-Rule 5, when the plaintiff was ignorant of the death of a defendant and could not, for that reason, make an application for the substitution of the legal representative of the
When the
defendant.
petitioner submits when an application is filed to set aside the abatement and to condone the delay in bringing the LRs on record, the court applying a hyper-technical approach has dismissed both the applications considering the submission of the learned counsel for the petition. There shall be stay of all further proceedings and so and so. In this case, the though caveat is filed and it is submitted that the papers are served, there is no representation on behalf of the caveator. He appears for whom?
Yes. Defendants 3 to 5.
2 and 3. And who are the other notice to?
Sorry, my lord.
Notice has to go to other.
Notice has to go to respond number 2, my lord, who has been absconding in the matter.
He has filed it on behalf of R2 and 3. R2 to 4 in 1.
My lord, respondents who have to be issued notice, my lord, are respondent number 1, respondent number 2, 3.
Who is already filed the caveat?
Caveats, my lord, have been filed by respondent 3 to respondent number 5.
Look at the cause list. It says caveat for R2 to R4.
I apologize, my lord. R2 to R4, my lord.
And another one, it is R2 and 3. How many are the respondents?
My lord, there are totally 6 respondents, my lord, out of which respondent number 5 and 6 are not germane to the issue, my lord.
Then file a memo.
We'll file a memo.
A memo is filed seeking dispensation of notice to respondents 5 and 6. Memo is taken on record and notice to respondents. Notice to the respondents 5 and 6 is dispensed with. In WP number 23354, caveat is filed on behalf of R2 to 4, notice to R1, and then in WP 23532, caveat is filed for R2 and R3, notice to 1, 2, and
2 and 3. For R2 also you filed caveat.
2 and 3, so 1 and 4. Same hand summons, all returnable by, the memo shall be by 25th. Yes.
My lord, can a date be given, my lord, because the matter is before the trial court on the 24th. There's a step.
Yes.
Grateful, ma'am.
Serial number 42, VG Bhanu Prakash.
Here for the petitioner. Let's subsequent on arbitration award, my lords, wherein I was not, I didn't appear in the matter, my lords. Execution filed, my lords. In the execution, an application is filed by the respondent asking for attachment of certain properties. Subsequently, I appear, I indicate before the Honorable Executing Court, out of 7 items of property, 6 have already been sold. Only 1 item is there that could be auctioned off. Spot sale is fixed, my lords, but none of the auction purchasers come forward. And that application is pending, my lords. In the meanwhile, another application is made for seeking for my arrest. That application, in spite of my objections, is now allowed, and I'm before my lords with that impugned order.
Come to the order.
The order, my lord, should find it at Annexure A, page number 20. By way of separate order, my lord, this I could not make it as an annexure. Lords.
Take that.
Page 20, it says by its separate order.
Yes.
Lords, from the first page till page number 11, the facts, or page number 9, my lords. Then the reason starts at page number 9, paragraph number 5. Again, the Honorable Trial
Come to
Court.
para 9.
9, my lords. Section 51 of the CPC allows the decree holder to realize the award by way of attachment and sale, and also by committing the JDR to civil imprisonment under Order 21, Rule 11A of the CPC in the provision governing the execution of a decree or award. However, it mandates that an application seeking the arrest and detention of the JDR in civil prison must be set out the grounds for such relief. In the affidavit filed in support of the IA, so-and-so, a partner of the decree holder company, has stated the facts of the case, the particulars of the award and the amount payable with the JDR to the decree holder. Further, he has explained the undertaking given by the JDR, the violation of such undertaking and the futile attempts made to get the award executed.
Yes. What do you say?
MOU was signed, my lords, in the year 2019.
No, all that correct.
Yes, my lords.
Now for this issuing the arrest warrant, what are the reasons?
My lords, out of 7 properties were attached, my lords, by the arbitrator, my lords. Out of it, my lords, a memo was filed on 13th March 2026, claiming that 6 properties have been sold by him. 6 properties, he has sold the property. My lords, may kindly
Properties are sold by him.
Yes. Sale is produced by him before the arbiter. For a moment.
Yes, my lords, one
The property.
Yes, my lords,
Lords,
one pro-
in item number, my lords, for a moment. In the item number 7 property, my lords, my lords, he claims objector application was filed on his behalf, claiming that, my lords, they have entered an registered agreement, my lords, in favor of one Narayan Swamy. My lords, that is on 15th December 2021. Objector, my lords, after hearing for some time, my lords, the application was rejected with cost. My lords, he claims that this item number 7 property, my lords, it's a joint family property of him and his wife. My lords, six properties have been sold.
What is the amount?
Amount, my lords,
One crore
as on
84.
today, my lords, is 2 crores 10 lakhs, my lords. My lords, my lords, notice was issued. He did not appear. My lords, CMP was filed. He did not appear in the company petition.
Was the award passed?
My lords, award was filed, my lord, in the year 2024, my lords. 25th.
Did he sell all these properties?
My lords, property, my lord, according to him, my lords, property was sold in the year 2015. My lords, award was passed on 25th July 2024. My lords, mail was sent, my lords, on 28th November 2024. My lords, after that, my lords, he responds to the arbitrator claiming that, my lords, he wants some time to put his defense. That was rejected, my lords, award was passed. Thereafter, my lords, execution was filed. He did not file objections. My lords, he came before the court, my lords, he made before the court, my lords, that he will make the payment. He needs some time. Thereafter, my lords, advocate changed. My learned friend appeared, my lords. Thereafter, my lords, we sat in the month of February, my lords. He sought 3 months time. Up to July, we will pay the entire amount. My lords, even, my lords, after award has been passed, we made the payment year 2019. My lords, after 7 years spending in the litigation, my lords, we have no other option, my lords. My lords, if he makes the payment, my lord, why should we send him to prison? I don't want, my lords, him to go to prison. I want my money. My lord, let him give him bank guarantee, my lords, or let him make my payment. That's all I'm before the court, my lords.
My only issue is this, my lords. They put up my property for sale. Nobody came forward. They could have put it up another one or more times, my lords. I would have also found a
Objector petition in your in the
no, objector petition is filed by the agreement holder insofar as the others. My only request is this, my lords.
There are no other properties. 6 properties, according to my lord, according to him, before the court, is entire sold. One property, my lords, it is joint family property of the petitioner and his wife. How can I, my lords, go for property sale? Let him sell the property and give my money, my lords. I don't want his property also.
My lords, I'll make my efforts with the client to see to it that some payment goes, my lords. I'm not coming in the
That
way
is
of-
what you have been doing it from the.
Yes, I do understand that, my lords. If this property is put to auction one more time, I'll also try to buy a finder and find a buyer so that it can be sold off so that he'll also get, because this is worth more than 5 crores is what my instructions are, and his due is 2 crores. So if I am able to find a buyer, I'll be able to settle his thing as well as everything, my lords. All I am requesting, my lords,
Once this notification is issued, then the family will come.
no, my lords, there is no, only he has got a son and daughter who have nothing to do with it. I can, on instructions, I'm stating this, my lords, it could be put off auction in another 15 days time, my lords. So I'll also try to find some buyer so that we can put the entire thing to rest. In the meanwhile, I'm not able to go to my house, my lord. If my learned friend, I'm making an earnest request to my learned friend, 15 days
If
time.
you send him to the civil prison, what is it you will get?
Nothing, my lords.
So if the property is.
No,
sold, you get the money.
let him give undertaking to the court, my lords. Within 3 months, we'll make the payment, my lords. I have no objections. My lords,
I'll have it tomorrow, my lords. I will give a
my lords,
undertaking
my lords,
as
it
to
was
what is the
understanding
timeline.
before my learned friend in the office. My lords, we sat here only, we spoke. My lords, 3 months time was sought. By June, he will make the payment. We are in, my lords, we are in August.
No, you want undertaking or that proposal for.
No, my
selling
lords,
the
we want
property?
undertaking, my lords. We want money, my lords. We don't want, my lords, property or sending him to prison, my lords.
Tomorrow?
Tomorrow, my lords. Great.
Yes.
Then number 43 adjourned, 44. Gaurav Reddy and co-petitioner.
Matter for the petitioner. The plaintiff's application to lead secondary evidence by producing the copy of the legal notice issued by the respondent and his mother has sought to be produced as secondary evidence. That application has been rejected.
Let's see the order.
Even other side also says no objection.
I've submitted no objection to the trial
Let's
court.
see. Where is the order?
Will it?
Order.
Order 144. Sorry, 142. The reasoning. Section 65 of the Evidence Act, the permitting to lead secondary evidence only upon the establishing the existence and execution of the original documents and upon providing the circumstances bearing
This is
the case.
issued by whom and received by whom?
Notice issued by the respondent. and
Received by you.
Received by me. Because the reply has been marked as an exhibit P34. The notice has not been marked.
The petition is before this court agreed with the order passed, agreed with the order dated 23/7. What is this date? 23/7/26.
Yes, madam.
23/7/2026. With the principal civil judge and additional JMC KGF Kolar in OS number 270 of 2019. The petitioner is a plaintiff in the suit. He has filed an application under section 151 CPC, read with section 61 CPC, paying to mark the Xerox copy with the legal notice dated 3/7/2012, alleged to have been issued to the defendant as secondary evidence that came to be dismissed by order impugned. It is submitted that that is dismissed by way of order impugned. The court, while dismissing the application, has observed that section 65 of the Evidence Act permits reading of secondary evidence only upon establishing the existence of and execution of the original documents and upon providing the circumstances bringing the case within one of the statutory exceptions. In the present case, except making a bold statement that the original notice was misplaced with a deceased pharmacy and could not be traced despite search, no material has been placed before the court to establish when and under what circumstances the original was lost or what efforts are made to trace it. No satisfactory foundation has been laid to invoke the provisions relating to secondary evidence. The mere fact that certified copy of the reply notice dated 27/2012 has been marked as exhibit P34 and that refers to the legal notice dated 3/7/2012 does not dispense with the mandatory requirement of admitting secondary evidence of the alleged original notice. A reference in another document cannot by itself prove the existence and execution of the contents of the original document. It is important to note that before secondary evidence is permitted, the court must be satisfied that the conditions prescribed under section 65 of the evidence are strictly fulfilled. In the absence of such foundational fact, the application cannot be allowed. Next, Parallel counsel appearing for the petition that even the defendant who has issued the said notice has said that he has no objection to mark the document as secondary evidence, as the same was as he himself admits that the said document is said notice was issued by him. The court, approaching in a very hyper-technical manner, had dismissed the application. Next, Parallel counsel appearing for the respondent submits that he has no objection to allow this application. Next, having heard the counsel's on his said peruse the material on record, the court has discussed about the scope of section 65 of the Evidence Act, permitting to lead the secondary evidence. Here, the document which the petitioner wants to rely as a secondary evidence is a document, a notice dated 27/2012, issued by the defendant to the plaintiff.
Yes.
Issued by the defendant to the plaintiff. Plaintiff submits that according to the plaintiff that document is lost, and according to the defendant, even the defendant has stated that he has no objection to mark such a document. In those circumstances, the court ought to have allowed the application in the substantial interest of justice. In that view of the matter, the order impugned dated so and so, and this court is passing the following order. The order impugned dated so and so is set aside, and the application filed with the plaintiff under section 151 CPC, read with section 65 of the Evidence Act, to mark the legal notice dated 3/7/2012 is allowed.
Then number 45.
One submission. In earlier when this honorable court has directed the trial court to dispose of the suit within 6 months. It is expiring on the 18th of this month. Another 6 months may be extended.
All will not be done in this petition.
Because it is expiring in 18th of this month.
They will do. That is the duty of the learned judge. He will address a letter. Yes.
Then number 45. Sagar G. Nahar for petitioner. CH-19 Rao.
Before it starts, we have been served with the copies of the petition not yesterday late in the evening. So
they are the plaintiff, they had made the application and they have got an order in their favor.
In the evening, I think
I can assure him, Billots, that other than the case which he has put forth before the trial court, I will not argue me beyond that. And I can't argue beyond that. It's a 227 petition.
will require the order sheet of proceedings, which I'll have to place.
I-
it before you, Lordship. I'll require
That's
the
the-
order sheet of proceedings, Lordship, which I'll have to place it.
I
before the
have
court.
no difficulty.
There's a blatant fraud which has transpired. Court has done something. Lordship, I think
I,
that is the matter of the merits. So it could be had on Monday, Lordship, let us do.
Lords, the date for
Otherwise, they're not going
complaints,
to follow the notes in Monday, I'm sure.
the date for complaints is on Monday. I don't want to be in contempt of the orders of the court.
Tomorrow. I'll take it up tomorrow or else Monday, like we'll say that, no.
Till let there be no, that the order be kept in suspension till Monday, because I don't want.
Two things, if you don't want the order to be, if I hear it on the merits, whether I'll suspend it or not,
That's a different.
it's a matter of,
That's a different.
so if you want it to be on Monday, then we have to pass an interim order. If it is tomorrow, I can take up. Tomorrow,
Lordships.
yes.
Then number 46 for admission matter, Balraj AC, petitioner.
My lord, 45 in list 1, please, tomorrow.
45?
List 1.
Tomorrow list one. Yes, 46.
My lord, I appear for the petitioner, my lord. My lord, the defendant's application, my lord, filed under order 7 rule 11, my lord, for rejection of plaint, my lord. My lord, suit for cancellation of the sale deed, my lord, which was executed in the year 2004 in favor of me. My lord, myself purchased the property in question, my lord, in 2004 by a registered sale deed. Thereafter, my lord,
Please come to your application under order 7 rule. Where is it?
please, my lord. Yes, my lord. Page 61.
Page?
61, my lord. 6.
Let's look at your affidavit.
My lord. 63 is the affidavit, para 2, my lord. I submit that the plaintiff has filed the above suit for passing the judgment and decree for cancellation of the registered sale deed dated 19/8/2004, executed by Shivanna, and the same was registered in the offices of senior sub-registrar so and so. In respect of the social property on the basis of the general power of attorney dated 5/2/99 in favor of the defendant herein and for granting of the relief. Plaintiff is not entitled for the above relief as the plaintiff is neither the owner or in possession of the social property. I have eligibility so and so. Para 3. I submit that I am the absolute owner and possession and enjoyment of the property bearing immovable property bearing site number so and so. 112 card out of survey number 51 of Nagdevanalli village. Presently Kingiri, Bangalore South Taluk as per town municipal Kata number so and so, measuring east to west 40. Not to so 30 feet, registered as sale deed dated 19/8/2004. So, fourth para. I submit that on acquiring right title and interest over the above property, approached the town municipal council Kingiri for transfer of Kata into my name, and Kata was transferred into my name in the records of town municipal council Kingiri. And later I had intending to construct a residential building in order to have roof over me and my family members. I obtained a sanctioned plan from the town municipal council Kingiri on 23/5/2005, and he has been in possession of the above property. I submit that as I am
So according to you, the suit is barred by limitation.
Please, my lord, because after six,
One-
please.
Now you have stated so many things in this affidavit with regard to your exchange of notices and other things.
Please, my
Was
lord.
it stated in the plaint?
Yes, my lord, it is
Let's
stated.
come
My
to the
lord,
plaint.
yes, my lord. Yes, my lord. Para 9, my lord.
Page number?
Page number 42, my lord. 42.
What
Or
did they say?
even for para for 7, my lord, page 41 also. The plaintiff submits that when such being the case and cause some inimical persons towards the plaintiff and the inactive possession of others, God created a forged, fabricated and manipulated general power of attorney after the demise of the plaintiff's father Chikkanna dated 5/2/99 in the name of one Shivanna. On the demise of on the said concocted and created general power of attorney dated 5/2/99, the said Shivanna executed registered sale deed dated 19/8/2004 in favor of the defendant herein, and the same was registered in the office of the senior sub-registrar Kingiri so and so. And para 8, the plaintiff submits that it clearly goes to show that the plaintiff's father died on 29/2/1992, but the created and concocted general power of attorney executed by one Shivanna dated 5/2/99 on the basis of the created and concocted.
Asking you, where did they refer to the notices?
Yes, my lord.
Notices.
Yes, my lord.
And that too, they're alleging fraud stating
ma'am.
that after the death of the father,
My
the
lord, he
GPA
obtains he obtains the death certificate of his father after 12 years, my lord. His father, he claims he has died in the year
when
1992,
was the document registered in your favor?
2004, my lord.
Basing on the GPA dated
My lord, GP dated, my lord, it is uh, GP.
1996,
Please, my lord. His father, my lord, his father was
died on 1990 in the year 1992.
after the, yes,
Then after the death of the principal, what is the GPA?
my lord, his father was alive, my lord. That is the,
No, 92 he died.
my lord,
96
it
is
is
the
incorrect.
GPA.
It is incorrect, my lord, because he says, my lord, he obtains
And all
the,
those things can't be decided under Order 7, Rule 11. Please come. The petition is before this court. Agreed with the order passed on IA number 3, it's number 607 of 2020, dated 19 September 2025, by the Principal Civil Judge, Bangalore Rural, Bangalore. The respondent herein has filed a suit for cancellation of the sale deed.
please, my lord.
Sale deed. According, it is the case of the plaintiff that after the death of the father, basing on a GPA, the document is executed in favor of the petitioner. The petitioner, who is the defendant in the suit, has filed an application under Order 7 to 11, seeking rejection of the plaint on the ground that the suit is barred by limitation. In support of his support of IA, an affidavit is filed. In the affidavit, it is stated that there was exchange of notices between the parties way back in the year 2004-2005, and they have the knowledge about the same, and they filed the suit in the year 2020. And as the suit is miserably barred by limitation, the same has to be rejected. The trial court, by order, has rejected the application seeking rejection of the plaint. While passing the order, the court has observed that a plea of limitation is considered is a mixed question of fact and law, because its resolution requires both applying the law of limitation to the specific facts of the case, such as when the cause of action arose, when the plaintiff gained knowledge of it. As a result, the issue generally cannot be decided summarily without allowing the parties to present evidence, and a plaint cannot typically be rejected on grounds of limitation at the initial stage, as it involves disputed questions. Therefore, without a full-fledged trial, the court cannot reject the plaint on the ground of limitation and accordingly dismiss the petition. Learned counsel for the petitioner submits that the notices that are exchanged between the parties makes it clear that their knowledge of the document way back in the year 2004-2005, and the question of filing a suit in the year 2020 does not arise. It is submitted that in every case, a question of the limitation necessarily be not a question of fact and law. It is submitted that on the face of it, without going into the other aspects, the court could have dealt with the same, but without appreciating the same, the court has rejected, and the order needs to be set aside, and the plaint is liable to be rejected. Expert, having other counsels on either side, counsel for the petition. There is a material on record. Suit is filed for cancellation of the sale deed. Admittedly, the sale deed was executed in the year 2004.
Well, please, ma'am.
2004. According to the plaintiff, the father died in the year 1992. The GPA is of the year 1996.
Please, ma'am.
GPA is of the year 1996. According to them, after the death of the father, this document came to be executed, and there is a fraud. Further, the petitioner defendant relies upon notice exchange between the parties, however, that do not find place in the plaint. In those circumstances, the court cannot, considering an application under Order 7 to 11, court cannot look at the defense of the defense put forth by the defendant. Court can alone look at the plaint and the documents filed in support of the same. In these circumstances, the trial court has rightly rejected the application. and this court finds no reasons to interfere. Discuss next.
Serial number 47, Samir Hassan for petitioner.
Kindly pass over, madam. Senior wants that.
It won't, I won't be calling the passos. This is matter on Tuesday.
Madam, I request, madam, tomorrow, madam.
Tuesday. Yes,
Tuesday.
48.
Serial number
Tuesday in the
48.
first list.
48, Prakash, BN.
Defendants revision, Lord. 7 Rule 11 application has been rejected. This is a suit for partition by challenging the sale deed of 2006 executed by the father. Lord, the daughter has filed a suit for partition challenging the sale deed of 2006. Father executes the sale deed in 2006. He was alive till 2015. And 2023 present suit is filed. And I have filed an application on 2 grounds. One, there is no cause of action and it's barred by limitation. And kindly see, my lord, the application, which is at page 51. Affidavit is at page 52, para 5. Lord, I have extracted the plain government and then said how the suit is not maintainable.
She says that this property fell to the share of the father.
Father has sold it in 2006 to my mother. That is plaintiff number, defendant number 1.
Then counsel for the petitioner submits that the plaintiff, the suit is filed for partition and also question the sale deed that is executed in favor of the petitioner herein in the year 2006. In the year 2006, it is submitted that in the plaint itself, so it is stated that the property is property in the partition. This particular property fell to the share of the father, and it becomes a self-acquired property of the father. He executed the document in the year 2004. 6 and died in the year 2015. Those circumstances on the face of it, basing on the plain governments, the court ought to have considered the case of the petitioner. Considering the same, there shall be stay of all further proceedings pursuant to the order dated. Notice to the respondents.
Serial number 49, urgent, 50, Shanmukappa.
Not appearing for the petitioner, my lord. Lord, it's a suit for partition filed by the respondent. Son has filed a partition suit against the mother, my lord. My lord, the original owner of the property was the petitioner's mother, and subsequently, after she passed away, the property devolved on the petitioner and her sister. They entered into a partition deed, my lord. So this, and that is in 2024. So the property devolved on the petitioner is from the maternal side, my lord. There is no concept of ancestral property. But here the suit has been filed saying that he has a right since it is an ancestral property.
Where from you can get that it is a property from the maternal family?
Lord, it is the property belonged to the mother of the petitioner.
Who said so? Plaintiff said so.
The plaintiff's allegation is that the father has contributed money, my lord. But even in that scenario, my lord, if that is to be taken into account, after the passing away of the mother, the property has devolved upon the petitioner and her sister, and they have entered into a partition deed, my lord. Even by that extent, it still remains as maternal side, my lord. There is no continuous male lineal descendant.
How all that can be decided in under order 7 rule 11?
My lord.
But that the evidence is required.
Yes. No, my lord. Even if we are to take the contention that the plaintiff has taken, and the property once by
from the joint family fund, father has contributed something to buy that property. If that is the case.
No, that is the grandmother of the respondent.
Come to the plaint.
Yes.
What did the plaintiff say?
Lord, the plaint.
Who is Mallegowda?
Lord, Mallegowda is the father of the respondent, my lord. Father of the, I mean the grandfather of the plaintiff, my lord.
Paternal grandfather.
The maternal grandfather. My lord, the Mallegowda being the maternal grandfather, the allegation of the plaintiff is that he has contributed money to purchase property in the name of one Renuka, who is the grandmother of the plaintiff, my lord. And this was purchased in the year 1982. 16/01/82 is the sale date, my lord, by which
Your mother is the daughter of Mallegoda.
Yes, my lord. The defendant number 1 is the mother and defendant number 2 is another son, my lord. The plaintiff is also one of the sons of the defendant.
Who filed son filed?
My lord, the son is filed against the mother.
Against
Against the mother, my lord.
mother and
Mother and the other son, my lord.
no daughter.
No daughter, my lord.
Please come. When counsel for the petitioner submits that when a suit is filed seeking for partition in respect to the properties which were acquired by the mother, that is defendant number 1, from her father, and the petitioner has filed the petitioner who is a defendant in the suit has filed an application order 711 stating that the said properties cannot be termed as joint family properties and they are not open for partition. These aspects were not considered with the court and the court rejected the application filed under order 711 considering the submission of the council petition. They shall be stay of all further proceedings. Notice hands on.
Chair number 51. Mahesh, CM.
Appearing for the petition, Your Lordship. Senior is held up in the different court, Your Lordship. An adjournment
It's matter
on Monday, Your Lordship.
on 19th of August.
Much.
52. Raju, yes.
Petition. My lord, defendant's petition filed application order 7 rule 11A, no cause of action.
What is the suit for?
Suit for partition and separate position. My lord, so suit for partition and separate position. Earlier that plaintiff's fathers have filed a suit for partition comprehensive.
Come to your affidavit.
Page number 22, my lord. Para 2, inner para 2, impugned order. In the affidavit filed, the support of the application first defendant stated the relationship between the parties admitted.
Not 22, affidavit in support of the IAI Act.
Yes, my lord. Page number 52, my lord, affidavit. But 53 will come to the relationship admitted, properties as admitted. Para 4.
Come to the impugned order.
Yes. Impugned order, page number 30, my lord, para 30.
Come to the reasoning part.
Pardon.
Reasoning part.
Yes, my lord. The plaintiff have filed the above suit, page number 24, against the defendant for the relief of partition and separate portion. After filing of the suit, defendant have appeared before the court through the advocate and filed a written statement, and defendant one filed a present application to reject and appliant as there is a no cause of action and suit is barred by limitation, and the court fee paid the differential fee. The submission defendant counsel is there is a no joint family status and there is a no ancestral property available for partition. Plain schedule properties originally belongs to the father of the defendant one, namely Hyder Ali Khan, father of the defendant one, executed settlement deed in favor of the defendant one. Hence, the plaintiff have no right over the plaintiff scheduled property. Once the brothers of the plaintiff, defendant number one, has filed a suit in OS number 431 of 2006 and 248 of 2008, the said suit have disposed before Lok Adalat. Hence, there is no cause of action to file a suit, and the suit is barred by limitation. Hence, pray for allow the application and so on. So, the submission of the plaintiff counsel reasoning, my lord. This order 7 rule 7, my lord. Reasons in para number 13, my lord. A meaningful reading, para number 13, page number 28. A meaningful reading of the plaint shows that there is no partition. Moreover, Mohammedan law, there is no concept of joint family and non-state property. Admittedly, defendant one.
For the petitioner submits when the respondent herein has filed a suit for partition. When in respect to the property, earlier partition suits were filed and compromised, and there is no cause of action for the plaintiff to file the suit. The court has failed to consider the same. Considering the submission, they shall be stay of all further proceeding. Notice and summons.
Number 53. Ajay Kadkolti,
Permit me to
petitioner.
take notice to our advocates on record because of 23 members are there, my lord.
I've already said so.
Only
Yes.
hands. Then number 53, Ajay Kadkolti.
Interim.
Yes.
Very unfortunate case, Manoj, where I was a legal advisor to a company. Company would indulge in thieving of information from electoral rolls. I would say, I'm sorry, I don't subscribe to such acts that you're conducting. I want to resign, and whatever is the outstanding, please give it to me. They would not give me, my lords, the outstanding amount. What I would do is, I issue a legal notice, and I also file a criminal complaint. Those criminal proceedings were challenged, my lords, by the plaintiff before this honorable court. This honorable court would dismiss their petition. Those criminal proceedings are ongoing. After, my lords, these criminal proceedings that I would file, they would now, my lords, file a suit against me for recovery of damages, saying that the email that I addressed in private capacity to an individual is defamatory, and hence there is recovery of damages suit against me. I'll just request your lordships, trouble your lordships with just one paragraph on cause of action. And that is my application. I file an application under 711A. Trial court misreads it as 711D. Well, may I request your lordships, my lord, I'll just point out two paragraphs. The cause of action, may I request your lordships to kindly turn to page number 53, my lords, of my paperwork. Absolutely nothing, my lords, in the plaint, except for saying this email was received, which has caused me damage, which has caused me loss. Hence, I'm claiming damages of 15 lakhs. I request your lordships to kindly read, my lords, para 16. The cause of action arose within the jurisdiction of Bangalore, wherein the plaintiffs received the mails.
Para 12.
Please, my lords.
Para 12.
Para 12, my lords, they are saying that is not the cause of action for defamation. Yes.
We'll see what is.
Very well. May I read para 12, my lords? Yes. Please. The plaintiffs state that the defendant tried to adopt illegal methods by blackmailing the plaintiffs by sending mails, messages, calls, meetings, and through a legal notice, but failed miserably. Because of these incidents, the plaintiff number 2 is facing mental agony and in the constant fear of being attacked by the defendant and her people, due to which the plaintiff could not focus on her daily work and move on freely. Further, the defendant, along with the person, namely Abhijit, alleged to be her husband, has been to the customers, clients, staff, vendors. Well, it's absolutely nothing. My lord, they should state, my lords, as to what is their cause of action. Your lordships, my lords, have consistently held many omnibus, my lords, averments that are made in the plaint, which may, my lords, be categorized as clever drafting, could not be a cause of action. I can understand, my lords, had she named person A, person B, person C at least. Well, then in that event, my application would not be maintainable. That would be a subject matter of trial. Let's kindly look at our averment on cause of action, Millets. At para 16. Nothing but vendetta litigation without there being any cause of action.
Let me look at it. Let me look at it.
On the email, Millets, though Millets it may travel on facts, this email that they're referring to is an email communication that I would address to the plaintiff. Even on facts, my lords, it does not amount to a publicizing act, which may tantamount to defamation.
No, we will not look at the complaint like we look at a complaint under 482.
No, I bowed down, my lord. I respect, most respectfully bowed
We
down.
won't be
Now, my
saying
lords,
whether there
kindly.
is allegations are retracted or not. That is not the way.
No, I bowed down. I am not troubling your lordships at all on that, which is why, my lords, I respectfully submitted. I don't want to travel on facts insofar as my application is
Complaint
concerned.
is a bundle of facts.
Please, my lords, I bow down. I don't want to travel on facts at all. Even if all the averments that are there in the plaint are looked at its face value, my lords, whereas she even made out a case for a, but there being a case against me, my lords, where there is a cause of action. And your lordships have held, my lords, in an application under 711. I fall under clause A. Now, my lords, kindly see the impugned order, my lords. May I request your lordships to kindly turn to page 28. The trial court misreads, my lords, my application, considers my application on parameters of clause D, and says my application is not maintainable.
Plaintiff sent a legal notice dated 15/2/2023 to the defendant,
Please.
directing to seek apology. The copy of the said legal notice dated 15/2/2023 and copy of the reply notice dated sent by the defendant is produced.
May I request your lordships to kindly turn to the impugned order, my lords, for a moment.
No, this reply notice was sent on exchange of notices was on 15/2/2023 and 21/2/2023.
My lordships are referring to, my lord.
It is filed on 5/4/2023.
Please. My lords, the legal notice is not the act of defamation that is being alleged by this plaintiff. What she alleges is my email communication, which I would send to her, much at a point of time when these proceedings had not taken place, asking her that look for certain period before I came out of the organization.
No, according to you, now we have to look at the email communication and then whether she has made out a case.
I'm not going to trouble your lordships for the email communication.
Then how?
Now, my lords, the plain reading of
according to you, cause
Please.
of action. She said
Please.
to have she has narrated some acts, whether whether she will prove it or not, it's a matter of trial. She said that all these things have gone. Then she issued a notice to you. You have issued a reply notice.
Please.
Then she filed the suit. According to her, that is the gist of it. Now, order 7, rule 11, you say you fall under A.
Please, my lord.
No cause of action for them to file. Who are you to say that?
Can I
there is
persuade your
no
lordship?
Yes.
Can I persuade your lordship?
Yes.
No, my lords, I'm just assuming the worst case against myself. Had she even mentioned, my lord, saying that there is an email communication, I'll assume the worst case against myself. That email communication was read by my manager. He started questioning me. Oh, is it so that you're not paying him?
That kind of a meticulous
No, my lords,
reading of the plaint is not contemplated.
My lords, I bow down, my lords. My lords, I'm cognizant of the fact that your lordships is not exercising the yardstick that your lordships will exercise in 482. But my lords, have a look at this plaint. My lords, absolutely nothing except for narrating, my lords, few documents being exchanged. Now have a look at, I'll just trouble your lordships just for 2 minutes, my lords. And
What about this? Please come to order 7, rule 11.
please.
Every suit will go if you look at like that. No suit will has to go to the
My lords,
trial.
I bow down, which is why I was careful, my lords, in assisting your lordships only insofar as the averment.
No,
This is, my lord, which is why, my lords, I begin my
Look at order
assistance.
7, rule 11. Please come to order
Please,
7.
my lords, have a look at this clause A, my lords. The plaint shall be rejected in the following cases where it does not disclose the cause of action.
Please convince the court on that point.
Very well.
According
Now-
to you, where is no cause of action?
Well,
She has stated, she has given narrated certain facts.
Please.
And according to her, a cause of action arose when she has issued about all days and a legal notice is issued. You issued a reply notice,
Please.
and immediately she has filed the suit. According to her, that's a cause of action. So we will not be going into a
I am not troubling your
meticulous
lordships at all on
appreciation
that.
of all those A mini trial we will not conduct.
No, no,
under
certainly,
Order 7
Milord.
Rule 11.
Milord, I'm not troubling your lordships to conduct a mini trial on facts. I'm only requesting your lordships that had there been a single sentence, Milord, to state that communication X was read by this person other than me, and that has caused or defamed me in his eyes. That could be, my lords, a matter of trial. And if I was troubling your lordship saying that that person was not there or that person is not existent, that person was not there in the organization, my lords, I bow down, your lordships will dismiss my petition and say it's a matter of trial. The matter has got.
This will order notice.
Very good.
Notice to the respondent.
May I request my lords to consider my application for continuance.
And summons.
Very good.
Then number 1354.
And deeply obliged.
Pradeep HS.
My lord, I'm for the petitioner. It may be taken on 18, my lord. One more matter belongs to same petitioner is listed on 18.
Yes, along with so and so. What is the number?
634/26, my lord.
Yes, along with that on 18. Yes, 15, 55.
55. Cell number 55.
Appear for
Saudi HR.
petition, my lords. An appeal, my lords, filed with a delay of 955 days, my lords. Without any explanation, my lord. The suit was also not prosecuted.
And it means how many? Almost 3 years.
Yeah, 3 years. 2019, my lords, is the order. In 2021, they filed the appeal. My lords,
On that, an order is passed in 26.
yes,
Let's see that order.
yes, my lords. Lordship, you kindly
Let's see the affidavit in support of that.
Yes, my
What did they say? What is the delay? For?
Yes, Annexure C is the order, my lords, impugned. Lordship will get the affidavit in support of it. Annexure A is the application. Page 24 is the affidavit. There were 4 plaintiffs. Now an allegation is made that third plaintiff colluded with the defendant. There are, it was a suit for partition, my lord. There are several properties. All the property, subject matter properties were sold before the suit for partition was filed. Then a suit for partition was filed. There they allege
This appellant was arrayed as defendant number?
appellant is 13. Appellant was respond number 30. Defendant number 13 and respond number 30. And they did not bother to prosecute it. They do not come for.
What do they say? What do they say? What is the reason?
So now they say that the third respondent, third defendant was a brother who joined them in filing the suit, and then he betrayed them, and he was following it up. We were all sitting at home, and he was kept us in dark.
Who are you?
I am one of the defendant, lords.
For the family member.
I am a family member. There was a gift in my favor.
You could have told them about the pending proceeding.
No, I am not. I was a defendant. I was contesting the matter. It is among the plaintiff.
You're all members of the family.
Yes, my lord. We were living in a different places.
Your partition suit, your own family, what will happen?
With great respect, my lords, I have, there are transactions.
I can understand you are a purchaser, you are unconnected with the family. It's all family. What will happen? The dispute will be decided.
No, it's not about that, my lord. If the properties were available for sale, it was there in the property, then it would have been, my lords. My mother has gifted it.
The judgment and decree.
The judgment and decree is that the suit is dismissed for non-prosecution. They did not come forward to cross-examine. One of the defendant dies. It was abated. Then again they make application. All those things they have done. The PW1 did not come for cross-examination despite of giving enormous opportunity. And they were all residing in the same address. And all of a sudden, after 2 years, she checked it in internet and she came to know that it is, she realized it is dismissed.
The defendant number 30.
30.
30 has filed an appeal.
No. Plaintiff has filed an appeal. Sorry, plaintiffs have filed an appeal. I am defendant number 13. I am the petitioner herein. The plaintiff. Lord,
it's a contested suit.
It's a contested, but they did not come forward.
Dismissed for non-prosecution.
Dismissed because they did not come forward and for cross-examination.
Judgment and decree.
Your Lordship, kindly see annexure D is the judgment.
Page number.
Page number, Lordship will get it at 60.
The suit of the plaintiff is hereby dismissed with cause.
Yes, Lordship may kindly see, 54 onwards is the recording. Everything, Lords. The reasoning starts at 61. There were 4 plaintiffs. Against one of the plaintiffs, others are now making allegation. He was looking after it and he did not come forward. No, we were not aware. And after 2 years, 3 years, now we have come and
What happened to him?
he is there. He is already as different respond number 19 in the appeal.
He is appearing.
I don't, in this, I am not aware.
It is submitted. The suit is decreed. Suit is dismissed. The partition suit is dismissed. And after 3 years, after 955
days, as per
days, appeal is filed without stating proper reasons, and the court has condoned the said delay. It is submitted that as on the date the suit is filed itself, there are no properties for partition. All these were observed by the court considering the submission. There shall be stay of all further proceedings. Notice and summons.
Number 56, Kamala G for petitioner, R. Lokesh.
Here for the appellant, my lord. The suit is for partition.
Here for respondent.
My lord, the first and second respondent are the plaintiffs, are the daughters of the third respondent. My lord, they have filed the suit in the year 2015. My lord, today, after 11 years also, the stage is still in notice stage only. My lord, I filed application in the year 2017 for rejection of plaint. It was disposed on in 2025. My lord, my specific case is, my lord, it is admitted fact in the plaint that the family partition between the father and the male children took place in the year 1989 in the court itself. A decree was passed in the 1988. 1988 suit was there, 1989 it was decreed. I purchased one of the suit schedule property, that is item number 4 in the year 1992. After that, my lord, in the year 2008, my lord, today I am 90 years of age. I have 9 children. In the year 2008 also, before the court only, I got partition to all my children.
Except this property, there are no other properties.
My lord, there are 9 items of properties. All 9 items of properties was partitioned in the year 1989. It is admitted fact in the plaint. By looking into the plaint itself, my lord, plaint has to be rejected. My lord. Not only that, my lord, after that there are all the suits for properties have been sold out.
You are concerned with only your item number of the property.
For one item number 4, I am concerned, but I filed application to reject entire plaint only. The reason is, my lord, if you want kindly see one para, they have mentioned that in the 89, it is admitted fact that in the plaint in 89,
Father is when the father died.
all the properties was sold out, my lord.
In the pendency, father died.
During the pendency of the suit.
In the year 1989, 2 sale deeds was there. In 92, sale deed was. 95 also sale deed was there.
Come to the order.
Well, order says that I am only concerned about only item number 4 and suit cannot be rejected.
Correctly said.
My lord,
How can you say that their entire plaint has to be rejected? What is your locus?
Yes, my lord, kindly see the.
You are only concerned with why you are made a party as a defendant, because in respect of which property there is a sale deed.
But how long I should wait, my lord?
No,
That
for
is the
that
problem,
reason
my
you
lord.
can't ask their plaint to be rejected.
Because what? There is no fault of my lord. In 90, after
Suit is of which year?
Suit is 2015, my lord. Till today it is in stage of notice.
Say, like, considering the age of this defendant, will ask the court to dispose of the matter within 6 months.
Yes, that also I am ready.
Even the matter has not reached the trial because of deaths of some of the defendants.
But something has to be done. What is the age? You said 90.
90 years, my lord. Even my some
Even
9
he has
children.
disposed the property in favor of his children. That is defendants 14 to 20.
Yes, they got divided in 2008 in the court itself, my lord. Now they want to sell some properties. They are not able to sell because anyone in
Have
that
sought
village
for
says
not
the
binding
case is
of the
pending
decree.
on.
The present application is filed. That's I number. An application is filed under Order 7 to 11 AB and D of the CPC, date 11/7/2017, by defendant number 13. and that came to be dismissed by order dated 16th October 2025 in OS number 812 of 2015. For the fourth additional senior civil judge, Bangalore rule, properly framed. According to the defendant, he has purchased the property in the year 1980.
1992.
1992.
1992.
He has purchased the property in the year 1992. There was a partition among the male members of the family in the year 1989,
89.
basing on that the property is sold to the petitioner. Now after, and in the year 2015, the suit came to be filed. It is submitted that the Order 7 Rule 11 application is filed on
ABD.
in the year
The year 2017 I filed.
2017. That application is filed. That came to be disposed of on 16th October 2025. It is submitted that when the properties are already partitioned and pursuant to that, when the properties are sold, the entire suit itself, there is no cause of action for them, and the suit itself has to be dismissed on the ground of no cause of action limitation. The court, without appreciating all the facts, had dismissed the petition. It dismissed the petition. It is submitted that looking at the age of the defendant, who is 90 years old, if in this manner the proceedings go on, that would cause a lot of prejudice to he will not be even able to enjoy the food. He will not be able to see that the litigation goes to a logical end. Then counsel appearing for the respondent submits that the court has rightly dismissed the petition because the defendant is concerned only with the property which she has purchased. There are other suit scheduled properties. He cannot seek dismissal of the entire suit, and the court has rightly dismissed the petition. And there are no grounds to interfere. Having heard the counsels on either side, there is a material non-record. As far as the reasoning given by the trial court, this court is of the view that no interference is called for. However, considering the age of the plaintiff, defendant number 13, this court deems it appropriate to pass the following order. This court, number one, this court do not find any reasons to interfere with the order impugned. Number two, the writ petition is disposed of, directing the so-and-so court to dispose of the suit as expeditiously as possible, but not later than a year.
Chair number 57. Sundaram MV, for petitioner.
The petitioner, my lords, was led by senior counsel. He's on his feet at the moment.
Is this matter on 9th of September?
Lords, we have a shorter date. But is shorter date possible, my lords? Is a shorter date possible?
Fortunately, not possible. 24th. The first list. Yes.
Chair number 58. PS Babu Narayan, for petitioner Manjunath KV.
I appear for the petitioners, my lord. Petitioners or defendants, the respondent is the plaintiff. Suit for specific performance, my lord. IA impugned order is Order 7 Rule 11 CPC. My application for rejection of the plaint is dismissed. There are regarding facts, my lord. Plaint averments, cause of action para may kindly be perused. Page 21 of the paper book. Para 16. Cause of action for the suit arose on the date of execution of the registered agreement of sale dated 5/10/2010 and 3/10/2012. When the defendants have executed second agreement of sale on 4/12/2012, and the plaintiff got issued legal notice to the defendants and on
looking at page number 90.
Yes, my lord.
Your affidavit. You are saying about the judgments and all.
Yes,
How
my
the
lord.
court are they produced by the plaintiff?
Yes, my lord. There is a
No. The judgments which you are referring in this affidavit at page number 2, Are they produced by the plaintiff or by you?
It is produced by the petitioners, my lord.
Then how will the court look into all this?
This judgment is relied upon by the district court in an arbitration
No,
proceeding.
that is correct. At order 7, rule 11, if this document is filed by the plaintiff, we can understand. But the court will not look into your document.
No, even otherwise, my lord, even without reference to my judgment.
So that's why, please look at it. Para number 1, para number 2, what you have said that cannot be looked into. Then come to paragraph.
Para number 1 is the pleading of the plaintiff.
That is, that is in continuation of that, you stated para number 2 that can't be looked into. Then come to para number 3. Settled principle of law that once a limitation begins to run in the year 2012, as per the alleged agreement, same it is also basing on
That is
the,
also plain government.
according to you, this averment is in connection with this order in the suit.
Yes, madam.
That document itself cannot be looked into.
Even without looking to that document,
And
my lord.
please come to the order and tell the court without looking into any of your objects.
Plaint, my lord, cause of action.
That where is the plaint? Yes. Which paragraph?
Paragraph 16 on page 21. 21 and 22. Agreements are of the year 2010 and 2012, my lord.
Oh.
There
The
was
cause
an
of action for
arbitration.
the suit arose, that is what you are looking.
Yes, my lord. There was an arbitration proceeding, arbitration clause contained in agreement dated 3/10/2012. Arbitration proceedings have taken place. Arbitrator has passed an award that was challenged in arbitration suit before the district court, my lord. The district court has set aside the award passed by the arbitrator. So now,
It was disposed of on 2/7/2025.
yes, my lord. Yes, my lord.
Then when was this suit filed?
This suit was filed on 30/7/2025.
Hmm.
Page 52, my lord. Arbitration award, judgment of the district court. Page 52.
You have filed it along with the plaint?
Yes, ma'am.
50?
52. The petition filed is allowed. Consequently, the award passed by the arbitrator dated 3/6/2015 in arbitration case number 1 of 2013 is
Who has
hereby.
initiated the arbitration?
My lord,
Who has initiated, who is the petitioner?
they are the respondent herein.
They are the respondent.
Plaintiff before the trial court. So both parties are at liberty to approach the competent civil court for exercising their remedy. My respectful submission is, my lord, once arbitration proceedings have initiated, then the respondent has to take recourse to section 43 of the Arbitration Act, if he is aggrieved by that. Without taking recourse to section 43, filing of a civil suit is not maintainable. Limitation does not save.
What is the court discussed in the order? Let's see that. This order is in your favor.
Annexure J, my lord.
Part of this order is in your favor. So you are happy with part of the order and remaining part you say that it's wrong.
No, it's not against part of the order, my lord.
No, petition filed is allowed. Who filed the petition?
That is the district court order, my lord,
That's what I'm saying.
in arbitration suit.
Whose favor?
I had filed that.
So that is in your favor. You are accepting the first limb of the order. And you say the second limb of the order is bad.
No, I do not say that, my lord. Even if there is.
No,
even-
what
even-
you are saying is the court gives a liberty.
Yes, my
Both the
lord.
parties are at liberty to approach the competent civil court
Yes,
for
my lord.
exercising their remedy. They
Yes, my
filed a
lord.
suit.
Yes,
You
my
say that that order is bad. That is what you are saying now.
If the remedy exists, that can be exercised. Section 43 of the Arbitration Act even if there is a liberty reserved,
You should have questioned this order. You should have questioned it. Such a liberty shouldn't have been given.
I fairly concede I have not questioned that
Because
order,
it was in your
that
favor.
portion of the
Half
order.
of the order is in your favor.
But now once the suit is filed, I have questioned regarding the maintainability of the suit. Even if that, assuming for the sake of argument, my lord, even if that liberty is reserved by the district court, what happens is it can be looked into whether that liberty reserved will override the Limitation Act. That is, liberty is only a procedural clearance to knock on the door. If the substantive law bars the entry, the door remains shut. So therefore, my lord, even if that liberty is reserved,
Yes,
now
what you say?
My lord, as for his own arguments, my lord, the second portion of the order of the district judge, my lord, it says
Yes.
that I am at liberty to approach the civil court. I have approached, my lord. And limitation starts from the date of the judgment of the district court.
Because it's section 14. Section 14 of the Limitation Act.
section,
There were 43,
Lord.
there is absolutely,
You are pursuing the legal remedies.
yes, my lord. My submission regarding section 14 is, my lord, section 14 is if a litigation has taken place before a wrong forum. This is not a wrong forum. Arbitration is not a wrong forum.
Not wrong forum, wherever, during the, you were fighting before a forum, wherever it is. The list is pending.
Yes.
Then, my lord, para 22 and 23 of my paper book, it refers to, that's the plaint, my lord. In the plaint, there is no reference to section 14 of the Limitation Act. There is no reference to how limitation is saved. There is absolutely no pleading. No pleading regarding why the suit is filed in the year 2025. When the agreement
The order, how the court has dealt with it, let's see.
orders at Annexure J, my lord, page 97. The last portion at page 107, para 13. And the ratio laid down in the said, above said decision made it clear that in order to reject the plaint, the court has to satisfy itself, court has to be satisfied with the point that it must be apparent on the plaint that the suit is hopelessly barred by limitation. Then only the court can, without hesitation, reject the plaint. Wherein the instant case, the Honorable District and Sessions Court Chikwadapur itself has given liberty to approach the competent civil court to get resolved their dispute. As such, the plaint government does not show that the suit is hopelessly barred by law of limitation. Accordingly, I answer point number 1 in the negative. So when we consider the plaint governments, my lord, there is absolutely no pleading how suit came to be filed in the year 2025.
Anything you want
It is there, my lord.
Anything?
Huh?
Anything else you want to add?
My lord, whatever he says, my lord, we already said that, my lord. Kindly go to inquest 21, my lord. In the cause of action, we have said that suit was pending and there's an order from the
Heard is on.
much.
Number 58, 59. N. Srinivas Murthy for petitioner. B.S. Anil Kumar.
Yes, my caveat is not notified. I will take the notice on behalf of the first and second respondent.
No representation on behalf of the petitioner. Let this matter in the month of September.
Then number 60.
I am aware from the petitioner, my lord.
Yes.
I am aware from the petitioner, my lord. The respondent.
Lord, may I make a request, my lord?
Yes.
Lord, the senior counsel is engaged, Lord, on behalf of the respondent. He has some medical issues today, Lord. Any date next week, Lord, he'll come here and
Have you heard?
My lord.
Senior
Proceedings may be
counsel has
stayed.
some medical.
The proceedings may be stayed, madam, any date, madam.
No, no, yes.
Because
I'm
they
not hearing,
they
not
filed.
hearing of why the court stay.
My lord,
This
my
is
lord,
my-
that is only my reason is seeking the proceedings are stayed, my
When
lord.
do you want
Any
My
date
lord,
next week.
only reason, my lord, only any date.
matter?
Proceedings may be stayed, my lord.
Till next date of hearing, my lord.
12th August. Nothing will happen. 12th
12th
August.
August, but kindly, my hard, my lord, kindly. What is the going on in the lower court? I explain only 2 minutes, my lord.
At least you prepare. You can't ask for a week when they have urgency.
No, no, we will.
Tomorrow.
Next hearing
it is
date.
Tomorrow in the first
So
place.
today, my lord, he has some medical emergency. That's why
Going on in the lower
my
court, I
lord
proceed, my lord.
will
Is the
argue, my lord.
only that 2 minutes, my lord.
Till next date of hearing, my lord.
Is tomorrow.
Tomorrow.
Till the extent.
Tomorrow list one, sir.
Yes, much
Yes,
obliged.
Cell number 61. Ramesh Shenke.
Here for the caveat.
For petitioner, my lord. The judgment and decree passed by the trial court, my lord, insofar as direct eviction of the petitioner from the shop premises in contrary to law and without
For
appreciating
small
the
causes suit.
My lords, if I could just mention.
What is the order passed?
My lords, if I could just mention that the decree has been executed. I am the landlord of the property. An order of eviction was decreed in my favor. I have taken vacant possession of the property.
Dated 25 to 2026 is already executed.
Yes, my lords, because 60 days were given for him to for him to in fact hand over the possession. He does not. Then I wait till 90 days. After the appeal period, I file my execution. Once I file an execution, even on that day, he has not filed a civil revision petition. Now, what happens is subsequent to that, a delivery warrant is issued, and I have sought for execution. I have received the possession of the property. I can place this on record.
Take that.
Well, in fact, what happens in the trial court is, my lords, they file about 10 applications to delay my proceedings on one or the other pretext. One is rejection of plaint, one is maintainability of the application. Then they say review application. He does not lead his evidence. He does not cross-examine me. He does not pay the rent. These are the legal hairs of the landlord, wherein I prove it through my evidence, my lords. Now, he does not even challenge his own order, his own application where it gets rejected for reopening of the cross-examination.
Yes,
My lords,
Mr.
costs would have to be imposed. In fact, I'll place the documents on record. I have it here.
We'll hear it.
Please. My lords, in fact, his revision petition would become infructuous.
Why?
My lords,
Stay
because the
petition
prayer sought for is eviction. My lords, eviction has been granted, possession has been taken over by us, my lords. That being the reason, now nothing would survive in a civil revision petition is what my submission is, my lords.
Page number 6, my lord.
What do you say about that? Possession is already taken.
I filed the warrant as well, my lords, which has been accepted. Third. Page number 3.
Then counsel for the respondent submits that. After the appeal period is over, execution is filed and possession is already taken. Then counsel the petitioner submits that he has no instructions. Is this matter in the month of September?
16/6/26, the possession was taken, my
16/6?
lords. 16/6/26, the possession was
16,
taken.
6, 2026. Yes, next.
Cell number 62 to 64
Obliged.
urgent. 65 for orders. Cell number 65.
No representation. Just in the month of October.
Cell number 66.
This also same.
Cell number 67.
Appearing for petitioner, my lords. My lords, in this case, 18/1 application along with Section 5 of Limitation Act was filed, my lords. Section 5 Limitation Act is been dismissed for not condoning 237 days of delay, my lords. My lords, the reason
the court office has taken objection with regard to maintainability. What is this order? Where is the order? Let me see.
Order dismissing Section 5 Limitation Act, my lords, higher 1. My lords, kindly come page number 28, my lords, operating portion of the dismissal order. May I permit to read, my lord? My lord, this
Yes.
my lord, this is land acquisition matter, my lords. In the year 2007, the government of Karnataka makes a notification to acquire the property, declaring the petitioner's property as a cold area because that is surrounded by the water of Hemavati Reservoir project. In the,
Yes.
they don't compensate the petitioner, my lord, landlords until civil contempt court petition is filed before this honorable court, my lords, in the year 2015. That comes to be disposed in the year 2021. My lords, this state.
According to you, the CRP is maintainable. If maintainable, how it is maintainable?
My lord, the order is 115 we have filed, my lord. Under writ also, there is limited scope, my lord. So, and as it is dismissed, IA is dismissed, we have come before this court under 150, my lords.
That's why how you come under 115?
My lord, may I read the operative portion now?
Yes, I've seen.
It's at page number 28, my lords. Admittedly, eighth line from the bottom, my lords.
Yes.
Admittedly, the application under 18 subclass 1 is not filed within 90 days from the date of deposit of the amount of 19/2/2020. The court notes that from the deposit of amount 19/2/2020, but this amount is deposited before registrar judicial before the court in civil contempt court matters under 335 of 2015. This compensation amount is not awarded to the petitioner. It has not come to the pockets of the petitioner. It is in the government and judicial register judicial deposit. They have deposited to avoid the punishment under the civil contempt court, my lords, and they have not distributed. And on the register judicial subsequent date on 21st Jan 2021 distribute via RTGS as per this honorable court order, my lords.
They have relied on a judgment of the Honorable Apex Court, where Section 5 will not apply.
Acceptable, my lords. And acceptable, my lords.
You accept everything. Then what do you expect the court to do?
My lord, there is subsequent notification from the register judicial extending the date of limitations. From next date, I will produce that notification, my lords.
Yes,
and in the meanwhile, my
the
lords.
objection with regard to the maintainability is kept open. This is matter on 10th of September. Yes, next. 10th of September.
In between notice?
Notice to the respondent. Yes.
Then number 68 disposed, 69 Chandrasekhar PV.
For the petitioner, my lord. The petitioner is the land action officer.
Maintainability.
Yes, maintainability, my lord. This is an order that passed under section 64, analogous to 18(3)B order, my lord. It is not an enhancement application, my lord, not 3031 reference. The application was allowed, but directly the land to refer the matter. Our contention is, my lord, they received the compensation before the authority.
Where is the order?
The order is under section 64. Page 18, my lord. Direction to refer the matter. Operative portion is 37, my lord. The petition filed 64, right to buy.
CRP is filed against the judgment passed by the second edition city civil and session judge at Bangalore.
It is not a decree, my lord. There is no decree. Like it is enhancement, my lord, decree will draw. 3031 decree will draw. It is not an enhancement. It is analogous to say 18(3)B World Act, my lord.
Then how will it come under 115?
Lord, this is an order. Order passed by the reference court directing to refer the matter. My lord, the last of is 115. The High Court may call for record any case which has been decided.
Section 64 of the Act is allowed.
Yes, madam.
Is directed to refer the application of the petitioner dated to the court for determination of proper and fair market value within 60 days from the date of this order.
This is not for enhancement. It is not for enhancement. If it is enhancement, then decree will.
The reference order.
It's only order directing to refer the matter. That has a challenge, because they received the compensation by way of consent. Philosophical section 29 of the KID Act. It says agreement. I have produced agreement also. When once received the compensation.
Where is the provision to question this reference order?
If it is an appealable order, then I have to file appeal.
Under the Land Acquisition Act, to show what is the procedure for this? A reference order will be questioned.
If it is a challenge to acquisition, it will lie. It is an order passed by the reference court authority. Therefore, revision is maintainable. Section 115.
Where it is referred to the court.
Yes, madam.
Which court?
That is authority, same court, madam. Same court. That is authority, 64 authority, district court, second national district court. Same court. That is, your lordship, facts are like this, madam. I may permit you to make some facts, madam. That is, lands were acquired by the state under the provisions of KD Act, madam. There are two modalities under the KD Act, payment of compensation. Under section 29, the
Court calls it a judgment.
so it is, if it
Page
is a
number
judgment,
19.
madam, then there must be a decree, draw the decree. If a decree draw, madam, appeal lies, madam. If there is no decree.
So if appeal doesn't lie, it will 115 lies.
Yes, ma'am.
How?
No, it's an order passed by this subordinate to this honorable court, madam.
What is 227?
227, there was a writ can I can file.
Huh?
If it is, madam, interim orders are filed, they passed, madam. It is a final disposal, madam. Therefore, revision is maintainable. It is my submission. It is not an interim order. It's a finally decided, madam. Section 115.
Give the Land Acquisition Act.
Section 115 is very clear, madam. The CPC.
No. Right to fair and then next fact. Fair compensation, transparency, and all that. If he has a book, take.
Yes, ma'am.
A right to fair compensation. Right to fair compensation.
Yes.
Good.
It is analogous to parameter of old 18(3)B, madam.
I think Sumna Naganand or somebody is appearing for the respondent.
But a respondent, the contesting is a first respondent. Second respondent, BM Marcel, Mr. A. Ravishankar is
She's who appearing?
Mr. A. Ravishankar is appearing.
Appears with the second respondent.
The second respondent.
The issue with regard to the maintainability is kept open. Second respondent, so and so.
The first respondent, a private party.
So and so is right to
Notice
take
us.
notice. For the second respondent, issue emergent notice.
Not for interim order for this.
What is interim order?
Lord, Your Lordship kindly see, they received the compensation page, Lord, 48, under section, consent is received the compensation. There is a specific clause, page 142, my Lord, Your Lordship kindly see. Now, my Lord, by virtue of this, they will initiate contempt proceedings against me before reference court. Therefore, I have to refer the matter. Therefore, interim order starts for me.
What is the contempt in that?
There is a direction to refer within 60 days. If now want to refer it,
First respondent.
Against me, my lord. I am the land action officer. I am the land action officer. Petitioner, land action officer. There is a direction against me.
Then counsel for the petitioner submits the right of receiving the compensation under consent. Now the court has passed an order to refer the matter to the civil, so to refer the matter, to refer the applications of the respondents dated 21/3/2018 and 4/4/2018 to the court for determination of the proper and fair market value within 60 days from the date of the order. Considering the submission, there shall be stay of operation of the order dated since.
Cell number 70.
My lord, in this matter, I beg to appear for the petitioner. This petition is by the defendant number 8 in the suit. The suit for partition and separate possession. Insofar as maintainability is concerned, my submission is, my lord, the compromise decree was called in question. Recall application was filed before the same court, which is permissible, and by the minor defendant number 8 upon attaining majority. That application came to be dismissed by the impugned order, which is at page 20, a cryptic impugned order. That's the effect of deciding the rights of the parties conclusively. Therefore, CRP is indeed maintainable, is my respectful submission. It decides the rights of the parties conclusively insofar as those particular properties are concerned. Hence, CRP is maintainable, perfectly within the parameters as contemplated in section 115 of CPC.
What is this order?
It's a cryptic order, my lord. There is no consideration at all.
No, what is your IA? Your IA is to separate the compromise.
IA for recalling, to set aside the compromise decree, which was entered into by the parties, and I was represented by my next friend.
No, it was entered into before which authority?
Before the trial court. Before the trial court in a suit for partition, there was a partial. Before the local, partial partition was there. The partition, compromise petition was filed before the court, and compromise was recorded. And thereafterwards, I filed an application to recall that order, set aside that compromise on the ground that
Can that be
the mandate by way of an application, which is the correct procedure for I have to go before the same court if I am a party to the proceedings. Therefore, my lords, CRP is perfectly maintainable because the rights of the parties are conclusively decided insofar as the properties are concerned. That is regarding maintainability. On the merits of the case, my lords, is a cryptic order. There is the mandatory requirement as contemplated in 32 Rule 7 that an application supported an affidavit of next friend.
Objection with regard to maintainability is overruled. Notice to the respondents.
Let's further proceedings before the trial court state.
No. Yes.
Cell number 71.
Very great.
Dr. S. Armugam.
Yes, my lord. Here I have filed a suit for partition claiming 1/7 of my share. 7 persons have been made as the parties who are the co-owners. I got the interim order of status quo that the status quo order was after hearing passed. Both the parties has to maintain the status quo. Now, they have challenged it in the miscellaneous appeal under Order 41, Rule 1. And in that, the respondent has not made all of them as the parties. We are 7 co-sharers as per the plaint. But the appellant who challenged the order has made only one person, that is the plaintiff as the party. The order is both the sides should maintain the status quo. Now he got an order only against the plaintiff, not the other co-sharers, as if it is want of necessary parties. The order is that miscellaneous appeal itself is not maintainable.
You should have told the court that it is not maintainable.
No, that he won't hear because the thing is, the IA2 is allowed without hearing from the other party. From us, it is not at all heard. Our notice is not served. We have not appeared.
The order in question now.
But order?
Which order is in question? What is the date of the order?
That order is now stayed by allowing IA2. That is the order. It is decide the suit itself.
I'm asking which page number it is. Please tell the court page number.
Yes.
Page number, sir. Page number.
Order. Page number 13, my lord.
This is what I'm asking.
Well,
you can go to the court and you can file an application before the court. Why should you come here?
That is IA number 2 filed by the appellant is allowed. It is finally decided without notice. And accordingly, order passed in IA by first additional senior civil judge.
It has only
Court.
stayed till the next date of hearing. It is stayed till the next date of hearing.
Stay of what the status quo passed by the lower court. That order is there in page number 59. It is a very long order, and in the operative portion is 59, page number 59.
Maintainability is kept open. Notice
It
to the
reads,
respondents. Yes.
72, 72, 72.
that also same, because it is
Notice we will say.
both, it may be,
Cell number
Yes.
73.
My lord,
Himantappa Haravi.
petitioners, my lord, the petitioners are borrower from the first respondent regarding 3 lakhs rupees. There was an award against the petitioners, my lord, 5,85,070. Now,
order.
annexure G, my lord, annexure page number 60, my lord, is 16. Page number 16, the court below issued a warrant against the petitioner, my lord. Page number 20, this is the award amount. Page number 20, 5,85,070. The petitioner undertakes to deposit the 50% amount with the trial court within 2-3 months, my lord. The remaining amount is next, my lord. The petitioner undertakes to deposit the 50% of the award amount to the trial court. Meanwhile, the short
What
increase
is the amount?
5,85,000. 5,85,000.
The decree.
When
was the judgment and decree?
17th, my lord, May 2024.
Hmm.
17th May 2024.
Hmm.
The now filed the execution proceedings, my lord, before trial court.
What is the amount in the execution?
That my lord, 5,85,000.
It's a decretal amount or the amount of the
3 lakhs, my lord. Decretal amount 3 lakhs. The entire amount, my lord, 5,85,000, with including interest.
How much you will deposit?
On 20%, my lord, it is. 20%, my lord.
I heard it correctly. You said 50%.
Sorry. 50%, my lord, economy. Within 3 months, remaining of 3 amounts, my lord.
The land counts for the petitioner. The land counts for the petitioner submits that the court, without even recording the reasons, has issued a arrest warrant. It is submitted that the petitioner is ready to deposit half of the amount, considering, and it is submit, and the amount is 5,85,000. Considering the same, the petitioner shall deposit half of the amount within a period of 4 weeks from the date of receipt of the copy of the order. If the petitioner fails to deposit the amount, he shall pay cost of rupees 1 lakh.
Great.
Notice to the respondents, hand summons.
My lord, short hand delivery, my lord. Great.
Hand delivery not possible, that will be uploaded.
74. Maya Holla, KV Satish, the respondent.
My lord, respondent, my lord. The case is posted for our judgment, my lord.
You are for the petitioner or respondent?
Respondent. The suit is posted for the judgment, my lord. In lower court.
Non-adhering of 73, what happened to 70?
73.
Issue 3 weeks time, my lord.
It doesn't mention about a letter. Cause list.
74.
No, sir. 74. Let this address for the learned principal citizen or session judge seeking extension of time. It is stated that the earlier a coordinate bench of this court as directed to dispose of the matter within 6 months.
My lord, 3 weeks, enough, my lord. Because of his posted for judgment.
Months, and it would expire on 31/7/2026. Then judge has cited various reasons and sought for another 6 months time for disposal of the suit. Now it is posted for
Judgment, my lord.
when?
14/7.
14/7.
Yes, ma'am.
And counsel for the petition respondent submits that the matter is posted for judgment. Hence, hence his court is granting 3 months time to dispose of the matter.
3 weeks is enough, my lord.
She's asking 6 months. We don't know what is the difficulty. 3 months. Yes. Yes.
230 mention matter. Cell number 112. 112.
No, where is our CRP? That pronouncement of orders here.
List number 3. Cell number 1.
Land counsel for the petitioner submits that the court.
The opposite side, they want to amicably settle the matter.
Huh?
The opposite respondent, they want to amicably settle by announcement of rent. So your lordship may kindly issue the notice, and respondent counsel, I am also representing his own brother-in-law's case. So your lordship may kindly issue the notice, we will report the settlement.
Land counsel for the petitioner submits that there is a likelihood of
Stay
settlement.
may kindly be granted regarding voluntary.
There is a likelihood of settlement. Further, it is a case that when an application is filed under 21 Rule 97, court has failed to independently consider the right set up by the applicant, and the court has also failed to consider the case of the petitioner in the light of the order passed by a coordinate bench of this court. Considering the submission, there shall be stay of all further proceedings pursuant to so and so. Notice to the respondents, petition is permitted to take out hand summons.
Your lordship, I will. Stay may kindly. I will.
Cell number 112. Mention matter. Cell number 112.
Let the petitioners are wife and husband. They purchased a piece of land in the form of house site in survey number 7/8 of Kumbena Agrara village,
What is
Bidirelli
this letter
Hobli.
dated 17/6/2026? Letter dated 17/6/2026. That is what is question.
Letter, Annexure J.
26.
Annexure J dated
Page number?
page number 45, my lord. 17th July 26.
What is this letter?
Lord, they have demanded the petitioners to produce NOC from KEB, GBA, so as to continue the temporary power supply to the building, which
GBA
is
means?
temporary.
GBA means?
GBA means Bangalore, Greater Bangalore Authority.
Hmm.
So,
When
yes.
is when was the construction?
so construction was undertaken in the year 2023, my lads. So power supply was sanctioned, temporary power supply was sanctioned, and thereafter another 15 kV of temporary connection power supply was sanctioned as per Annexure H, and the building as per Annexure G, my lad, it has reached completion stage. Now at this stage, they have issued this notice, and
Yes,
on the
Mr.
day of,
Devraju.
Let him.
You appear for?
I am Rescom.
Yes.
Let him give his reply to the notice, my lord. Consider in accordance with
For this NOC.
the, as per the order of the Supreme Court, my lord.
Supreme Court is prospective.
Yes.
That's why I asked him when is that? And there is the judgment of Justice Suraj Govindaraj where he has clarified on that.
They have issued.
No, you can't insist for that. Use the mic, I can't hear you.
Temporary power supply was sanctioned for the purpose of construction. Where that construction is made without license, without plan. The BBMP issued a letter intimating us so far as that without construction, they are constructing the building.
Without permission.
Without permission.
But then what did they do?
That we have intimated, obtain NOC from the BBMP, we will so far as continue temporary connection.
If he has making construction without permission, they have to follow some.
That they have to follow.
What did they do? They issued a
they
notice.
have not
to you?
even issued a single notice so far.
They have a party here that they have to say that.
So, because they will send a communication to you, you will disconnect the power supply.
They
will not do
said that
anything.
in the notice that they have issued a 311 and 12 notice for the demolition order also has made. That is that they have said in the notice. The
Order is not yet communicated to us, my lord. If such an order is communicated, we reply.
You made the Westcom a party.
Hello.
BBMP as a party, ma'am.
Who appears for BBMP? Let that council come, will see.
Yes.
Who are the councils? BBMP.
Third respondent. Pawan Kumar is up here.
Mr. Pawan Kumar is director to take notice on behalf of.
The notice was already ordered, my lords. We have already
Name is
served
there.
copies.
PL Sanjeeva Faratri.
Sanjeev Paratri.
Pawan Kumar Faratri. Where is he? Why is he not representing? Have you informed him that the matter
Please, my
is
lord,
taken?
we have served the copy also.
No, today, is he aware that the matter is taken up at end of the list?
Today only his name has come in the list, my lord. That's why.
List this matter at 2:30. Tell him to
I'll
get
intimate.
instructions by tomorrow. Tomorrow is Friday. List this matter at 1 o'clock.
At 2:30 may kindly.
1 o'clock. 87?
Well, serial number 76 was mentioned in the morning.
No, she'll call the matters. Why everybody is mentioning? I don't
No, out
understand.
of turn, it was taken a bit above estimate order. That's why I made a mention.
He'll call.
I will
Why are you not calling in line the mentioned matters?
Yes.
Mentioned at 76, it was mentioned, my lords, in the morning.
I came running, your lordship. That's why, my lord. It was going on. 73 was going on.
No, it is over. Now those matters are over. Now I'll not be calling them. Now only the 2:30 matters and mentioned matters I'll take up now.
Oh.
Yes.
87 matter at least tomorrow, your lordship.
It will be there in the list.
Grateful.
Yes. No, yes, take that.
Number 113.
That I am relying on the judgment of the Honorable High Court. Bench matter.
This writ petition, you have to go, you have to file a writ petition under 220. Take that.
Honorable High Court judgment I am relying.
Bench ruling. What your lordship, page number 42, madam.
Yes.
Para 42.
Para?
Para 42 onwards.
Yes.
I have put a flag on it.
Yes. Yes.
Two judges of the Andhra Pradesh High Court
Hmm.
ruled the only question that falls for consideration is whether district forum have acted in excess of judiciary illegally or with material irregularity.
That's what it said, red petition and under Article 226. This is what the
Further,
judgment says.
my lord, even regarding, no, 115 there is a discussion, my lord. 115 there is a discussion. That's why
Okay, just listen to the court. How can a consumer forum be a court subordinate to the High Court? Is it a court?
This is also between this consumer forum. Not make any.
I am passing an order
Para-
under
para-
Article
para-
226. You can question it. You please question it.
For a moment, your lordship, for a moment, this is between the consumer forum and this only. The Andhra Pradesh High Court.
It itself is there. You read the head note. Have you read the head note?
It is true, but on the contrary, regarding mental revision is also mentioned. That's what I'm saying. For a moment, your lordship kindly peruse the order.
Yes.
The history.
Yes.
The history recent legislation in India shows that the legislature passed acts.
Which para you are reading?
After 43, para 43.
Yes.
After para 3.
This is the judgment of the
Socioeconomic
Supreme
matters,
Court.
socioeconomic matters are made provision for levy to sell and so on. So, opportunity province legislature difficult problem of construction and sometimes the act questions provide for usual application to the High Court. In the respect of such matters or authorities, references be made to it. In such a case, the High Court will undoubtedly deal with the problem raised by the construction of the relevant provision in accordance with the extent of jurisdiction conferred on it by the material provisions contained in the statute itself. Sometimes, however, no such specific provision is made, and the question raised in regard to the construction of provision of such statute reach High Court and under its general revision 115, the court can exercise it. Further, observe that the High Court must inquire whether the complaint made against the decision of the subordinate court on the ground that it is misconstrued, irrelevant provision or the statute attack the provision under section 115 of CPC. Here also the warrant is, even though amount is deposited, ED has been given, madam.
Yes.
ED has been given.
The present, all the three writ petitions are common order. The present writ petitions are filed. The three writ petitions of all the writ petitions are filed. Agreed with the order passed by the District Consumer Dispute Redressal Commission in execution number 10, execution application number 107 of 2022. Issued to the, it is not, it is by the Consumer Redressal Commission. Against this order, the petitioner has filed a CRP under 115 and he relies on the judgments passed by
2009 Supreme Court.
Supreme Court in AR 2009 SCC 930 and also a judgment of the Andhra Pradesh High Court in AR 2004 Andhra Pradesh 49 in case of Mrs. Megacity Builders versus AP State Consumer Dispute Redressal Commission. CPC.
Section 51 may kindly be taken. Section 51.
Under section 151 CPC.
One 115 of the CPC.
Section 115 is a revision. If the High Court may call for the records of any case which has been decided by any court subordinate to such High Court, in which no appeal lies thereto, and if the subordinate appears to have exercised the jurisdiction not vested in it by law, or to have failed to exercise jurisdiction vested to it, the Consumer Forum is not a court subordinate to the High Court, and the CRPs filed under 115 before this court are not maintainable. Hence, the office objection with regard to maintainability is sustained and petitioner shall avail the appropriate remedy. Yes.
Liberty may kindly be used.
Yes, next.
Serial number 76, I had informed in the morning itself, my lord. The lordships had said if it doesn't reach, maybe mention. 75 it stopped at, my lord. 76 payments are to be made by the petitioners, please, my lord. They are also present here,
Well, yes, next.
please.
230 mentioned matter. 230 mood matter. Aditya Chatterjee for petitioner.
No, this 117 also called 230 matter. Some report is received from the judge.
117. Vandana PL 230 matter.
My lords, there's a speaking order, my lords. In the last date of hearing, the petitioners had challenged that there was no reasons assigned. Then my lords had called for report, and there is a speaking order, my lords.
That is the petitioner. Where is that report?
They have to challenge on merits, my lords. As of now, the current petition is only for non-production of reasoned order. Lords, if I may.
Yes.
My lords, they have challenged Order 3, Rule 2, my lords. They are questioning the authority of the executing personnel, my lords, who have initiated the execution proceedings, my lords. The said proceeding is in the year of 2005, my lords.
No, anyhow, this order is available now.
Yes, my lord.
2026 order.
Yes, my lord.
Let him file and I'll hear the matter.
Yes, my
This court has called for report from the concerned judge. May, considering the submission of the and answer the petitioner, when the order is not uploaded, various reasons are stated why the order is not uploaded with the court. Now it is submitted that it is uploaded and they'll monitor the same. Then counsel for the petitioner shall file the same for the court. Does this matter on 13th of August? Yes.
Amended petition.
Serial number 230.
My lords, I may be permitted to take further steps with respect to attachment, my lords. They have only questioned, this is a procedural lapse, my lords. Substantial law is already defeated by apex court.
Not there. How will we decide all that? Yes, call the next one.
For the petitioner. The impugned.
I've been served a copy today.
We filed it this morning and moved it for urgency.
File in the morning, the matter shall be reached by afternoon.
Please, minutes. I'm so sorry the background is that the client had engaged a lawyer who in June 2025 filed a retirement memo, which was rejected on the ground that she was.
Ready?
I'm sorry, my lord.
You're ready?
I have to make certain submissions because this, my lord, this has a very checkered history.
At the petition will do. I only asked, are you
My lord, I'll have
ready?
to file my objections.
Yes.
It's an order of 7/7/2026.
The order that has been
The
passed.
No, sometimes give opportunity.
I'm sorry, my lord.
to
I'm sorry.
others.
I'm sorry. I'm sorry.
Yes.
The order has been passed under Order 16, Rule 6, in a suit for civil defamation, summoning my CDR records of 3 phones, directing the jurisdictional police to go to the service provider, get my CDR records for 18 months, out of which 16 months are during the pendency of the suit, from November 2025 all the way back to May 2024. All my CDR records on the ground that he was not able to mark some documents of screenshots that he produced. The CDR records contain my whereabouts on every single day in those 18 months. Every person that I have called, every person I have sent an SMS, but they don't have the contents, obviously, of the messages that I have sent or the phone conversations that I have. Therefore, there is no circumstance in which this CDR.
Is the order?
No, the order is at page 41. No analysis at all as to how this is relevant to his suit.
Let's see the order.
Starts at page 41. Sorry, may I pause for one moment to give one more fact of background. What the petitioner and the respondent had a romantic relationship in 2009 to 2024. That relationship broke up, after which I was made the subject of harassment at his hands. I filed an FIR.
No. Is it the matrimonial
19.
matter is also
It is
there
not.
pertaining to this?
Nothing at all. It's
I
a
filed an
political matter,
FIR.
nothing more.
I filed an FIR regarding stalking and harassment at his hands. That was published by certain newspapers. They pick up the FIR and publish it. On that basis, he files this civil defamation case and starts harassing me from May 2025. In that background, this application is filed saying summon all of her CDR records over the course of 18 months. Page 41, the impugned order begins. May I read once?
The aforesaid call detail records are material and necessary for the just and effective adjudication of the issues involved in the suit.
With absolutely no analysis as to how it can be material, because all it will contain is a phone number of every person I have called for 18 months.
Where is that IA?
The IA, your lordship. So.
Take that. Yes. What did he say in the IA?
That's the application is for production of documents before this court in respect of providers, service providers of phone numbers so and so belonging to defendant number 1 to produce soft copy of the CDR between the period from 27th May 2024 to 26th November 2025 in pen drive. The first 3 pages deal with the background of the suit. Para 6 at the last sentence, purpose of seeking the CDR of defendant number 1 is to adduce evidence before this honorable court as to the conduct.
I couldn't find.
Page para 6, my lords, I'm so sorry. Last sentence, purpose of seeking the CDR of the defendant is only to adduce evidence before this court as to the conduct of defendant number 1 in defaming me and bringing CDR on record. I submit defendant number 1 defame me by spreading false information through news media against me. Further, the defendant also, number 1, also went to the extent of reaching out to my friends, family from BJP, even my advocate, making false, illegal and defamatory statements. Then the last sentence of that para, by bringing on record the CDR, I intend to divulge the defamatory conduct of the defendant number 1. I submit at the time of leading my evidence in the suit, I attempted to produce certain screenshots with an intent to establish my case that defendant number 1 had been contacting me and my acquaintances prior to the initiation of the present suit. And also there being a temporary injunction operating against her, she continued to contact them. Unfortunately, the screenshots available with me does not satisfy the requirement of admissible evidence. Therefore, I am now seeking this honorable courts may be pleased to direct the service providers of the above mentioned phone numbers belonging to defendant number 1 to produce the CDR of defendant number 1 to support the present suit. Those CDRs do not contain the information that he mentions in para 8. I've produced the Department of Telecommunications. What is the content of a CDR? Your Lordship may kindly see that at Annexure T, page 315. Highly invasive private information of the petitioner, which can have no bearing at all on the suit. In supersession of letter number 1, letter number so and so on above mentioned subject, undersigned is directed to convey the approval. The next page, from page 316 onwards, serial number 8, call initiation time, serial number 9, call duration, serial number 10, first BTS location, brief description of location and mark. Serial number 12, last BTS location. 13, last cell global ID. 14, SMS center number in case of SMS MMS. Service type, mention voice call. IMEI number, call forwarding number, providing the call forwarding number in case of call forwarding. Roaming network circle, providing the name of network and circle. For the last 18 months, every single person that I have called, every single message that I have sent to my personal friends, to my family, to anybody that I know, is being brought on record without any justification whatsoever. He is claiming of defamation in certain messages to him. Please.
May I make my submission, Madam? prior to this IA, my lord, two other IAs were filed. There's also, my learned friend did not read what was there in the previous two paragraphs. Airtel was summoned, my lord, as far as these records are concerned. Two IAs were already filed, IA number 5, IA number 6. Airtel came with this record before the Honorable Trial Court as well. That CD was broken. Now, my lord, how efficient they are, my lord, that's a different aspect altogether. IA number 6 was filed. Again, they were summoned, saying that please bring these documents on record. And my lord, it's not 18 months as my learned friend would say, it's about 10 months from what I could calculate. Now, my lord, there's a history to this. My lords may kindly see there's an interim order passed in this in this very case, my lord. Interim order says you cannot, may I just take my lords to the interim order, they've only produced it. Why I had to emphasize on this is, my lord, this is a political, my lord, it's purely political, nothing more. They had previously filed a police complaint against me. The FIR was quashed, 2 complaints. Please, why I had to file this also is very important, my lord. My lords may kindly see page 45, my lord. Page 45, page 46, the order would start.
Yes.
Please.
Yes.
If my lords were to kindly see, the plaintiff filed so-and-so injunction restraining the defendants from making, uttering, speaking, writing, relaying so-and-so against the plaintiff in print media, newspapers, magazines, so-and-so. I'll skip all of that, my lord. Another means, or even circulating the FIR and crime number so-and-so produced as Annexure L and news articles on 3/6/2004 and 5/6/2024 produced as so-and-so through means of mass communication such as emails, social media. I'll skip all of that. The plaintiff filed IA number so-and-so, my lord, seeking an order of ex parte temporary injunction restraining the defendants from contacting the plaintiff or any relatives, acquaintances, family or friends, officials from BJP and making false, illegal, defamatory statements against me, be it against him, be it in person or through calls or so-and-so. I won't trouble my lords by reading all of that. Why this had to be done is, my lord, initially we had a gag order as against the press. Because what happened, my lord, there were certain publications made. This FIR was being circulated. This FIR was being circulated not at anyone else's behest, but at the petitioner's behest. Now, what happens one day prior to the FIR being registered? My lords may kindly see. Today, my lord, it's very convenient for them to come and say that please don't take my CDI records. CDI records were pulled out by them of mine. My lords may kindly see. I will take my lords. It's a document produced by them. My lords may kindly see page 224. This is a chat between, my lord, the respondent and the petition number 2. That is the brother of petition number 1. They say there was a romantic relation. There was no romantic relationship. It was purely a civil dispute. There are observations made by this honorable court where the entire process has been abused, my lord. My lords may kindly see. This is on 223, if my lords were to kindly see. 223, 224, their own document. I was an MLC candidate, my lord. I had a ticket ready also for to contest in the MLC, on a ticket, my lord, from BJP. If my lords were to kindly see 31st May 2024. My lords has, my lord, towards the bottom. Sir, Shashi has information. Shashi is petition number 1. Has information. She has also kept your phone on tracking and has all lot of records. At present, you are in Bangalore only, so stop telling about Delhi meeting and stories. Take your time to pay money, that's okay. But don't create stories around it. Yes, she has not left a demand of meeting her family and talking this matter, and we support her in this. My calls were on tracking record, my lord. CDRs of mine was pulled. On 31st May 2024, this was done.
Oh, but now the question is, let's
Please.
not go into all that. What is
Please.
relevant for this, to decide this application?
Please, my lord.
Why do you want?
My lord, I want this because despite the interim order being passed, my lord, she still continues and this goes right to the top, my lord. It goes right to the center. Central ministers have been contacted by her.
So,
Please.
you said in your application,
Please.
that what is the purpose, for the what purpose
Please.
you wanted?
Please.
You said you want that your screenshots, which you are not
Not
able
screenshots. Screenshots will not meet the admissible evidence, my lord, because screenshots I have. That, my lord, I cannot give it
to. Can you
65B.
get, by this?
I'm
by
not
this,
asking
are you
for
able
that.
to getting?
I'm only saying, my lord, so what my learned friend, in fact, I'm very grateful that my learned friend produced Annexure T. Annexure T will only say who she is contacted. I only want to show that, my lord, she's contacted
But
those
you
people.
didn't say so in your affidavit. That's
My lord,
not
my
the
lords may
reason.
kindly see. I cannot because as far as defamation is concerned, as far as my lord, no.
No, what did you say?
Please.
Only para 8 is your.
I will just read that. I'll just
I
read that.
submit that at the time of reading my evidence in the presence, I attempted to produce certain screenshots with an intent to establish my
Please.
case. The defendant number had been contacting me and my so-and-so.
Please, my lords may kindly come to my lords may kindly come before that itself. Initially, what I've said, because all of this is there's a precursor to it, my lord. If my lords were to kindly see paragraph 3.
This is about what has you stated in the plaint.
I'm sorry, my lord.
What you have stated in the
No,
plaint.
no, no. My lords may kindly see, my lord, paragraph 3.
Yes.
Further, this honorable court was pleased to restrain the defendants by way of temporary injunction from contacting me or any of my relatives, family, so on so on. So this was the intermodal passed. Now, my lords, may kindly see why I had sought for this.
That's at paragraph 8.
Paragraph 6 also, my lord.
Nothing.
Paragraph
Just say.
6 and 7. I'll just read this again, my lord. Please, I submit that defendant number 1 defamed me by spreading false information through news media. Further, defendant number 1 went to the extent of reaching out to my friends, so and so, making illegal, which I intend to submit by substantiating the screenshots of various chats, call details, and other. So they also call details, my lord. So which is why what I'm trying to show is, I'll just read. And other electronic communication which took place between defendant number 1 and me, as well as my friends and family. By bringing on the record, the CDR, the defendant number 1 intends to divulge the defamatory conduct of the defendant number 1. I submit that at the time of leading my evidence, I intended to produce certain screenshots with an intent to establish my case that defendant number 1 had been contacting me and my acquaintances even prior to initiation of the present suit. And also, despite there being a temporary injunction operated against her, she continued to contact them. Unfortunately, the screenshots available do not satisfy the requirement of so and so, so and so. Despite the interim order being there, I am still never getting calls. My acquaintances are getting calls.
Should her entire data be before the court?
I am not asking for the chats to come. I am only saying, Malad, the call detailed records during this relevant period to show that she's contacting.
Why should it be? That will not decide your dispute.
Malad, then the entire purpose of me getting an interim order is also defeated. I will just take my lords to the observations made by this honorable court itself in my lord, the criminal petition. My lords may kindly see why this is important. Initially, my lord, on 31.5, I've shown my lords the chat where they are tracking my details. They have the CDR. That's an admission made by them.
I'll hear it on Tuesday. We'll stay the operation of the order.
My lord, as far as this is concerned, then my lords may have it tomorrow. I'll file my objections because as far as this is concerned, there is a reason, my lord. My lords may kindly see.
I'll hear you.
Then, my lord, may I just point out this one aspect? If my lords is to pass any order, may I just point out one aspect? Because this has culminated in something where there are 3 complaints. I will just take my lords only to the observations made by this honorable court. May I just point out, they themselves have produced it. My lords, may kindly see page 96. No, I will try
Take
to.
it on Tuesday, it's fine. Or else
100.
I have to pass a final order today itself.
I'm sorry, my lord.
If you take it on Tuesday, there is a chance.
My lord, chance is, my lord. Now what happens?
It has to be today. I have to, with the same, whatever is my thought process now, I will pass an order.
My lord, but if
I'm
my lords were to kindly.
Giving you a chance.
I understand, my lord. May I just.
You better take it on Tuesday.
I will try to just convince my lords in 30 seconds. Otherwise, I'll stop.
If I hear it now, then I have to pass orders. The same what I indicated that I'll pass a final order. We'll set aside this order. If it is on Tuesday, at least I'll stay operation till Tuesday. Tuesday, I hear you. Choice is yours.
I was just served it now. I've come with whatever ammunition
This
I
is
have.
matter on Tuesday. Land counsel for the petitioner submits that by way of this application, the entire data pertaining to the petitioner for a period of 10 months.
18 months, my lords.
18 months is directed to be placed on record. This court as per its order, considering the submission. Then heard the land counsel for the respondent, and he opposed the same and submits that. And he has drawn the attention of the court to the earlier injunction orders and also an application filed by the petitioner. Prima facie, this court is, I'll not say anything of that. Till as a matter is coming up on Monday, in the interest of, in balancing the interest of both the parties, this is matter on Tuesday. Till such time, the operation of the order is stayed.
Deeply grateful. I'll file my objections.
Take that. And that also, 76 also.
Cell number 76. Cell number 76.
Lord, maybe permitted to.
No argument.
No, no, I'm ready. 10 crores DD is ready, Mr.
Yes.
Maybe permitted to deposit that.
Deposit where?
To the court.
Was it directed to be deposited before the court?
No, my lords. No, my lords.
Given to him.
We handed out to me.
Why will you deposit before the court?
That is the reason I'm seeking permission, my lord.
Yes. I'll record it that you have given the DD.
Yes.
Yes. Then what is the order?
My lord, next is, they were supposed to release 702. Next,
With regard to the remaining amount, land counsel, the respondent shall come up with the calculation, not, and on that day, an order will be passed with regard to the payment of the remaining amount.
My lord, I'm filing the memo of calculation also. Next payment, I had, as per my affidavit, I'm supposed to pay 5 crores, my lord. From today, 1 month, my lord. I'll pay it.
No, my lords. This 10 crores, what they have done, they're not paying it to me today. They are handing it over to this honorable court.
Take it, we.
In the name of the court, it is taken.
Why?
My lord, I've taken the.
My lords,
demand of the
what
name
they
of the
do,
court.
my lords?
The reason is, my lord,
But,
the
my lords-
review petition was filed, it was on 4th August, my lord, and it is posted for order.
No, my
But
lords.
there is a deposit before it is posted.
Supreme Court. My lords, what they do, my lords?
Vacate the order.
No, my lord, there is no interim order, my lord. I'm
That order I will recall. Earlier
No.
order I have passed. Why, what is this,
My lords,
what's the conduct of the petitioner? Payment is supposed to be made to him. Why should you take it in the name of the High Court?
they have the money, they don't want to pay me. They, my lords, take the orders of this honorable court, sell 2 flats. My lords, for the last 1.5 months, I've been running behind them for all this. My lords, there is absolute no cooperation in the apartment there. Everybody is instigated. Cases after cases have been filed. Logs of the associations have been taken. The clubhouse has been unauthorizedly taken over. The dues are not getting paid. My lords, I am subjected to harassment after harassment, please, my lords. This is the conduct. He has the money. He sold the apartments after taking a lordship's order. He doesn't want to pay me, my lords.
After handing over 2 flats, it has been sold on Monday.
Now, my lords, they come with the DD in the name of this honorable court.
It is.
Petitioner shall hand over the demand draft for an amount of rupees 7 crore 50 lakhs
That is
by
been done.
tomorrow
That is
afternoon.
done.
Then, after payment of rupees 10 crores, further orders will be passed.
The 10 crores DD is ready, my lord.
Why did you take the DD? Did the court say that you should deposit before the court? Then why did you take?
I'm seeking permission, my lord.
What permission? I don't understand.
I'll get it changed. I'll have it on Monday.
No, my lords, let them do the RTGS tomorrow morning, please, my lords.
Yes.
Let them do the RTGS tomorrow morning. No more, my lords, concession, my lords. I am in execution.
My lord, self-review petition was pending. That is, the order will be pronounced.
So you will be like simultaneously, you'll be pursuing here, you're
My
pursuing
lords, they
there.
file an affidavit undertaking to pay the entire amount.
I will not abstain from paying the money, my lord.
Then,
I will be depositing in the court, my lord. I am not saying I will not pay the
you're very
money.
unreasonable, Mr. Counsel.
I will
Tell your party.
I'll
Yeah, don't try to be too smart.
tell him. I'll tell.
Why did you take the DD on his name? On the name of the court?
From the Delhi lawyer that there is a pending, review petition is pending, so until then you can deposit in the court, I think, that was it.
Why this advocate can't advise you? Who is representing you here?
That's okay, well, we'll get it changed. I'll get it
We will
changed.
change it.
No, my
For
lords,
itself.
If you instruct, we will change it.
Yes.
your lordships had instructed
There
already.
is no question of instructing.
Yes, ma'am. We'll do it. We'll do it.
You have to understand from why the order can't you read? Why the interpretation is required from the Delhi advocate?
I'm sorry. That's what I told. Anyway, madam, if I get the
The petitioner, this court on this matter came up on 31/7/2026, wherein the day they are supposed to pay 10 crores. When the petition has failed to pay the same as per the undertaking affidavit filed before the court, this court has passed an order that by 6/8/2026, the petitioner fails to place a demand draft before the court, the writ petition will be dismissed. Very surprisingly, the petitioner gets a demand draft in favor, in the name of the
opportunity. I'll give
High
it
Court.
tomorrow, etc.
The conduct, this shows that the petitioner's intentions and conduct are not correct. By tomorrow, if the TD is not handed over to the respondent, the order dated, when is the date of the order?
24/6.
The order dated 30?
24/6. The correction to
The
the
order
order
dated 24/6/26 is stands recalled.
And my lords, the trial court may be directed to proceed with the auction of the
tomorrow
properties, please.
it is
That case.
If the amount, if the DD is not given, the trial court is at liberty to proceed with the matter. If the amount is paid, the list is matter on 12th of August.
My lords,
11th, etc.
11th.
11th.
my lords, in the meantime, I was asked to file the memo of calculation. My memo of calculations are
Yes.
ready, please, my lords.
Then counsel the respondent
Sir,
has
I am
filed the
also
memo of
filing the
calculation.
calculation.
Then have you served on him?
I'll serve it. I'll give it to you. That is not served to me.
I'm seeing you from afternoon. He also here. Why can't you serve him that?
No, my lord, I was trying to deposit to the court. That's the reason I couldn't serve. Now I will deposit.
I don't understand the strategy.
I've given it.
Both the counsels have exchanged the memo of calculation. Yes, you can submit on the next date of hearing.
Please, my lords.
Yes, call that matter.
Sign ಮಾಡಿದ್ದೀರಾ? Sign.
Oblige.
ನೋಡಿ sir, sign ಮಾಡಿದ್ದೀರಾ?
Yes.
Cell number 31, list number 2.
Where is he?
Good end up.
Respondent bank.
And
Lord, in
for
this
the
case,
petitioner,
Lord, we have.
they've not
yes.
complied with the orders of this.
No, no, my lord, let me explain. We have in fact, my lord, initiated the process of release, my lord, because the original documents are with the CMM court. In fact, we have written to sent a mail to the petitioner, my lord, yesterday. And in fact, the manager has contacted the petitioner. The petitioner will be coming tomorrow for receiving the original documents.
Thank you.
So, yes, my lord, so we have complied. My lord, I filed an application seeking a direction. My lord, specifically on 5/12/2025, the petitioner had undertaken to furnish a survey report. That has not been done. What has been furnished, my lord, is a survey sketch as per their own objections that they filed. My lord, my problem is, on one hand, we've been releasing the property. On the other hand, under the auspices of this court, valuation was conducted. But unfortunately, without a survey report, the valuers are not able to, in fact, assess the building also. Because there is, let me just complete. Yes, my lord. Because there is a apprehension that the buildings have not been constructed wholly within the survey number, my lord. And so survey report is very much essential for us to even proceed further with surface measures. In fact, my lord, on one hand, they claim to, they have in fact undertaken to pay the entire dues. They have written us letters. On the other hand, they are proceeding before challenging the measures before DRT. Of course, they are entitled to. But what I'm saying is this approbation and reprobation, my lords, has done equity to them. All is an extending equity to us, my lord.
My lords, in January of this year itself, we have furnished this survey report. It was placed before your honors. My learned friends, other counsel was
I
there.
understand.
That is that page number 7 of.
It's a sketch.
It's a survey sketch. They
That
only
is
said
what
it's
the
a
government
survey
has
sketch.
given. This was a specific requirement. This is what the government has given us, my lords. We may go to the government and I'll certainly cooperate with them because that was an immediate requirement for them back in January.
When will you furnish it?
January itself, my lords. I've placed it on record before this honorable.
What she is asking for a survey report.
Survey report.
When it will be furnished?
May I take instructions on it? It may be listed tomorrow only. I'll take instructions. I have no hesitation, my lords.
My lord, what
Because
they have, my lord, survey
was-
report.
And second, just one more point.
Listing the matter again tomorrow itself, something is not
I'm sorry.
acceptable.
My lords, and one more submission is DRT has stayed all the proceedings.
Whatever is the time, I'll grant.
My lords, DRT has stayed all the proceedings insofar as surface section. I'm not sure what they'll do with the report. Now, for a month, for a
They
period of
can't
2.
dictate. It's for us to deal.
No,
It has to understand the
if there's a stay in
saleability of the
operation.
property, my lord.
No, they can't have the survey report of that property. No, what is that report? What will you do?
My lord, survey report will actually give you a detailed POD and superimposition of the buildings on the survey number.
Now you have, by virtue of the order passed for this court, you have the property, whatever it is that is.
Yes, my lord, that property we are releasing, my lord. This is
redeemed
the other main property on which resort stands. That is the property. That's the only property left.
Where Vignesh Sethi appeared.
Yes,
that
that
there's
is
a
the only
stay in
property
operation
which is
as of
left
now, my
to
lords.
us.
DRT has stayed the entire surface proceedings because I've deposited certain amount of money and before the DRT. I'm not sure
No,
what
no,
they
I
do.
remember that.
Kindly,
That time, that is what you said, that you will conduct the survey.
Yes.
Survey was conducted, my lords, immediately as per
The report is not given.
No,
That's what
survey
she
was
is saying.
conducted by them. Government has also conducted survey and the sketch is issued. Now they're
valuation.
saying that some report is required. I'll take instruction, maybe listed in the next week. We'll cooperate, my lords, because no hesitation now.
I'll
There's a
say
stay
that
also.
you should furnish it by getting.
Certainly, my lords. I may be directed.
Where
to
is
take
that IA?
My lord, I filed the IA on 27.
IA number?
24/7.
24/7.
24/7.
IA number?
2 of 26.
Then counsel for the respondent bank has filed I number 2 of 26. Seeking a direction to the petitioner to abide by its undertaking given to the court on 5/12/2025 to furnish the survey report in respect of survey number 293/5, survey number 293/18, 293/24, survey number 293/31, survey number 293/34, old survey number 293/24 of Maggalu village, Virajpet Hobli, Virajpet Taluk. It is submitted that as per the order passed for this court, the petitioner has to furnish the survey report, and without the survey report, it would be very difficult for the respondent bank to deal with the said property. Then counsel appearing for the petitioner submits that he has placed the survey report and the survey sketch, but no report is given. Anyway, he'll take all possible steps to get the survey report. Considering the submission of the land counsel to the petitioner, this court is passed the following order. The petitioner shall take shall make all efforts and shall get the service, shall give the survey report to the respondent within
Government agency, 1 month time may be granted.
4 weeks.
And
4
also
weeks.
cooperate, my lord, cooperate with the respondent bank if the
And
respondent
shall
is
also cooperate with the respondent bank for what?
for the purpose of survey, my lord, because it requires even the respondent.
When there's a stay in operation, I'm not sure how they'll conduct the survey. When a government will conduct the survey, that is between me and the state. They will not come in between
My
because
lord,
I'm
but
still
then
the owner of the property.
We are the mortgagee, my lord.
No, I understand,
Excluding us.
but when there's a stay in
Yes, let
operation,
them
I'm not
cooperate.
sure.
Right, you're a beneficiary of the court's order.
Kindly, my lords, absolutely.
So,
I've undertaken
whatever
within 4
is,
weeks. Yes, my lords.
whatever is the order, this has to happen.
Kindly,
Isn't
my
it?
lords.
Pending
If they want to
rectification,
be
you
with
got
us,
you got a part of the property redeemed.
my lords,
So
we
many
are
things have
absolutely
happened.
grateful. That's why we will
You
cooperate,
have
my
to,
lords.
you have to complete this also.
Kindly.
This passover matter, the electricity matter is
The
one.
Till number 24, pass over BESCOM
Grateful.
matter. Till number 24.
Lords, I've served it on
appears?
BESCOM, my lords, and
Who served?
I've served it to Mr. Vinayak, your lordships
What
have
are your
directed.
instructions?
Yes. In this case, as per my information, Swami, they are required to approach consumer grievance redressal forum.
That he said, that I have already said he has a remedy, alternative remedy of appeal.
No, not alternative. May concern me. First thing is they are required to appear there. If they have any grievance there, they have to come here, because there their prayer will be considered by depositing
So
of 50%.
before, under 127, there is a remedy of appeal.
127? Yes, your lordship.
They already assessment is made. Now, according to them, it is not a remedy that there is a
127 they have not. 127 they have not.
Lords, one.
That's what I'm saying. He says it is not an effective, the alternative remedy cannot be a ground.
Yes.
But there is some manifest error in the order.
Yes, your lordship.
That's what he's submitting. Have you gone through that?
Just I saw the details from the, tomorrow can it be?
Lords, can I point out to your lordships this manifest error? Page number 89 is the translated copy of the order.
What is the
My lords,
imminent, what is the
22
immediate requirement of interim order?
My lords, my disconnection, electricity has been disconnected, my lords. I'm a software company.
When?
As
A
per
software
my
company,
information,
When they have disconnected?
my lords, 29th of July, my lords.
no, that is
29th
wrong.
of July. Electricity bill says 7th August will be the date of disconnection. They come randomly on 29th July. I asked them on what authority are you disconnecting this? They produce an internal communication, not even a notice. The code supply, the electricity supply code requires clear 15 days notice prior to disconnection.
Already it's been more than a week.
Please, my lords. My lords, he in fact even responded and even made some representation before the MD of BESCOM. None of that has yielded result. Therefore, I have come before your lordships. And I filed this on 31st.
My submission, Swami, as per the
This
no
is matter
disconnection,
on the top of
no
the list.
disconnection take place.
And according to the petitioner, tomorrow, according to the petitioner, the power connection is disconnected. According to the respondent, it is not.
No.
Lords,
According
I
to
have the copy,
respondent, the
Lords. I
power
have the
connection.
annexure. I have produced it on the basis of which.
I'll take up tomorrow as a first case.
Yes, Your Lordship.
Let him get instructions.
Yes.
Yes. Signature.
But serial number 33 passed over matter, my lord.
My lords, ma'am.
I said passed over will not be called. Like you asked for pass over. If I pass
No,
over,
my
it
lords,
will be.
petitioners asked for passed over matters. I had moved the matter for the respondent. There is interim order in their favor, my lords. They took for pass over, my lords.
So it will come tomorrow.
My
Tomorrow,
lords,
my lords.
serial
The
number
same stage, my lords.
My lords,
My lords, serial number 117, my lords. It may be
One
listed.
request, my lords.
Entry order extension ಮಾಡ್ತೀರಾ ಸರ್ ಎಂಟ್ರಿ ಮಾಡೋಕ್ಕೆ ಹೇಳ್ಬೇಕಾ ಇಲ್ಲಿ ಫರ್ದರ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತಿತ್ತು ಸರ್ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಟುಮಾರೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತರ ಹೋಗಿದ್ದಾರೆ ಏನದು 54 ಇವಾಗ ಅದೇನು ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡಲ್ಲ ಬಿಡಿ, ಅದು ಡಿಸ್ಪೋಸ್ ಆದಾಗ ಹೇಳಿದ್ರು.
ಏನಾಗಿರುತ್ತೆ ಹೇಳ್ತಾರೆ ಬೆಳಿಗ್ಗೆ ಆಗಿರುತ್ತೆ ಇವಾಗ ರೆಕಾರ್ಡ್ ಮಾಡೋದು
ಅದೇ ಸರ್ 86 ಫಸ್ಟ್ ಮ್ಯಾಟರ್. ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. ನಾಳೆ ಜಾಸ್ತಿ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್ ಮಾಡಂಗಿಲ್ಲ. ಪಾಸ್ ಓವರೆಲ್ಲ ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ. ಅದಕ್ಕೆ ಒಂದ್ ನಿಮಿಷ ನೋಡ್ತೀನಿ, ಡೇಟ್ ಹೇಳ್ಬಿಡ್ತೀನಿ ಇರಿ. ಕರೀತೀನಿ, ಕರ್ಬಿಟ್ಟು ಡೇಟ್ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಸೆಲ್ ನಂಬರ್ 75 ಟುಮಾರೋ.
Code officer.
Entry ಮಾಡ್ರಿ, ನೋಡ್ಬಿಟ್ಟು ಮಾಡ್ತಾರೆ ಸರ್. 76 ಆಲ್ರೆಡಿ ಗಾನ್. 77 ವಿ ಪ್ರಕಾಶ್ ಅಂಗಡಿ ಸರ್. ಅಲ್ಲ 75 ನಾಳೆ, 75 ನಾಳೆ, 76 11/8 ಹೋಗಿದೆ ಆಲ್ರೆಡಿ. 77 ಇದ್ದೀರಾ ಸರ್? 77 ಇದ್ದೀರಾ ಸರ್? 13/8 ಅದೇನು ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ ಇದು? ಸೀರಿಯಲ್ ನಂಬರ್ 17 77 78 ನಾಳೆಗೆ. ಸೇಲ್ ನಂಬರ್ 78 ಸೆಪ್ಟೆಂಬರ್ಗೆ ಹೋಗಿದೆ. 79 ಸಿದ್ಧಾರ್ಥ್ ಸುಮನ್ ಅವೈಟಿಂಗ್ ಸರ್ವಿಸು, ಮೆಮೋ ಆಫ್ ಸಮ್ಮನ್ಸು. ಇದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರೇನೆ. ಏನು ಇದು 78 ಪಾಸ್ ಓವರ್ ಎಲ್ಲ 78 ರವಿ. ಏನು
Code officer.
80 ವೈಷ್ಣವಿ ಶಿವಶಂಕರ್ ಇಲ್ಲ. ಹಂಗಾರ ಡೇಟ್ 81 SK ಮಿಥುನ್ 80 ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಇದೆ. ಅದು ನಮ್ಮ ಮೇಡಮ್ ಎಲ್ರಿಗೂ ಹಾಕಿದ್ದೀರಾ? ಅಲ್ಲಿ ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ R1 to R14 ಇದೆ. ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡ್ತೀನಿ 25 8 ಅಲ್ಲಿ ನೋಡ್ಬಿಟ್ಟು ಕೊಡಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 81 SK ಮಿಥುನ್ 81 SK ಮಿಥುನ್ ಇದ್ದೀರಾ?
Code officer mic mute ಆಗಿದೆ.
Cell number 90 SK ಮಿಥುನ್ ಅದು ಅಯ್ಯೋ ಇದೆ ಅನ್ಸುತ್ತೆ ಮೋಸ್ಟ್ಲಿ. ಆಯ್ತಾಯ್ತು 91 ಮಂಡೇ ಅದೇ ಸರ್ ಮಂಡೇ. ಸೆಲ್ ನಂಬರ್ 92 ನಾಳೆ ಇಲ್ಲ ಸರ್, ನಾಳೆಗೆ ಆಪ್ಷನ್. 93 AN ಕೃಷ್ಣಸ್ವಾಮಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಪ್ಲಾನ್
ಆಯ್ತು ನಾಳೆ ಆಯ್ತು 93 ಯಾರು ಇಲ್ವಾ? 94 ಸುಲ್ತಾನ್ ಸಿದಿಲ್ ಇಲ್ವಾ? 94 ಇಲ್ಲ. 95 96 ಆಯ್ತು. 97 ವೀರೇಶ್ ಮಹೇಶ್ ಉಪ್ಪಿನ್ ಇಲ್ಲ. 98 ಇದ್ದೀರಾ? ಏನು ಐವೋ ಇದೆಯಾ ಇವ್ರೆ? 10 8 ನಿಮಿಷ ಸರ್. 99 ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಇದೆ ಇದು. 99 ಅಲ್ಲಿ ಯಾರು ಇಲ್ವಾ? 100 101 102 ಅಯ್ಯೋ ಇಲ್ಲ. ಆಯ್ತಾಯ್ತು. ಮಂಡೇಗೆ ಇವ್ರೆ ಮಂಡೇಗೆ ಆಲ್ರೆಡಿ ಎಷ್ಟು ಮ್ಯಾಟ್ರ್ ಇದೆ ಗೊತ್ತಾ? 58 ಮ್ಯಾಟ್ರ್ ಆಲ್ರೆಡಿ ಇದೆ. ಡೇಟ್ ಗಿವನ್ ಅಲ್ಲಿ ನೋಡ್ತೀನಿ ಇರಪ್ಪ. ಮಂಡೇ ಇಲ್ಲ. 17 18 102 18 ಆಮೇಲೆ 103 ಅದು ಡಿಲೇ ಎಂಟ್ರಿ ಮಾಡಿದೆ. 18 ಅದು ಸೇಲ್ ನಂಬರ್ 104 ಕೆ ವಿಜಯಕುಮಾರ್. ಮಂಡೇಗೆ ಬೇಕಾ ಅರ್ಜೆಂಟಾ? ಅದು ಮಂಡೇಗೆ ಆಲ್ರೆಡಿ ಇದೆ, ಹಂಗೆ ಕಾಯ್ತೀರಾ ಅವತ್ತು. 105 ರಿಪೀಟ್ ಮಾಡಪ್ಪ ನಾಳೆಗೆ. ಅದು ಏನೋ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಇದೆ. ಯಾವುದು? ಇಲ್ಲ ಬೇಡ, ಅವರು ಮೆನ್ಷನ್ ಮಾಡ್ಲಿಲ್ಲ, ತಗೊಳ್ಳಿಲ್ಲ ಮೇಡಮ್. 107 106
ಮ್ಯಾಮ್ 106
ಐವೋ ಇದೆಯಾ? ಐವೋ ಇಲ್ವಾ? ಆಯ್ತಾಯ್ತು. 28 107 ಐವೋ ಇದೆಯಾ? ಐವೋ ಇದ್ರೆ ಹೋಗುತ್ತೆ ಇವ್ರೆ. ಐವೋ ಇದ್ರೆ ಲಾಂಗ್ ಡೇಟ್ ಕೊಡಕ್ ಹೇಳಿದ್ದಾರೆ. ಎಂಟ್ರಿ ಮಾಡ್ರು ಮತ್ತೆ ಅಗೈನ್ ಅಂಡ್ ಅಗೈನ್ ಯಾರು ಕಮ್ಮಿ. ನಂಗೆ ಗೊತ್ತಿಲ್ಲಪ್ಪ. ನಾನು 107 ನನ್ಗೆ ಹೇಳಿದ್ದಾರೆ, ಅದನ್ನ ಪ್ರಕಾರನೇ ಮಾಡೋದು. ಆಯ್ತಾಯ್ತು. 19 ಇಲ್ಲ 108 10 8 109 ಹೇಳಪ್ಪ. ಐವೋ ಇದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ? ಇದು CH ಮೂಡ್ ಅಂತ ಮತ್ತೆ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? ಯಾವ ಡೇಟ್ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರ? 29 110 ಸರ್. ನೀವು ಬೆಸ್ಕಾಮ್ದು ಹೇಳಿ, ಬೆಳಗ್ಗೆ ಬಂದು 10:30 ಹೇಳಿ ಅಂತ ನೀವು ಹೇಳೋದಿಲ್ಲ. ನೀವು ಹೇಳಿ ಲಾಸ್ಟ್ 3 days ಐ ಆಮ್ ವೇಟಿಂಗ್ ಅಂತ. ನಾಳೆ ಕೊಡ್ತೀನಿ. ನಾಳೆಗೆ ಬಂದು ಹೇಳಿ 10:30 ನೆನ್ನೆ. ಯಾವತ್ತು ಹೇಳಿ ಬೇಗ. 10 111 ಬಾಲರಾಜ್ VR 111 12 ಆಯ್ತು. ಇದೆಲ್ಲ 13 14 ಎಲ್ಲ ಆಯ್ತು. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇರೋದು ಮಾತ್ರ ಹೇಳಿ.
ಲಿಸ್ಟ್ 1 26 ಪಾಸ್ ಓವರ್ ಸೋಮವಾರ. ಲಿಸ್ಟ್ 1 26 ಪಾಸ್ ಓವರ್. ಲಿಸ್ಟ್ 1
ಸೀರಿಯಲ್ ನಂಬರ್ 9
ಸೀರಿಯಲ್ ನಂಬರ್ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ಐವೋ ಇದೆ.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ.
ಫಿಫ್ತ್ ಆದ್ಮೇಲೆ ಕೊಡಿ. ಲಿಸ್ಟ್ 1
59 ಆದ್ಮೇಲೆ ಕೊಡ್ಬೇಕು.
106 ಯಾವ ಡೇಟ್ ಇದೆ?
59 ಅಂದ್ರೆ ಇಲ್ಲಿ 1 4 5 7 9 ಸೇಲ್ ನಂಬರ್ 10 ಲಿಸ್ಟ್ ನಂಬರ್ 20 ಒಂದ್ ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ ಪ್ಲೀಸ್. ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ಬಿಡಿ ಡೇಟ್ಸ್ ಎಲ್ಲ. ಸೇಲ್ ನಂಬರ್ 10 ಸರ್. ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 10
ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಮೇಡಮ್.
5 ಲಾಂಗ್ ಡೇಟ್ ಕೊಡಲ್ಲ, ಅದು ಮೆನ್ಷನ್ ಮ್ಯಾಟರ್ ಅದು ಸರ್. ಅದು ನಾಳೆ ಹೌದು ಇವ್ರೆ ಅವರು ಅಲ್ಲಿ ಇದ್ರ ಮುಂದೆ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ಬಿಟ್ಟು ಪ್ರಾವಿಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಲ್ಲಿ ಗಲಾಟೆ ಮಾಡಿ ಅದು ಲಿಸ್ಟ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ಅದು. ನೀವು ನಾಳೆ ಬನ್ನಿ ನಿಮ್ದು ಏನಿದೆ ಸಬ್ಮಿಷನ್ ಹೇಳಿ. ನಾಳೆ ಮೇಡಮ್ ಮುಂದೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ. ನಾವು ಹಂಗೆಲ್ಲ ನೀವ್ ಹೇಳಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೇಳ್ದಂಗೆಲ್ಲ ಕೇಳಕ್ಕಲ್ಲ ಸರ್. ಒಂದ್ ನಿಮಿಷ, ಅದು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದಾನೆ ಮೇಡಮ್ ಹೇಳಿದಾರಲ್ಲ. ಬೇರೆ CH ಮೂಡೋದು ಮೆಮೊ ನೀವು ಮೂವ್ ಮಾಡಿದ್ದೀರಾ? ನಾಳೆಗೆ ನಾಳೆ ಬಂದು ನೀವ್ ಹೇಳಿ ನಮ್ ಕೋರ್ಟ್ ಆಫೀಸರು ಕೇಳಿದ್ರು ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಾನೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಹೇಳಿ ಸರ್, ಹೇಳಿ ನೀವ್ ಹೇಳಿ. ಅದು ಅಲ್ಲೆಲ್ಲ ಪ್ರಾವಿಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
Court officer, madam. Court officer, ma'am. List 2, serial number 8, madam. Madam, mute ಅಲ್ಲಿ ಇದ್ದೀರಾ? Court officer, madam. Hello. Madam, court officer, madam. But judgments ಯಾವುದು? Madam, ಇದು ಲಿಸ್ಟ್ 2, ಸೀರಿಯಲ್ ನಂಬರ್ 8, ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ. Court of ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಒಂದು ಮ್ಯಾಟರ್ ಮೆನ್ಷನ್ ಮಾಡಬೇಕಿತ್ತು. ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಮೇಡಮ್.